ಫುಲ್ ಶಾರ್ಟ್ ಚಿಕ್ಕದು. ಹಾ ಫುಲ್ ಚಿಕ್ಕದು. ಇಷ್ಟೇ ಸೈಜ್ ಬರೋದು, ದೊಡ್ಡದು ಬರಲ್ವಾ? ಇದ್ರಲ್ಲಿ ಏನಕ್ಕೆ ದೊಡ್ಡದು ಬರುತ್ತಲ್ಲ? ದೊಡ್ಡದು ಕೊಡ್ರಪ್ಪ ಮತ್ತೆ.
Court officer? Court officer? Court officer? ಇನ್ನೊಂದ್ಸರಿ ಹಾಕ್ಬಿಡಪ್ಪ 22 ನೋಡ್ಕೊಂಡು ಅಲ್ಲಿ ಬರ್ಕೊಂಬ ಓಡು.
ಹಲೋ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಹಲೋ ಹಲೋ,
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಹಾ ಓಕೆ ಮೇಡಮ್, ಓಕೆ ಓಕೆ
ಸರ್ ನಮ್ಮ ವಾಯ್ಸ್ ಕೇಳ್ತಿದ್ಯಾ ಸರ್?
ಕೇಳ್ತಾ ಇದೆ ಮೇಡಮ್.
ಓಕೆ.
ಅವರು ಬರ್ತಾರ ಮೇಡಮ್? ಮೇಡಮ್ ಯಾವ್ದಾದ್ರು ನೋಡ್ತಾ ಇದಾರ ಆದವರು? ಹಲೋ ಮೇಡಮ್ ಬರ್ದಿಯಾರ? 21 ಅಲ್ಲಿ ಯಾವುದು?
21 ಅಲ್ಲಿ ಅಲ್ಲಿ ಆ ಸೆಷನ್ ಅಲ್ಲಿ ನಮಗೆ ಮತ್ತೆ ಮೀಟಿಂಗ್ ಇಂಗ್ಲಿಷ್ ಅಂತ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇದೆ. ನಾವು ರೆಸ್ಪಾಂಡ್ ಅವ್ರ ಟೈಮ್ ತಗೋತಾರೆ. ಟೈಮ್ ತಗೋತಾರೆ.
ಅವ್ರನ್ನ ಅವ್ರು ಕಳಿಸಿ. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ದೀರಿ ಮೇಡಮ್? 21 ನೀನು? ತಾವೇನ್ ಮಾಡ್ಬೇಕಂತ
ರಘುಪತಿ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಎಲ್ಲರಿಗೂ ಕೇಳ್ತಾ ಇದೆ.
These memos only for admission and orders. Hearing ಎಲ್ಲ ದಯವಿಟ್ಟು ಕೊಡ್ಬೇಡಿ. But matter is admitted. Thing vacating still when the matter is admitted, how can you vacate the information? All in all, hand out the memo later.
Finally,
Oh, 2018. Doesn't matter, Mr. Yen month. 2006 7 pending ಉಳ್ಕೊಂಡಿದೆ ಏನ್ ಮಾಡಿ ಅದು ಮುಂದಿನ ವರ್ಷ ಬರುತ್ತೆ ಅಷ್ಟೇ ಬಟ್ ಆಗ್ತಾ ಇಲ್ಲ ನಾಟ್ ಹ್ಯಾಪನಿಂಗ್ ಫೈಲಿಂಗ್ ಬೇಕು ಡೇಟ್ ಕೊಡ್ತೀನಿ ರೀಚ್ ಆಗೋದಿಲ್ಲ ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಮುಂದಿನ ತಿಂಗಳಲ್ಲಿ ಯಾವ ಒಂದು ಡೇಟ್ ಸಿ ನಂಬರ್ ಮೇಡಮ್ ಯಾವುದು ಚಂದ್ರಪ್ಪ ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ ಮಾಡು
Serial number 51, my lord.
ನೋ ಮೇಡಮ್ ಸಾರಿ ಎಸ್ ನೆಕ್ಸ್ಟ್
My lord, serial number 51, my lord.
61
51, my lord.
ಸಿ ನಂಬರ್
51, my lord.
ಮಿಸ್ಟರ್ ದಿಸ್ ಆರ್
My
ಆಲ್
senior is not feeling well, my lord.
ಆಯ್ತು ನೋಡೋಣ ಸಿ ಸೀರಿಯಲ್ ನಂಬರ್ 27
My senior is not feeling well.
yes one week time is not keeping that sorry 1 week as time petition that's in the orders list mister Mister, everybody wants adjournment. What is this? The admission matters. Sorry. Admission matters. All argument ತಗೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಮತ್ತೆ ಇನ್ನೇನು ಅದು ಲಿಸ್ಟ್ ಮಾಡೋ ಉಪಯೋಗ ಏನಾಗಿದೆ?
just do it right now. To find the memo to be seeking withdrawal of that.
The appeal was dismissed as withdrawn in terms of the judgment dated 10/3/2022. This court, in terms of the order dated 6/12/2017, allowed IA number 1 of 2017 and permitted Mr. D. Pratap to come on record as respondent number 16. On 5/11/2019, the London Council for the appellant had filed a memo stating that the appellant and respondent number 13, who are his brothers, are his class 2 legal heirs. The said submission was placed on record as per the order dated 5/11/2019. On the basis of the memo dated 11/12/2017 filed by the London Council for the appellant, it was stated that the appellant is a legal representative of the deceased respondent number 14. It was recorded that the appellant is a legal representative of the deceased respondent number 14 in terms of the order dated 6/2/2020. Stop. Next para, the London Council for the appellant filed an amended appeal memo on 7/2/2020, which was returned by the office with an objection that the appeal memo / cost title was not amended in respect of the respondent number 14 and completed respondent number 16. Proposal of the appeal on 10/3/2022, the London Council for the appellant has filed an amended cost title on 17/3/2022. Full stop. Hence, the amended cost title is accepted. Office is directed to amend the cost title and proceed and issue a fresh certified copy. Complaints office objection raised on Wakala. Some office objections are there. Wakalatiಗೆ ನೋಡಿ ಕುಡಿಯೋದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ರಿ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಇಲ್ಲ ನೋಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ ವಕಾಲತ್ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ whatever you want to do you please correct it. The password. Yes. What is this complaints of office objections? What is this IA, Mr.?
IA is filed for conducting dealing with customers. ಆಮೇಲೆ ನಿಮಗೆ ಸಾಮಾನ್ಯ ಎಲ್ಲ ಸಾಂಪ್ರದಾಯಿಕ ಬರುತ್ತೆ. ಇದಕ್ಕೆ ಬಂದ್ಬಿಟ್ಟು ಸ್ಟೇ ಇದಕ್ಕೆ ಇರ್ತದೆ.
22. 21. ಇನ್ನ ಅಡ್ಮಿಷನ್ ಬಂದಿಲ್ವಾ? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವೇನ್ರಿ? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ? This is appeal for admission along with IA 1 of 22 and 2 of 21. E. Nagaraj. What is the suit for? This appeal is filed by which defendant? We will discuss. This way, appellant has failed to take steps to bring the legal representatives of deceased respondent number 2. The appeal against the respondent number 2 as awaited. R2 is dated. Sorry. The respondent number 2 was the defendant number 2 before the trial court. Full stop. The plaintiffs slash defendant number 2 before the trial. The plaintiffs slash respondents 3 the plaintiffs 1, 2, 3 slash appellant 1, 2 and respondent number 3 are the legal representatives of the deceased defendant number 2. Stop. Since they are already on record, question of filing a formal application to bring the legal representatives is dispensed. counsel for the appellant is directed to make appropriate entries in the title indicating the death of the respondent number 2 and that the appellants / respondent number 3 are the legal representatives. This is the appeal for admission. What about the IA-1 of 12? IA-1 of 12 is filed for continuation delay of 3 days in filing the appeal. The learned counsel for the respondents has no objection to allow this application. Hence, IA-1 of 12 is allowed. This is the appeal for admission.
I appear for the appellant below. The first appellant died on 8/2/2022.
An application is filed in IA-1 of 22 to bring the legal representatives of deceased appellant number 1 as A1 bracket
A1E. A1A to A1E.
I can read it, please wait.
I am sorry.
A1A to E. Good stop. Since the cause of action survived the death of the appellant number 1, the legal representatives are entitled to come on record and pursue this appeal. Hence, IA-1 of 2022 is allowed. The appellant 1 A1 bracket A to E are treated as the legal heirs of deceased appellant number 1. Full stop. Counsel for the appellant is directed to amend the cost title and furnish an amended cost.
And one more memo is filed by me.
Wait, please wait. The memo is filed to treat the legal representatives of R1. Legal memo is filed to treat the respondent 1 bracket B to F as the legal representatives of deceased R1A. Stop. In view of the memo, the respondent 1 bracket B to F are treated as LRs of the deceased R1A. Counsel for the appellant is directed to amend the cost title and furnish an amended cost.
Oblast.
2 weeks.
Oblast.
Yes. This is the appeal for admission. Sorry, final hearing as per seniority. Yes, whether notice is issued on this issue notice on IA-1 of 20. If you have no objection to come on record.
I have no objection, only to verify if all the legal heirs are being.
He says he has no objection.
My only issue is that whether all the legal heirs are mentioned or not. I just want to clarify that. I'll not come in the way of.
Just look at it now. If you have any objection, then we'll. IA-1 of 22 is filed to bring the legal representatives of deceased R1. Stop. The learned counsel for the deceased learned counsel who earlier represented the deceased respondent number 1 submits that he has instructions to appear on behalf of the legal representatives of the deceased respondent number 1. Stop. He has no objection to allow the application. Hence, IA-1 of 22 is allowed. The legal representatives of deceased R1 are permitted to be brought on record. Sri so-and-so, you may say, and what's your name? Srikara. Huh?
Srikara is my colleague.
So Srikara PK. Your office is directed to show the name of Srikara PK as a counsel for R1 bracket A to D. List the appeal for final hearing as per seniority. In the amendment of the cost title, the counsel for the appellant is directed to amend the cost title and furnish an amended cost. Yes. Yes. The process when will you do? Please do it today. The counsel for the appellant is granted 1 day's time to pay the process to issue notice to the unserved respondents.
Here by appellant, my lord.
Time is granted.
Appellant. Judgment appellant died ಆಗಿದ್ದಾನೆ my lord. Legal yes ಗೆ LR application ಹಾಕಲು ಒಂದು judgment ಇದೆ my lord. Page number 86 my lord. filing the
Therefore,
judgment.
the learned counsel for the appellant submits that the ಯಾರು ತೀರೋಗಿದ್ದು appellant
appellant legal yes party ಮಾಡಿದೀನಿ ಮಲ್ಲ.
who died?
Mallayya. Yes,
who is Mallayya?
Mallayya is legal yes father madam. RA judgment ಆದ್ಮೇಲೆ madam.
Hey, Mallayya was the plaintiff defendant appellant.
Appellant madam.
For the first appellate court.
First court ಅಲ್ಲಿ respondent madam. YS madam page number 39 madam.
The learned counsel appellant submit that the respondent in RA 87 of 2007 / defendant in OS number 166 of 2004 expired after ಯಾವತ್ತು
28/7/2015 my lord.
28/7/2015
my lord. Death certificate produced my lord. Page number 84 my lord.
Yes. And therefore, the legal representatives of the said person have filed this appeal. Stop. Full stop. In view of the aforesaid submission, filing applications by the appellants to come on record as the legal representatives does not arise. Hence, office objections in this regard overruled. Is the appeal for admission now?
So delay the my lord. Notice agಬೇಕು my lord.
Is the appeal for
condonation of delay? Page number 69 my lord.
delay? Orders regarding condonation delay. ಯಾವುದು ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ ಈಗಾಗಲೇ. What is 19/2007?
Page number 69 my lord. Delay application is there my lord. Delay ಮೇಲೆ notice ಆರ ಸಾಕ್ಷಿ.
Sir, the appeal is dismissed for non-prosecution.
ಡಿಸ್ಮಿಸ್ ಆಸಮಿಗೆ ಅದೇ ನೀವೇ ಟೈಮ್ ಕೊಟ್ರೆ my lord ಕಂಪ್ಲೈ ಮಾಡಿದೀನಿ my lord. ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಬಂದಿದ್ದು ಲೀಗಲ್ ಎಸ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಬೇಡ ಅಂತ. Page number 69 my lord.
Issue notice on IA 4 of 22, 5 of 22. Of 22 and 1 of 22. Yes. Process ಇವತ್ತೇ ಕೊಡಿ. Counsel for the appellant is directed to process during the course of the day, dealing with the appeal shall stand dismissed. Yes.
Yes my lord.
Appearing for the respondent number 226 my lord.
Issue notice on
for the appellant.
Purple, a memo is filed reporting the death of the respondent number 1 on 13/4/2018. Sub counsel for the appellant is directed to take steps. Next, memo 13/4/2018. In this regard, a memo is filed on 11/6/2019 to treat the respondent 2 to 5 as the legal representatives of deceased R1. In view of the above, the respondent 2 to 5 are treated as legal representatives of deceased R1. Counsel for the appellant is directed to make appropriate entries in the cost title indicating the death of R1 and that R2 to R5 are the legal representatives. 1 week time is granted to pay process in respect of the deceased respondent number 8, failing which the appeal against respondent number 8 shall stand dismissed. What is this IA 1 of 22? Issue notice on IA 1, 2, 3 of 2022. Process kodi ivattu.
Initially it was sued for intention. Later,
It is amended and sued for declaration and provisional by paying the court fee. And this was dismissed on the ground that only descriptions of the bound measurement was not tally with the original sale.
What is the topic of the
degree of the suit ನಲ್ಲಿ ಸ್ವಲ್ಪ amount display ಆಗಿಲ್ಲ. So therefore it was during the appellate authority, first appellate court was accepted the rectification and accepted the court fee. Here also we have paid sufficient court fee.
trial court
Only thing is that records ಬಂದ್ರೆ
trial court is ಕೊಟ್ಟಿದ್ದೀರಾ?
25,625 ನೇ ಕೊಟ್ಟಿದ್ದೀವಿ. First appellate court also we have paid same court fee. And for this court also we have paid.
The appellate submits that court fee of
25,686
was paid before the trial court as well as the first appellate court and before
here also.
See, a discrepancy in the court fee paid is the office objection raised regarding discrepancy in the court fee paid overruled. The appellate is that published valuation slip before the filed before the civil court, before the trial court, in a period of 2 weeks from today.
ಅದು ಹಾಕಿದ್ದೀನಿ ಅದಕ್ಕೇನೆ ಫಸ್ಟ್ ಅಪ್ಡೇಟ್ ಅಥಾರಿಟೀಸ್ ಡಿಗ್ರಿ ಹಾಕಿದ್ದೀನಿ ಅದರಲ್ಲಿ ಇದೆ ಫ್ಯಾಕ್ಟರಿ ಓವರ್ರೋಡ್
Valuation slip before the trial court. ಕೊಟ್ಟಿದ್ದೀರಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕಿದ್ದೀನಿ. But the first appellate authority, first appellate court also displayed the 25,626.
Trial court valuation slip. After the decree, after the suit was amended,
yes.
How did you value it?
First appellate subject to call for the records.
ಚೆಕ್ ಮಾಡ್ಬೇಕಲ್ವ?
ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ
ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅದಕ್ಕೆ ಇದು ಆಫೀಸ್ ಸೆಕ್ಷನ್ ಗೋಸ್ಕರ ರೆಕಾರ್ಡ್ ತರಿಸಕ್ಕಾಗಲ್ಲ.
We have paid that is same amount we have paid already before this court and
whether you have valued it properly before the trial court or not is a question that has to be considered.
It is accepted in the first appellate court also has.
But what is the purpose of section 11 then? ಕೊಟ್ರೆ ಸರಿನೋ ಇಲ್ವೋ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ.
Records display it is.
ನಾವೆಲ್ಲ ರೆಕಾರ್ಡ್ ತರಿಸಿ ನೋಡಂಗಿದ್ರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಬೇಕಾಗಿಲ್ಲ ಹಂಗಿದ್ರೆ. Please furnish it, mister. ಅದೇ ನೀವು if you not valued it properly, you are bound to pay the court fees as deficit.
There is no issue.
Who knows? You know it. I do not know. The office does not know.
The office first appellate court has accepted it.
Office of the High Court of Karnataka at Bangalore does not know. So therefore, please furnish it. This is an application filed by you. What objection will you have? 1 of 22 filed by the legal representative. So this is respondent number come on record. Sorry, IA 1 of 22 is filed for condonation of delay. Filing the application to come on record as the legal representative. So this is respondent. Are shown for the delay is accepted as sufficient reason for not filing the application in time. Since IA 1 of 22 is allowed. Since the cause of action has survived the death of the respondent, IA 2 of 22 for setting aside abatement is also allowed. Consequently, IA 3 of 2022 is also allowed, and the applicants are permitted to come on record as a legal representative to receive respondent. On the application, why are you comparing the list the appeal for admission? Notice what is there?
Serial number 12, I represent the appellant, my lord. And for fourth respondent, process fee was paid. This honorable court had issued notice to the fourth respondent, my lord. The postal shara shows that, my lord, the item has been delivered on 12/1/2022 and respondent number 4, my lord.
Postal shara here.
Notice 4/1/2022 ಗೆ issue ಮಾಡಿದ್ರು. 12/1/2022 ಗೆ item delivered confirm ಅಂತ ಬರ್ತದೆ.
Thumb impression ಇದೆಯಂತೆ ಮಂಜುನಾಥ. Thumb impression ಇದೆ, ಯಾರ್ದು ಅಂತ ಗೊತ್ತಿಲ್ಲ. Please take out fresh process. 1 week time is granted to take out fresh to issue to pay the requisites for issuing notice to respondent number 4. Yes. Weeks. The DS was smart. The DS was smart.
Please, I appear for appellate. Lord, process fee was sought for. I had paid for process fee for a second time. ಆ ಟೈಮ್ ನಲ್ಲಿ ಆಫೀಸ್ನವರು ನನಗೆ ಕಾಪಿ ಕೇಳಿರ್ಲಿಲ್ಲ. ಈಗೇನೋ ಕಾಪಿ ಬೇಕಂತಾರೆ 2 ಸೆಟ್. 1 week your lordship.
1 week time is granted to comply the office.
Please.
Yes, Mr. Kamros Khan. Why don't you come? That is why I keep telling you, sir, you might be, we respect you as a retired army personnel, we respect you, but you should also respect you as the lawyers, their profession. ಅದಕ್ಕೆ ಹೇಳಿದೆ, ಯಾರು ಕನ್ಸಲ್ಟ್ ಮಾಡಿ. See, if there's an office objection that you are not served, welfare stamp ಹಾಕಿಲ್ಲ. But I asked you to file some application, isn't it? Where is that IE? Have you served the copy to the other side? What is this IA 1 of 22? IA 1 of 22. Your Colonel MM Ayana. Stamp hakilla. Yes. What about serving copy of the application? ಎಲ್ಲಿದೆ ಸರ್ವಿಸ್ ಮಾಡೋದಕ್ಕೆ? There's a proof of service. Yes, madam. You appear for the appellant.
Sent copy for a vacating stay, my lord.
You received the copy.
Yes.
These objections raised on IA 1 of 22 is overruled since the learned counsel for the appellant has acknowledged the receipt of a copy of the application. What is it, IA 1 of 22, madam? Any objection? Any objection?
While admitting the case, this honorable court has admitted and stay is granted and question of law is also framed, my lord. After vacation.
The retired army personnel, we have to grant some, show some concern. Sir, want me to tell it 2 more times? I will tell it. Onsati ಹೇಳು ಸಾಕಲ್ಲ. When, please pick a date of your choice. Please wait. Please. Please argue on April 19th, madam. ಬಂದು ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಾವೇ ಗೌರವ ತೋರಿಸ್ಬೇಕಲ್ಲ. 20th April. This is the appeal for final hearing on 20th April 2022. Yes. What do you want to say? Come for final hearing on 20th. Sir, this appeal is admitted. The appeal is admitted. We have framed a question of law. That question of law has to be answered. So they are willing to argue the appeal on 20th of April. Therefore, we are listing it on 20th of April. Please come prepared. 20th of April 2022. Number 16. 2 weeks time to comply the office objectives.
My lord, I am for the appellant in this case, my lord. Kindly press some time for 1 week, my lord.
1 week time is granted to comply the office.
Much obliged, my lord.
Actually, it has to go to blood section 96.
Withdraw Madi. Learn counsel for the appellant. Submit that. This appeal has to be filed before the appeal. Compromise alwa idu. Matte ade court munde hogabekalwa. Correct, but
any degree
how can you file an appeal against the compromise? It is, but you have to go before the same court which accepted the decree. How can you file an appeal? It shall not.
Otherwise, the body has law for the time being, appeal shall be like from every passed by the original court otherwise no. This is the original decree.
Right, please come to section order 23 rule 3. Where it is alleged by one party and denied by the other, the assessment of satisfaction should decide the question, but no argument should be granted to so on. So it will not be deemed to be lawful within the ministry. But to go before the same court.
Here, what happened? I want to sign the compromise decree. Compromise petition.
They are not signed.
The brothers want engage the council, everything they have done it. I signed the compromise petition. After the final decree, I came to know. Clause 1 portion has given to me.
Alle challenge ಮಾಡಬೇಕು. To learn counsel for the appellant. Sorry, the officers raised an objection regarding maintainability of the appeal. Since the decree challenged in this appeal is based on a compromise petition that was reported in OS number 154 of 2020. Full stop. The present appeal is therefore not maintainable, and it is open for the appellant to avail such remedy as is permissible under law to challenge the compromise decree. Invoice number 154 of 2020. Hence, the office regarding maintainability is upheld. The directed to return the judgment and decree invoice number 154 of 2020 of obtaining a certified copy of the same.
Before the same code.
Before the same code, need not tell that. You can't file an appeal against something which you have considered. You have a compromise oppondo. Appeal hengagtide.
Really? I made allegations about the brothers.
If you have to go before the same court.
Appeal for the apparent in this matter. I appeal for the.
The appeal is admitted. Let the appeal come up for admission for final hearing.
Yes, madam. Just be heard on merit. Yes, madam.
The question had indicated that perhaps appointment of a commissioner would resolve the dispute.
Yes, what is this dispute about?
The dispute was for recovery of possession members. I had filed the suit. I claimed the field schedule property on the basis of a registered partition deed. The defendants are other family members. They have not disputed the partition deed at all. According to that, I am entitled to 1 acre 13 acres.
Yeah, one of 22. Come 2006. Come,
madam. I pray for 2 weeks time in this. The reason is I'll have to undergo eye operations of both my eyes. ನಾನು 24ಕ್ಕೆ ಆಪರೇಷನ್ ಅಡ್ಮಿಟ್ ಆಗ್ತಾ ಇದ್ದೀನಿ ಒಂದು 2 ವೀಕ್ಸ್ ಬೇಕಾಗುತ್ತೆ.
ಯಾವತ್ತಿನ ಯಾವತ್ತು when do you want it? Before you undergo an operation.
ಅಲ್ಲ 24ಕ್ಕೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆ ಸರ್ ಅದಕ್ಕೋಸ್ಕರ. ಬೋತ್ ಮೈ ಐಸ್ 24 ನಾಳೆ ಆಪರೇಷನ್ ಶುರು ಮಾಡ್ತಾರೆ.
ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಸರ್ ನಾಳೆ ಪ್ರೀ ಟ್ರೀಟ್ಮೆಂಟ್ ಹೋಗಬೇಕಾಗುತ್ತೆ. ಎನಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಇಂದ ಏಪ್ರಿಲ್ ಮೇಲೆ.
This after 2 weeks.
Treatment.
They are now in the topmost seniority, 2006. Fortunately, we have cleared all 2005 appeals. ಸ್ವಲ್ಪ ಉಳ್ಕೊಂಡಿದೆ. IA 1 of 22 is allowed. This the appeal final hearing as per seniority. Same order. Same order. Same order. IA 1 of 22 is filed. The legal IA 1 of 22 is filed by the applicants or the legal representatives of the deceased appellant. The application is in time, and as the cause of action survived the death of the appellant, is allowed legal applicant to come on legal representative. Counsel for the appellant is directed to amend the contract. 21 IA is allowed list for final hearing. Come up, Mr. for final hearing. As per seniority, it will come up after 2 years, not 2 weeks. 2 years has no birth. This is 2011. No, I can't assure you after vacation, but it will come up in the senior. That also application allowed. Yes. The appeal as per senior. Yes. Same order. Same order. Sir, ಹಳೆ ಕೇಸ್ ಇದೆ ರೀ. ಹಳೆ ಕೇಸ್ ಬಿಟ್ಬಿಟ್ಟು ಹೊಸ ಕೇಸ್ ತಗೊಳಕ್ಕಾಗತ್ತಾ? ತಗೊಳ್ಳಿ, ಯಾರು ಬೇಡ. Yes. Number 25, IA allowed this. Please amend the cost. You are the smart. ಇನ್ನೊಂದಿನ ನೀವು ಅದು you will get it again for non-amendment cost. Put your yes. Yes. This time is granted to the needful. Notice ಹೋಗಿದ್ಯಾ? ಬರ್ಕೊಳ್ಳಿ. IF 2019 is filed for continuation of bring the legal representatives of deceased respondent number 2. So, the notice of this application was served on the legal representative who were not opposed to the application. The best comma, the cause shown for the delay in filing the application is accepted. IA 3 of 19 is allowed and the delay of 1093 days in filing the application. Since the suit is for declaration injunction, so the respondent number 2, IA 4 of 2019 is allowed and the abatement of the appeal is set aside. View of the IA 2 of 19 is allowed and record. Counsel for the applicant is directed to amend the cost date during the course of the day. The IA 1 of 2019 for extension. Admit ಆಗಿದೆ Mr. Admitted. Supreme order was granted and other orders as paid for on 19/7/2016. Question of extending the interim order does not arise. Hence, IA 1 of 19 is this the appeal for final hearing as per CR. File an application. I can file application. File money. Application. Sir, they will not take up out of turn. Out of turn ತಗೋಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಗೆ ಏನೋ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಇರಬೇಕು. Sorry. Here 1 of 16 is filed for continuation of 72 days.
And in this case, I'm appearing for appellant, my lordship. There is a delay of 72 days in filing the appeal, my lordship.
Yes.
Serial number 27, my lordship. I'm appearing
yes, I
for
heard
appellant.
it. Then what else? What else?
Nothing, my lord. I'm sorry, my lord.
Here 1 of 16 is continuation of delay of 72 days in filing the appeal. The cause shown for the delay is accepted as sufficient reason for not filing. Here 1 of 16 is allowed. This is the appeal for admission. Same order. This is the appeal for this is the appeal for admission. Yes. It will come up, Mr. You still have pending it. Now you say date and the opposite is saying this. The same order. Here 1 of 22 is filed for continuation of delay of 745 days in filing the application to recall the order dated 11/10/2000. Stop. Order dated. Hence the delay 745 days in filing the application control. Consequently, IA2 of 2022 is allowed and the order dated 11/10/2017 is recalled. 2 weeks time is granted for complaints of office objections, failing which the appeal shall again stand dismissed for default without reference to bench. So the one of 21 is filed for continuation of delay of 42 days, filing the application to come on record as the legal representative of this legal. Since the caution for the delay of 42 days is accepted as sufficient reason for not filing the application in time. Hence, IA 1 of 21 is allowed. The delay of 42 days in filing the application is controlled. Consequently, IA 1 of 19 is allowed. The legal representatives of the appellant are permitted to come on record. Counsel for the appellant is directed to amend the cost during the course of the day. Is the appeal for admission? 32.
Appellant in this case, my lord. Lord, state of hearing, lordship directed me to just put a word to settle the issue. I called my client, my lord, to settle the issue, and I has taken some time to resolve the issue in between. Since the relationship of brother and sister, my lord, after vacation, may I kindly.
What is 16/3/2022? The possibility of the settlement. Yes.
My lord, I have called my client and instructed, my lord, in time. He's also trying, my lord. So
listed for admission then.
Much.
So the appellant is not in a position to indicate whether the parties are willing to settle. Let's list the appeal for admission.
After vacation.
2018.
Much of
Notice on IA 1 of 2018. Same order. IA 1 of 22 is filed for international delay of 112 days in filing the application to recall the order dated 29/9/2021. Shown for the delay is accepted. Hence, IA 1 of 22 is allowed. View of the above, IA 2 of 22 is also allowed, and the order dated 29/9/2021 is recalled. Last stage. 2 weeks time is granted to comply the office objections, failing which the appeal shall again stand dismissed for non-prosecution. 2 weeks saka? 2 weeks saka inna beka? 3 weeks. Issue notice on IA 1 of 19. Yes. Yes. ಆಯ್ತಾ ಸ್ವಲ್ಪ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ನಲ್ಲ 3 months ಅಲ್ಲ ಸರ್, ಸ್ವಲ್ಪ ಕೊಡಿ, ಇವತ್ತು ಕೊಡಿ. ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದಕ್ಕೆ ಮನೆಗೆ ಹೋಗಿ ಏನೋ ತಗೊಂಡೋಗ್ಬೇಕಲ್ಲ. ಇಷ್ಟಾದ್ರೂ ಕೊಡಿ ಸ್ವಲ್ಪ, ಇವತ್ತು ಮನೆಗೆ ಹೋಗೋಕೆ ಲೆಟ್ ಹಿಮ್ ಟೇಕ್ ಸಮ್ ಮನಿ. ಎಷ್ಟಿದೆ ನಿಮ್ಮ ಹತ್ರ? ಎಷ್ಟಿದೆ ಕ್ಯಾಶ್? ಎಷ್ಟಿದೆ? ಎಷ್ಟಿದೆ? ಅಲ್ಲ, ಇವಾಗ ಏನೋ 5 ಲಕ್ಷ ಕೊಡ್ತೀರಾ? 4 ಲಕ್ಷ? ಹೌ ಮಚ್? 4.5 lakhs ಕೊಡ್ತೀರಾ? ನಾಳೆ ಕೊಡ್ತೀರಾ? ನಾಳೆ.
My client is ready to pay 4.5 lakhs.
He wants to keep it. He wants to keep the land. You again, Tirga, again you going back. Personally, I am having the right. I am. ಆಯ್ತು ಯಾವ ಕೊಡ್ತೀರಾ? ಗ್ರೀವೆನ್ಸ್ ಅಲ್ರಿ 1 ಲಕ್ಷ ಯಾವ ಕೊಡ್ತೀರಾ? 1 ಲಕ್ಷ ಯಾವ ಕೊಡ್ತೀರಾ? ತರಿಸ್ಬಿಡಿ ಇವಾಗ. ಸರ್ ಮುಳುಬಾಗ್ಲು ಇಷ್ಟು ದೂರ ಐತೆ, ಅಲ್ಲಿ ಯಾರೋ ಫೋನ್ ಮಾಡಿ ತರಕ್ ಕೇಳಿ, ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಳ್ತೀನಿ. ಲೆಟ್ ಹಿಮ್ ಟೇಕ್ ಸಮ್ ಮನಿ ಮಿಸ್ಟರ್. ಇನ್ 3 ತಿಂಗಳಾದ್ಮೇಲೆ ಏನೇನಾಗುತ್ತೋ ಹೂ ನೋಸ್, ದೇರ್ ಕುಡ್ ಬಿ ಎ ವಾರ್ ಇನ್ ದಿಸ್ ಕಂಟ್ರಿ. ಯು ಡು ನಾಟ್ ನೋ. ಸರ್ 1 ಲಕ್ಷ ನಾಳೆ ಇವಾಗ ತರಿಸ್ಬಿಡಿ, ಇವಾಗ ಪಾಸ್ವರ್ಡ್ 230 ತರಿಸಿ, ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ತರ್ತಾರೆ. richest person all false. 1 ಲಕ್ಷ ಇಸ್ಕೊಳ್ರಿ, 3 ತಿಂಗಳು ದುಡ್ಡು ಕೊಡದೇ ಇದ್ರೆ ಪೇ ಮಾಡಕ್ಕೆ ಮತ್ತೆ ದುಡ್ಡಿದೆ ತಾನೆ, ಅದ್ರೊಳಗೆ ಮಗಳು ಮದುವೆ ಮಾಡಿ. ನೀವು ಒಬ್ಬರೇ ಬುದ್ಧಿವಂತರು ನೀವು. ಮತ್ತೆ ಪೇ ಮಾಡಕ್ ದುಡ್ಡಿದೆ, ಮಗಳು ಮದುವೆ ಮಾಡಕ್ಕ. ಆಯ್ತು, ನಾಳೆಗೆ 1 ಲಕ್ಷ, 2.5 1 ಲಕ್ಷ ಕೊಡ್ತಾರೆ, ಇಸ್ಕೊಳ್ಳಿ. ಮಿಕ್ಕಿದ್ದು 2 months. ಅವ್ರಿಗೂ ನೋವು ಇರುತ್ತಲ್ವೇನ್ರಿ ಬಿಡುವಾಗ? ಅವ್ರಿಗೂ ನೋವು ಇರುತ್ತಲ್ವಾ ಜಮೀನು ಬಿಡೋದು? ಅವ್ರಿಗೂ ನೋವು ಇರುತ್ತಲ್ವಾ? ಪಾಸ್ವರ್ಡ್ 230 4:15 ಒಳಗೆ ಯಾವಾಗಾರು ತರಿಸ್ಕೊಳ್ಳಿ. And you write in that 1 lakh is paid by cash. Password. Please argue. ನೀವೇ ಮಾಡಿ ಸರ್. Password. It's 30 matters admission ಹಾಕಿದೀನಿ. Please see how much time it is. ಅಲ್ಲಲ್ಲ, ಈ ಮ್ಯಾಟ್ರು ಅಡ್ಮಿಷನ್ ಹಾಕಿದೀನಿ, ನಾನು ತಯಾರಾಗಿ ಬಂದಿದ್ದೀನಿ. ಎಷ್ಟೊತ್ತು ಹಿಡಿಯುತ್ತೆ ನೋಡೋಣ. ಇಟ್ಲ 4:30 ವರೆಗೂ ಪಾಸ್ ಓವರ್ ಆಗ್ತದೆ, ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಪಾಸ್ ಓವರ್ ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ ಪಾಸ್ ಓವರ್.
APO for the appellant, my lord.
Yes, please.
My lord, I felt, my lord, documents may be required, my lord. LCR is not yet called for. Your lordship may fix a date, my lord.
For admission, Mr. Hegde, please argue for admission.
Lord, the property, my lord, is a site, my lord, in
yes.
Pamenahalli village. Lord, claim is in respect of Ganesh Mari number 47 and 89. Lord, in the evidence, my lord, the trial court, my lord, after appreciating the material on record, my lord, kindly turn to page 40, my lord, page para 20. Only on the basis of appreciating the documents, my lord, the trial court has decreed the suit. Lord, para 20, your lordship got it, my lord?
Yes.
On the analysis of the evidence of the parties, it reveals that neither the plaintiff nor the defendant have elicited anything in their favor in either cross-examination, whereas the DW2 and 3 have deposed about the possession of the defendants over the suit schedule property. Plaintiffs have also not denied the possession of the defendants over the suit schedule property, but they alleged that the possession of the defendants over the suit schedule property as illegal and defendants are trespassers, and accordingly the plaintiff have sought the relief of possession apart from the relief of declaration of title. DW2 and 3 have reiterated the version of plaintiffs in respect of the possession, but alleged that it is illegal. Though both were members of the Gram Panchayat of Pamenahalli, their evidence regarding execution of registered deeds are different. Further, one witness of DW2 deposed about residence of plaintiffs and their predecessor in the village, whereas DW3 deposed that he had not heard about Rambalingappa and his sons. So also the plaintiffs. Further, as such, the evidence of DW2 and 3 are not believable. Hence, there remains the evidence of PW1 and DW1. As already discussed, nothing is elicited in cross-examination of PW1 and DW1 by the defendants and plaintiffs respectively. Hence, the documentary evidence plays a vital role. Lord, firstly, Lord, I would like to embark upon Exhibit P1, the sale deed, Lord. There is a reference to the documents only, Lord. Lord,
Yes.
according to the my case, Lord, I am the defendant before the trial court. Lord, suit is one for declaration of title and possession, as well as mandatory injunction to demolish the sheds existing on the property which has been constructed by the defendants.
Yes.
Lord,
Yes, please.
Lord, this Kanesh Mar number 89 originally belonged to one Mr. Donkanna, son of Pakiranna. Lord, out of this, Lord, the southern portion was sold to Hanumanna, son of Doddanna, on 18/4/1949. Lord, this particular Hanumanna mortgaged that property, including other properties, in favor of Dodda Hanumantappa on 6/2/1950. After discharge of mortgage loan, this
But what is the date of the first statement in favor of the defendants?
18/4/1949.
No, you say 11/4/1947. Please come to paragraph number 22.
Paragraph 22 of the trial court judgment, my lord. Yes. On the contrary to these documents, the defendants have relied upon the sale deed dated 11/4/1947, alleged to have been executed by Donkanna in favor of Hanumanna, and Exhibit D2, the registered mortgage deed dated 6/2/1951 between Hanumanna and Hanumantappa and Dodda Hanumantappa. And the Exhibit P3 is the reconveyance deed executed by the said Dodda Hanumantappa in favor of one Gauramma, the purchaser of the said property under the deed from the children of Hanumantappa. The property under these documents is nothing to do with the suit scheduled property. Hence, the condition of defendants and the property described in P2 tallies with Exhibit D2, and hence the property mortgage is divided between the sons of Ramalingappa, and hence the plaintiffs cannot claim their title over the suit scheduled property. And once mortgage is always a mortgage, does not hold any water, as the property under Exhibit D2 does not tally with Exhibit D1. Lord, I had difficulty, Lord, with this Exhibit D1, Lord. I have all other documents, my Lord. Exhibit D1, Lord, I did not have in my file, Lord. That is the reason, my Lord, Lord, I requested by my Lords, my Lord, to secure the lower court records so that, my Lord, once and for all, the appeal could be disposed.
That's right, but what does the trial first appellate court say?
Lord, first appellate court, my Lord, has not gone into detail about this, my Lord. The reasons, my Lord, your Lordship finds at page 15. The case of the plaintiffs is that, Lord, what happened is, Lord, plaintiff witness, Lord, PW1, has pleaded ignorance, Lord, of about all the suggestions made by.
Please read paragraph number 15.
15, Lord, yes.
Of the first appellate court judgment.
Yes, I will do it. On looking into all these materials, the case of plaintiffs is that suit property has come to the share of G. Govindappa in the partition of the year 1955, and after G. Govindappa, plaintiffs have succeeded to the suit property. According to the plaintiffs, the defendants have trespassed into the suit property and have put up temporary shed. The defendants have denied the title to the suit property by the plaintiffs and have contended that the suit property belonged to their ancestor Donkanna. Therefore, plaintiffs have claimed the title to the suit property on the basis of the sale deed executed in the year 1948 in favor of Ramalingappa by Donkanna, and also subsequent partition deed of the year 1955. The sale deed is produced as Exhibit P1, and partition deed, in which KS number 89 is given to the share of G. Govindappa, is produced as Exhibit P2. Lord, kindly appreciate, Lord, after this 1955 partition deed, in the year 1994, Lord, Ramalingappa's son, Dodda Hanumantappa, has executed a reconveyance deed, Lord, on 26/4/1994. That is mentioned down below, Lord.
Right. No. Donkanna lost this property in the year 1948.
Yes, Lord.
How did he sell it later again to you?
Lord, no,
Or
Lord.
to your predecessors?
The Donkanna sold it in favor of Hanumanna.
That is when?
Lord, in 1947. Lord, page 18 itself, Lord, 18/1/1947.
Yes. No, that is in respect of the southern portion.
Lord, that is the reason, Lord, I did not have Exhibit D1, the copy of the Exhibit D1. Lord, that is the reason, Lord, I thought, Lord, that records could be secured so that.
R. Gopal. R1 Idea.
7 under Exhibit D1, Venkana, my lord, who is the grandfather of defendant, sold southern northern portion. Later, my lord, in the year 1948, under Exhibit B1, Venkana sells, my lord, the remaining in favor of grandfather of the plaintiff. And, my lord, in the partition.
Exhibit B1 idea.
Yeah. Answer is that is in favor of.
Going to give it a copy to him. ಈಗ ಕಳಿಸ್ಕೊಡಿ ಒಂದು photocopy ಮಾಡ್ಕೊಳ್ಳಿ.
He sold it in favor of grandfather.
WhatsApp ಮಾಡಿ ಇವಾಗ. I'll pass it over. Pass over. Mr. R. Gopal will WhatsApp it to you.
Then, my lord, could it be tomorrow or day after tomorrow?
Sorry, sir. Sorry. Admission matters. Please don't ask time.
Yes. Lord, I will try to assist, my lord, the court.
Why I am not granting adjournment is the number of matters which are pending for admission.
Yes, my lord.
3,000 and odd cases are still pending for admission. So let us expedite it. Yes, Mr. T. and Raghupati. Password.
31. Appellate.
Admit issue, admit issue notice, call for records. The substantial question of law, the common substantial questions of law, which arise for consideration in this appeal is whether an illegitimate child of a co-person can claim a share in the co-personal property can claim a share as a co-personal in a co-personal property. Stella, this is the only question.
Section 133 of Karnataka Land Reforms Act. The land return case pending in disposal filed by some third party. During the pendency of the land renewal cases pending before the land renewal, civil court will not get the judicial party. That's what my submission.
Civil court judgment agide yaವಾಗ?
Judgment agide civil court judgment ಮಾಡಿದ್ದು ಬರಲ್ಲ ಅಂತ. That's what the ನಮ್ಮ ಹೈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ತೀರ್ಮಾನ.
ಅದಾಗಲೇ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ.
ಹೌದು.
Full bench judgment is no. If it is before 1975 when section 133 was introduced, then civil court has got jurisdiction. But if it is after 1975 when section 133 was introduced, any matter which the tribunal has to deal cannot be considered by the civil court. That is the law declared by the full bench of this. That is perhaps a judgment rendered by Justice. But full bench judgment consider ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
ಅದು ಇದೆ ಮತ್ತೆ ಓಲ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮುರುಗಯ್ಯ ಮಲ್ಲಯ್ಯ ಅಂತ
Number 2, whether the trial court was justified in not considering the effect of section 133 of the Karnataka Land Reforms Act 1961 on the claim of the plaintiff.
Bar number 7, filed by one common number.
The claim of the plaintiff. Yes. Paper books to be filed within 8 weeks.
The
buying up of final decree is state in the buying up of final decree is state. However, the proceedings of the final decree shall continue. Yes. Saying care about Mr. Yesterday and Mr. Next week and next week ಬರೋದಿಲ್ಲ ಅದು. Yes. Password. ಯಾರು ಪುಟ್ಟೇಗೌಡರ? Password.
This is not defendant's appeal. Appellant is 8 defendant.
Yes, please. Yeah. 43.
Yes, The purchaser of land in survey number 91, he suit schedule item number 2. He purchased the property from the first defendant and his family members on 15/10/2008. Approximately come to the family.
Work out your revenue in the final decree.
ನಾನು ಶೇರ್ ನನ್ನ ವೆಂಡರ್ಸ್ ಅಲಾಟ್ ಮಾಡಿದ್ರೆ ಸಾಕು.
Again, allot ಮಾಡಕ್ಕೆ. You have purchased property from the defendant number 1. Plaintiffs also have a right.
Approximately come to the family. Which is at claim number 101.
Yes.
ಹನುಮಂತಯ್ಯ ದೊಡ್ಡಮಾರಮ್ಮ ಇಬ್ಬರು ಮಕ್ಕಳು ಅವರಿಗೆ ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ ಪಾರ್ವತಿ. Notes, I purchased the property from the legal heirs of Venkatalaxmi. Plaintiffs are the legal heirs of Parvati. They filed this suit in the year 2009, contending that suit schedule properties were owned by Mr. Hanumantayya. After his demise, the legal heirs of Venkatalaxmi as well as the plaintiffs succeeded to the property, and there is no partition. They are entitled for a share. Defendants have filed written statement specifically contending that Mr. Hanumantayya owned properties at Banikutte, which are the suit schedule property. He also owned the properties in 3 survey numbers of Jeppanelli village. There was a partition between this Parvatamma and Venkatalakshmamma prior to 1976. This Venkatalakshmamma sold the properties allotted to her under the sale deed dated 16/2/1976. In Exhibit B2, it is not specifically mentioned that there is a division and she got the property in terms of the partition. But the trial court finding is that the defendants have not placed any document to establish that these properties, the properties at Jeppanelli village, was owned by Hanumantayya. They filed an application under Order 41/27 before the first appellate court, and they produced this sale deed before the first appellate court to establish that the properties at Jeppanelli was also owned by Hanumantayya. But
including the property that was sold.
Yes. And the fact that the Parvatamma Venkatalakshmamma has not joined the sale deed and it was sold only by the one daughter clearly established that there was a division between the 2 daughters.
That established.
Sorry.
Will that establish?
We have placed the sale deed before the first appellate court.
Let us assume that Parvatamma had sold one item of the property which belonged to her father. We'll accept it. Will that prove a partition?
I am going to establish submission. It will not directly prove the partition. I am going to submission on the scale of preponderance of properties. We are saying father owned different properties in 2 villages, and there was a division. One daughter shifted to this other village, and she got the properties owned by the father. She alone sold the properties. The remaining property was sold by the daughter of other daughter's legal heir, and she has not made any claim during her lifetime.
Include that property also in the final decree proceedings.
You already sold the property.
You include it. What is the difficulty? You can include it.
1976.
I include what?
Difficulty on the purchaser.
Sure. You stand in the shoes of the defendant number 1 and 2. So therefore you include that property also, so that the share of the plaintiffs are offset in that property that is sold by them.
Sold in 1976.
Why not is what I am asking you. If according to them there is no partition. If according to the plaintiffs there is no partition.
Partition amongst the legal heirs.
But yet they have sold. That property is still available for partition.
They are claiming under section 6. These properties were sold prior to 20th December.
It doesn't matter. You are not a party to it.
I am not a party.
Then your vendor is not a party.
My vendor is not a party.
Therefore, you can ask the court to apportion the property that is sold to their share and allot this property to your share. That the final decree court will do.
Specifically contended for the court.
Please reserve all your right to urge in final decree.
One finding of the appellate court. What has happened? The 8th defendant is the wife of the. She filed an application under Order 3/1/2 of CPC to examine her husband as a power of attorney. Trial court has permitted him to conduct the case on behalf of and he was examined as DW4. He was cross-examined. First appellate court specified his entire evidence on the ground that he has not produced the G. My and respect for submission.
ನಾನು ಹೇಳ್ತಿರೋದು if you purchase the property, defendant number 1. You are entitled to final decree proceedings. The final decree court may even allot the entire property.
First appellate court has to mainly come.
Please work out your remedy before the first appellate, final decree court. Yes, who appears for the respondent.
Can I take Lordship's attention to paragraph 32, page number 45? With the contention of the defendant that she is the bona fide purchaser of item number 3 property in survey number 91, measuring so and so. The power of attorney holder of defendant number 8 is examined as DW4. It is evidence of DW4 that he is the PA holder of 8 defendant. However, to establish his authority to dispose on behalf of defendant number 8, he has not produced so-called PA executed by defendant number 8, hence no reliance in the attachment to the evidence. First appellate court notes has completely ignored the fact that defendant number 8 has filed an application before the trial court.
It's all right. What is the end of what will you achieve after all this?
I am the submission. First appellate court could not have brushed aside my entire evidence.
Will take your evidence into account. Yes, what will happen?
And request to treat me as a bona fide purchaser.
With respect to what extent?
Because total extent is 2 acre. Total extent of the suit shell of properties. My extent is 1 acre 8 guntas. Total extent is 2 acre 22.
So therefore, what can
let them allot the remaining property to the share of 20? Let them allot my property.
That is what will happen in final decree, Mr. I don't know whether you ever conducted a final decree. Then whatever that is sold by the defendant number 1 will be, attempt will be made to allot the property to the defendant number 1 and the remaining to the plaintiff.
Please grant me that liberty.
Liberty is there. There is no question of granting that liberty.
The appellate court, in fact, has observed in the finding part, but it's not declared in the operative. Finding part, paragraph number 36, it has observed.
The 83 Supreme Court has observed. Please go through the judgment. 1983 SC 124 is the code. Year 19 SC 83 SC 124. You are a purchaser pendentility.
Prepared the documents and Kata was standing in my vendor's name over a period of 18 to 19 years and circulated the handbill before purchasing the property.
Please go through the judgment. Pass over. You have to work out your remedy in the final decree. You are a purchaser. And the entire extent is not purchased by you. No, only a portion is purchased. So that portion will be allotted to the share of the defendant number 1. The remaining portion will be allotted to the share of the plaintiffs. Otherly another.
Let me pass over, I will go through.
Yes. Kemchand alva. Yes, next. Pass over this. 43.
Sorry, madam. Yesterday I can't be present this afternoon.
Morning, sir. My
colleague mother passed away. Therefore, I was supposed to go there. I held up a test. There on the last occasion, my lord suggested, my lord, either to pay 10 lakhs start ready. Because I don't see has 2 daughters. I don't know that's the problem. Moreover, my lord, total extent is 2%.
Yes. Please argue. Let us see. If that is the case, we will admit it. Yesterday I suggested 5 lakhs. Yes, please.
Last occasion, my lord suggested also, my lord, even if the alternative
alternate ಇಲ್ಲ ಸರ್ 5 ಲಕ್ಷ ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಹೇಳಿದೆ.
Any land ಅಲ್ಲಿ 5 ಐಟಮ್ ಇದೆ ಯಾವ್ದಾದ್ರು
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ವಾಂಟ್ ಏನಾದ್ರು ಇನ್ನೊಂದು 10 ವರ್ಷ ಇಲ್ಲೇ ಇರ್ತೀವಿ ನಂಗೆ ಇರ್ಲಿ ಬಿಡಿ ಯಾರು ಬೇಡ ಅಂತ. ಹೇಳ್ರಿ 2006ನೇ ಇಸ್ವಿ ಇನ್ನ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ. 2006ನೇ ಇಸ್ವಿ ಕೇಸು ನಿಮಿಷ ತಾಳಿ ಐಎಮ್ಗೆ ಹೇಳ್ತೀವಿ. 2006ನೇ ಇಸ್ವಿ ಕೇಸು ಇನ್ನ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆಯಮ್ಮ. 16 ವರ್ಷ ಆಯ್ತು ಇನ್ನ ಮುಗಿದಿಲ್ಲ. ನೀವು ಇನ್ನ 10 ವರ್ಷ ಕಾಯ್ತೀರಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. ನೋಡಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಎಷ್ಟು ಎವ್ರಿ ಡೇ ನೋಡಿ ದೇ ಕಮ್ ಟು ಯು ಹೋಮ್ ಅಂಡ್ ಯಾವ ಕೊಡ್ತಾರೆ 5 ಲಕ್ಷ ಯಾವ ಕೊಡ್ತಾರೆ ನಾಳೆ 5 ಲಕ್ಷ ತಂದು ಕೊಟ್ಬಿಡಿ ನಾಳೆ ಮುಗಿಸ್ಕೊಟ್ಬಿಡ್ತೀನಿ ನಿಮಗೆ ಒಂದ್ ತಿಂಗಳ ತನಕ ಯಾಕೆ ಕಾಯ್ತೀರಾ ನಾಳೆ ತಗೊಳ್ಳಿ ನಾಳೆಯಿಂದ ನಾಡಿದ್ದಿಂದ ನಿಮ್ ಜಮೀನಲ್ಲಿ ಹೋಗಿ ಪೊಲೀಸ್ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ 5 lakhsಗೆ 1 month ಕೊಡಿ ಅಂತ ಹೇಳಿ ಆಕ್ಚುಲಿ 2 lakhs ಹಳಿದಿದ್ದಾರೆ ಯಜಮಾನ್ರಿದ್ದಾರೆ ಒಬ್ಬ ಮಗ ಇದ್ದಾನೆ ಎಸ್ ಎಸ್ 5 ಲಕ್ಷ ಕೊಡ್ತಾರಂತ ನೋಡಿ ನಾನು ಲೆಟರ್ ಬರ್ತಿದ್ದೀನಿ ಆಕ್ಚುಲಿ ಐ ವಾಂಟೆಡ್ ಟು ಕೀಪ್ ಇನ್ ಪ್ರೆಸೆಂಟ್ ಫಾರ್ ದಿ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಫ್ರೈಡೆ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗ್ತಿನ ಅವ್ರು ಡೇಟ್ ಕೊಡ್ತೀವಿ ಅವ್ರನ್ನು ಬರೆಯಲಿ ಶುಕ್ರವಾರ ತಂದು ಕೊಡ್ತೀರಾ ನೀವು ಒಂದ್ ತಿಂಗಳ ಇಟ್ಕೋಬೇಡ್ರಿ ಯಜಮಾನ್ರೆ ಆದಷ್ಟು ಬೇಗ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಮನ್ಸು ಬದಲಾವಣೆ ಆಗ್ತದೆ ನಾನು RPID ಲೆಟರ್ ಬರ್ದಿದ್ದೀನಿ 14 ತಾರೀಕಿಗೆ ಬರ್ದಿದ್ದೀನಿ ಮನ್ಸು ಬದಲಾವಣೆ ಆದ್ಮೇಲೆ ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ 3 ಜನ ಮಕ್ಳಿದ್ದಾರೆ 5 ಲಕ್ಷ ಜನರೇಟ್ ಮಾಡಕ್ ಆಗಲ್ವೇನ್ರಿ submission directly respondent every day they are going to their home and writing ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು ಬೇಗ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಈಗ ಅಂತ ಮುಂಚಿಂದನೂ ಹಂಗೆ ಮಾಡ್ತೀವಿ ಇವಾಗಿಂದ ಆಯ್ತು ಇವಾಗಿಂದ ಅಂತ ಹೇಳ್ತಿದ್ದೀನಿ ನಾನು ನಾಳೆಯಿಂದ ಹೇಳಿದ್ರೆ ನಾಳೆ ತಂದು ಕೊಡಿ ನಾಳೆಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಪೊಲೀಸಿಗೆ ಹೇಳ್ತೀನಿ ಪೊಲೀಸ್ಗೊಂದು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ ಅಲ್ಲಿ ಹೋಗುವ ಎನ್ಶೋರ್ ದಟ್ ಇಪ್ಪತ್ತೆರಡು 28 29 29 List on 29th at the request of the learning council of the appellant and the respondent. ಮಾಡಿ ಎಷ್ಟೇ ಸ್ಟಾರ್ಟ್ ಆಡ್ತೀರಾ ಆಡಿ why don't you argue this ಒಂದು ಹೇಳ್ರಿ ಒಂದೆರಡು ಮಾತು 4 ಗಂಟೆ ತನಕ ಪಾಸ್ ಓವರ್ ಆಗ್ತಾನೆ ಇರ್ತದೆ ಪಾಸ್ ಓವರ್ ಒಂದೆರಡು ಮಾತು ಹೇಳಿ ನೀವೇನು ಪರವಾಗಿಲ್ಲ ಮೇಡಮ್ you either argue or I'll dispose it off madam ನೀವೇ ಹೇಳಿ ಇಲ್ಲ ಏನಾದ್ರು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ yes madam yes concurrent finding ಇದೆ ಹಂಗೆಲ್ಲ ಕೊಡೋದಿಲ್ಲ ಮೇಡಮ್ yours is not the only case madam in the high court there are 3000 lawyers waiting for their cases to be listed sorry I can only pass over up to 4:30 you can come and argue anything pass over ಸರ್ ಎಲ್ಲಾ ಕೇಸು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿರಿ ಯಾಕೆ ನೀವು ಹೇಳ್ಬಿಡ್ರಿ ನಿಮ್ದು ಅಡ್ಮಿಷನ್ ನಂದು ಇಂಥ ಕೇಸ್ ನಾನು ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟು ಇಂಥ ತಾರೀಕು ಅಂತ ಹೇಳ್ರಿ ಆಯ್ತು ಪ್ಲೀಸ್ ಇಟ್ಸ್ ನಾಟ್ ಸಮಥಿಂಗ್ ಯಾರು ಆಯ್ತು ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಲೆಟ್ ಅಸ್ ಸಿ ಏನೋ ಇದ್ರೆ ವಿಲ್ ಅಡ್ಮಿಟ್ ಆಮೇಲೆ ಬೇಕೇ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋರು ಅಂತ
first respondent hearing. First respondent number 1 which are quite super partition. Soon came to degree. But again appeal has been given and it has been confirmed. Then once the soon came to be degree done. That's 27/4/2013. 27/4/2013. Super partition. Yes. Shares have been granted. That's the 4 shares. But subsequently minutes on 17/6/2010, the respondent number 1 was accepted.
Respondent is ಯಾರು?
Respondent number 1 is none other than the mother of the baby.
ಮತ್ತೆ ಅವ್ರು ಇದಾರಲ್ಲ, ಇಬ್ರು ಮಕ್ಳಿದಾರಲ್ಲ.
ಅದೇ mistake ಆಗಿದೆ. That's against dead person. That's a final degree has been achieved. Final degree has been passed against the dead person. Again, it's in the appeal. The same ground has been taken by this appellate that is against dead person and order. In spite of that, the court has said that it's a minor mistake. So it can be rectified.
Please read the order. Point number 1 in the order. Paragraph number 9 in.
There's paragraph 9.
10 in the
These 2 points for consideration revolves around discussion and sense of action fighting on one point without waiting on the other point. Hence, I've taken all these points together for consideration. That's the first and foremost ground that the judgment and decree invoice number 50/2010 dated 27/2013 was passed against the dead person. That's first response.
Please read. Yeah.
That's again same is in nullity. Further, it is contended that the petition in FDP number 2/2010 was also filed against the dead person and same as constituted this to be. In this background, there is no dispute that if the judgment is against a dead person, then said the judgment will be nullity. In this background, it is important to know as to when the baby number 1 was dead and whether a death was reported to the court. Suit was filed by one original engine and have 2 daughters, that is respondents. It is important to note that the suit was filed on 14/2018. The judgment in voice number 50/2010 shows that the plaintiff number 1 had filed a right justice. Further, in paragraph number 30 of the judgment, is clearly stated that there will be penance of the suit. Plaintiff number 1 has reported to be dead. Further, said paragraph also shows that related by plaintiff number 2 he was not proved and there was modification of share holding that all the children of plaintiff number 1 are entitled to equal share of property. Therefore, absolutely there is no appellate that the said judgment was against the dead person. Of course, in the course of title of judgment and decree, it is not shown that plaintiff number 1 is dead. Of course, in the cost title of judgment and decree, it is not shown that plaintiff number 1 was dead. Said mistake may be typographical error or oversight. Not mentioning of death of plaintiff number 1 cannot be treated to hold the judgment is passed against the dead person. It's 1762 when then prior to passing of the decree that she was expected.
But ಹೇಳಿದಲ್ಲ ಇಲ್ಲ this property is owned by this lady.
No, not lady, it's a father's property. So even after the judgment and decree, that kind of page next to the order.
Paragraph 12 ಓದು.
Paragraph 12. Further, it is contended that the final decree proceedings is also instituted by showing dead person as a part of the proceedings. The cost title of petition in FDP number 1/2013 contains the name of said original entity as petitioner number 1. However, the petition is signed by only petitioner number 2 and advocate of petitioners. The wakalat of counsel for the petitioners contains signature of the petitioner number 2 and 3. It is admitted fact that when the petition was filed, petitioner number 1 was not on. The lack of professional approach by the advocate for petitioner may be reason to show the name of the petitioner number 1 in the petition, even though she is because of mistake on the part of the counsel. Dead person has been made as a part. And my lord, the
even ಇದು preliminary decree ಎಷ್ಟು 1/3 ಮತ್ತೆ ಅಷ್ಟೇ ತಾನೇ ಬರೋದು.
again the chain has to be modified by the final decree proceedings.
The mother is not there.
Mother is
There are two daughters and one son.
This is again daughter of this 19/1/2022.
ಅವ್ರ ಮಕ್ಕಳಿಲ್ವಾ?
ಅವ್ರು ಇದ್ದಾರೆ.
ಮತ್ತೆ ಅವ್ರು ಬರ್ತಾರೆ.
ಅವ್ರು ಬರ್ತಾರೆ. Again, the steps has to be taken.
What I am asking you is, your mother was dead. She was made a party in the suit.
So the first plaintiff.
She was the first plaintiff in the suit. Suit was decreed. ಏನಂತ decree? So mother share ಕೊಟ್ಟಿಲ್ಲ because she is dead. Mother share ಕೊಟ್ಟಿಲ್ಲ because she is dead. Now in final decree proceedings, mother was again made a party though she was dead, which should not have been done.
Initiation of final decree proceedings against Miller even though she was dead prior to the passing of the decree. The council has made the dead person as a
ಏನ್ ಮಾಡ್ತೀರಾ?
party to the final decree proceedings.
Because of mistake by the
proceedings were dead. Famous dead person.
ಲಾಯರ್ ಮಾಡಿದ ತಪ್ಪಿಗೆ ಡಿಗ್ರಿ ಯಾಕೆ ಸಕ್ಸೆಸ್ ಮಾಡೋದು?
Lack of professional approach.
Obviously, ನೀವು OS ಅಲ್ಲಿ ತಾಯಿ ಸತ್ತೋಗಿರೋ ಅಂತ ನೀವೇ ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ತಿರ್ಗಾ FDP ನಲ್ಲಿ
ಮಾಡಿ
ಅಲ್ಲಿ ಅನ್ಪ್ರೊಫೆಷನಲ್ ತಾನೆ. That is unprofessional. Mother ಎಲ್ಲಿ ಕೊಟ್ಟಿದೆ is what I am asking you. Was any share allotted to the mother? It could not have been allotted.
She has to be modified. So that's
For what? Mother share ಎಲ್ಲಿ ಕೊಟ್ಟಿದೆ? Decree the preliminary decree. Please, where is the preliminary decree? Yeah. OS number 50. Preliminary decree ಇದೆಯಾ? ಕೊಡಿ ಇಲ್ಲ ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ? ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಮದರ್ ಶೇರ್ ಕೊಟ್ಟಿಲ್ಲ ಬಿಕಾಸ್ ಶಿ ಇಸ್ ಡೆಡ್. ಇಬ್ಬರು ಸಿಸ್ಟರ್ಸ್ 2/3 ನಿಮ್ಗೆ 1/3. ಏನು ಆಯ್ತು ಹೇಳಿ ಓದಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? Paragraph number 12. Then paragraph number 13. What is?
Moreover, no prejudice is possible to apparent hearing. It's an admitted fact that judge and judge can only present apparent respondents as a defendant. But nothing of this is, but by nothing, this is even the preliminary decree, the shares of parties of the enhancement to 1/3 share. Apparent as a grievance that the preliminary decree grievance was not applied, and equal share is to the properties were not awarded. It is important to note that the apparent is challenging the preliminary decree and not the therefore, you cannot be permitted to use grievance against preliminary decree. This is that it is appropriate to note the responsibility. The above principle is squarely applicable to case and apparent now cannot be permitted to dispute the characteristics of the preliminary decree. You have the above discussions in conjunctions of the apparent that the judgment in OS number 5410 was passed against the dead person and final proceedings was instituted against the dead person cannot be accepted. Further, no prejudice has been asked to defect in past item. Next point, the appellant has contended that trial court is basically proceeding to pass a final decree without giving an opportunity to the appellant. In this background, I have gone to the honest trial court after the institution of the eviction to this was respondent. The respondent was present in the court and great length of objection. However, on next day, the respondent again absent in the prosecution. His objection was taken as not valid. Thereafterwards, commissioner was appointed and report was secured. Even evidence of people who was there. Thereafterwards, the court responded to his appearance as advocate. However, in spite of the engaging advocate, respondent is not administered questioning report of the court commissioner. Or the question came of the commissioners. On 22/11/2020, fiction was about the penalty was passed. Therefore, the trial court was not prosecuted in the case. On the other hand, there was sufficient authority for the respondent to participate. Only good fact that the respondent has not this opportunity. So I'm sorry. Appellant has contended that the entire penalty was effective and illegal. But in closing to the appellant has contended that the court commission cannot effect partition of property. Therefore, has contended for effect partition of commission. Therefore, contended that the entire penalty is allowed. This regard towards the report's judgments. But the question is that the impact on the whatever the properties, that's how the ability to position entire properties. But shares of the other that he has really invested and accepted other to the property.
In sisters are there. ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಪ್ಪ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Chances of settlement.
Not from 2013 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. Not issue notice. ನೀವೆಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಂಗಿದ್ರೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀವಿ. Counsel for the appellant. ಫೈನಲ್ ಡಿಗ್ರಿ ನೋಡ್ರಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಭಾಗ ನೋಡಿದೆ ಅದನ್ನು ಒಂದ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟು counsel for the appellant seeks time to explore the possibility of a settlement. Just next Tuesday.
For permanent injunction concerning agricultural property bearing survey number 98/1 measuring 38 meters. And the claim of the plaintiff is that he had purchased in extent of 28 meters of land, said survey number from one G Mahalakshmi under the registered sale deed dated
26/6. 26/6.
The said sale deed my lord is at exhibit given. Now concerning the other 9.5 meters of land, a tenancy claim had been made by the brother of the plaintiff, and an order has been passed by the land tribunal, by the virtue of which entire 38 meters of land became the property belonging to the brother of the plaintiff by name Rectification. And thereafter there was a partition among the brothers, that is between the Venkat Reddy and the other brothers. And at that said partition of the year 1981, two properties entirely measuring 38 meters but to the share of the plaintiff. And this is the fashion manner under which it is for declaration of right for permanent.
Yes.
The defendant number 1 and 2 manner remained ex parte. The contesting respondent is defendant number 3. Now defendant number 3 by name Manjulamma manner claims property to defendant number 1, who is stated to have sold this property through the GPA holder defendant number 2. Now, of course, she doesn't know about the earlier transactions. She says that this is a property that belonged to defendant number 1, and he had traced it through his ancestors. And the property has been purchased by her. And hence, my lord, she seeks for this. This was the defense. Lord, survey number 98 originally measured 1 acre 17 meters, including 1 gunta of crop.
1 acre?
1 acre 17 meters. Included 1 gunta of crop. And this was bifurcated into 2 sub-numbers as 98/1 and 98/2, by the virtue of which my lord 38 guntas of land fell to one of the Bajudar and another 19 guntas to the other Bajudar. The division was made north and south. My lord, the Akarbans have been produced and it is marked as exhibit 350. Now the northern portion of the property, my lord, measured 38 guntas and it was assigned the survey number 98/1. While the southern portion, my lord, was assigned survey number 98/1. It measured 19. In the property, my lord, that was sold in my favor, that is in my brother's favor, by the erstwhile owner by name Mahalakshmi. My lord, 98/1 is the specific survey number. Yes. And to the south, my lord, it was specifically stated that the land of one Gangadharachari. Now that Gangadharachari, my lord, is the owner of 98/1. So it is evident that the property that I had purchased was coming in the northern side of survey number 90.
But what about exhibit P12 and P13?
They are the RDC extracts. Now what happened thereafter was, well, though this was the survey sketch, while making the entry in the RDCs, well, 98/1, which actually measured 38 guntas, was shown as 98/2. The names extent remained the same. Only there was a mistake, my lord, in entering the survey number. Accordingly, my lord, 98/2, which measured 19 guntas, was shown as 98/1. It was, my lord, 19 guntas only, and it stood in the name of Gangadharachari. Now, Gangadharachari died. My lord, I have produced the MR extracts. After Gangadharachari's death, the Pata, my lord, was transferred in the name of his wife by name Sharadamma. That is exhibit P4. After Sharadamma's death, defendant number 1's father by name Babu, my lord, got the revenue entries transferred to his name, saying that he is the Varis Dada of Sharadamma. That is exhibit P50.
Yes.
In this fashion, my lord, this 19 guntas of land
Khata Mala was got to the name of defendant number 1. And the RTC showed it as 98.1. Thereafter, what he did was, concerning the other portion of the land on which I am claiming
Issue notice, call for record. Yes, sir.
Not purchased. But this is for partition. But other of the present appellate was defendant number 34. Her husband was a member of the family, that is government, etc. In a Alessandana family, wife and husband, they belong to different groups. Husband belongs to his mother's kutumbam and wife belongs to her mother's kutumbam. And children of a male person belong to their mother's kutumbam, that is wife's kutumbam. But here, my lord, question is, my lord, occupancy right has been granted in the name of defendant number 34, who is the wife of a member of the family. Now, partition has been filed in respect of the very same property. The question is, my lord, whether in the light of an order by the land tribunal granting occupancy right in favor of a person who is not a member of the family, partition without getting that order set aside or declared as other.
Why should that order be set aside? News to the family.
No, my lord, I am not a member of the family. Wife is not a member of the family. Therefore, my lord, it cannot be said, my lord, it endures to the benefit of the family. It is granted in the name of a wife of. Whether it is right or wrong, my lord, it is
granted in the name of the husband of the.
Not husband, wife of one Aitapatingalaya, who was the member of the family of the king.
The wife of Tungamma.
Tungamma is the wife of Aitapatingalaya.
So this land is granted in the fame of Tungalaya.
Illa, Tungamma is not a member of the family, admittedly. Even according to them, defendant number 1 to 33 are the members. Therefore, when that order is operating, it should be set aside either by filing a writ petition, and a civil court has no jurisdiction to go behind the order.
What is the relationship between the plaintiffs and the defendants?
Plaintiffs and defendants, they are the members of the same family.
How many defendants? All of them?
D1 to D33. D34 is the wife of Aitapatingalaya, who was the member of the family.
How is the plaintiff and this Aitapatingalaya?
They are the members of the same family. Aitapatingalaya was the Yajamana. He was the Yajamana. But his wife, Tungamma, she filed the declaration, and occupancy right is granted in her name. The courts hold, my lord, that proceeding is collusive. Therefore, that order will not come in the way. That cannot be decided by the civil court. It should have been got set aside by the.
Why should it be set aside? It is used to the benefit of.
No, my lord, she is not a member. She is not a member of the family.
Where does the trial court consider that?
Yes. Trial court and first appellate court, they, my lord, they hold, my lord, because it is collusive proceedings, my lord, it cannot be.
Please come to page number 14. Sorry, 17 of the trial court judgment. Second line. Aitapatingalaya executed a permanent lease deed in favor of his wife.
Yes. Same. Well, that was set aside by a decree of the civil court. Well, that decree has become final, and admittedly possession was with the Aitapatingalaya. He was in possession. My lord, then, my lord, the wife filed a declaration in form number 7. Occupancy right is granted in her name in the year 1978.
Well, a suit for partition in respect to the very same property is filed.
What does it first appellate court say about this?
It says, my lord, it is a collusive proceedings, therefore there is no pleading with regard to collusion. Page 77.
Appellate issue notice. Call for records. The substantial questions of law which arise for consideration in this appeal is whether defendant number 54 was a member of the earlier Santana family of
Her husband
was not a member. Whether the defendant number 34 was not a member of the earlier Santana family of the plaintiffs and the defendant full stop. Whether the grant of the land in question to the defendant number 34 could be treated as by the land tribunal, number 34 by the land tribunal was due to husband of the defendant number 34 and the defendant number 34. Whether the question, whether the civil court could decide the question as to whether the plaintiffs and the defendants up to 33 were joint tenants of the land in question in view of section 133 of the Karnataka Land Reform Act 1961. Paper books to be filed within 8 weeks. Drawing up of the state, however, the proceedings of the final decree shall continue.
My lord, I am appearing for appellant, my lord, in this case. My lord, my senior is not feeling well, my lord. Kindly grant 1 week time, my lord.
Argue. Please argue, Mr. Yalla concurrent finding alli time keltira. Dismiss agadಕ್ಕೆ ಬಿಡೋದೇ ಇಲ್ಲ ನೀವು.
1 week time may be granted.
I will pass it over. You please get ready and argue.
No, my lord, my senior is not feeling well, my lord. That's why I am seeking time.
You pass over argument ಮಾಡಿದ್ರೆ dismiss ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
My lord, my senior is not feeling well, my lord. That's
ನೀವು
why
argument ಮಾಡ್ರಿ, ಎರಡು ಮಾತು ಹೇಳ್ರಿ, ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ರಿ.
ಸ್ವಾಮಿ ನಾನು ತುಂಬಾ ಜೂನಿಯರ್ ಸ್ವಾಮಿ.
ಫುಲ್ ಓದ್ಕೊಳ್ಳಿ ಜಜ್ಮೆಂಟ್, ಫುಲ್ ಓದ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಪಾಸ್ ಓವರ್. Present appellant is the defendant number 1. Yes. Why did the trial court dismiss the suit?
then the due to the marital property, and there was the property of the mother of the plaintiff who died. The self-acquired property of the father of the plaintiff, and who died afterward. After death of the father, the mother is the defendant number one, who has sold the property for having his family legal asset. On this note, my condition is my position is that present appellant defendant number one, the Manapata purchase is not only improvement because contention raised by the plaintiff firm, their interest was here is not die because the property is not granted property because this and the property is the property which was in position of the first defendant, that has become the exclusive position of the first defendant, and it is self-acquired harassment.
She noticed call for report. Early notice over.
Yes, ma'am.
The customary rights of the borrowers has been questioned.
ಇದು ಕಸ್ಟಮರ್ ರೈಟ್ಸ್ ಏನಿದೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ ಹೇಳಿರೋದು ಎಲ್ಲಾರು ಮಾಡಿದ್ರೆ
ಒಂದು ಸೂಟ್ ಆಗ್ತಾರೆ absolute we have the absolute rights over the transferring rights. That is a declaratory suit. That suit came to be withdrawn with the liberty to file a fresh suit. Later, my lordship, without seeking any sort of any suits or any sort of relief, our right has been established in 1970, 1966 itself, my lordship.
ರೈಟ್ ಅಂದ್ರೆ ಯುವರ್ ರೈಟ್ ಅಂದ್ರೆ ಏನು? ಕ್ಷತ್ರಿಯ ಸಂಘ
Transferring rights of
ನಂಜನಗೂಡು ಕ್ಷತ್ರಿಯ ಸಂಘ ಇದು ಟ್ರಾನ್ಸ್ಫರಿಂಗ್ ರೈಟ್ಸ್ ನಿಮಗೆ ಯಾರು ಕೊಟ್ಟಿದ್ರು?
Lordship, it's a palace authorities, lordship. Mysore Maharaja. Those records are, those documents are my lordship. ಅದೆಲ್ಲ ಯಾವುದನ್ನು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅವರು ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಲಿಲ್ಲ. Those records are
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
lordship.
What is the document?
ಎಲ್ಲ ರೆಡಿ ಮಾಡಿದೆ.
ಇಲ್ಲಿ ಅವ್ರು ಮಾಡೋದು ಏನ್ ಸರ್, ನಂಜನಗೂಡಲ್ಲಿ ಇರೋ ಎಲ್ಲಾ ಕ್ಷೌರಿಕರನ್ನಾಗ ರೈಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ ನಾಟ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಯುವರ್ಸ್.
ನಮ್ಗೇನು ತೊಂದರೆ ಇಲ್ಲ. ಇವರು ಔಟ್ಸೈಡ್ ನವ್ರನ್ನ ಕರ್ಕೊಂಡು ಬಂದು
Please read the order portion of the first appellate court.
There are several documents which are not at all appreciated by the courts, both the courts. Lordship, it is of the year 1930.
Exhibit.
Lordship. P1 now.
P1 is not 1930 the law.
P1 is after 1934. 30 minutes. It is up to 30. Here, Lordship, ನೀವು ಶಿಫಾರು ಮಾಡುವ ಮೇರೆ ಜೋಗಿ ಚೌಕಿನಲ್ಲಿ ಸ್ಥಳವಂತಿಗರಾದ ಹಜಾಮರು ವಿನಃ ಮತ್ಯಾರೋ ಮುಡಿ ತೆಗೆಯುವ ಕೆಲಸವನ್ನು ಮಾಡಕೂಡದೆಂದು ಒಂದು ಬೋರ್ಡ್ ಹಾಕಿರುವುದನ್ನು ಮಂಜೂರು ಮಾಡಿದೆ. Lordship, here, my lordship, there is an order to counseling right has been given only for the local barbers.
Okay, sir, you please come to the first appellate court judgment. ಏನಂತ ಬರ್ತಾರೆ ನೋಡೋಣ. ಸರ್ ಆಯ್ತು, ನಿಮ್ದೇ ಕೇಸ್ ತಗೊಳ್ಳೋಣ. ನಂಜನಗೂಡು ದೇವಸ್ಥಾನದಲ್ಲಿ people from the barber community of Nanjangud, only they have the right to township. Please come to the judgment of the first appellate. Page number 6061.
Article number 24 of 2013 is Article number 26 of 2013 is partly allowed. The judgment and decree of the trial court has said the suit of the plaintiff is partly decreed by modifying the relief of and also judgment and decree of the trial court has written. It is declared that the plaintiff and also all the barbers have got right of removal of money from the heads of the devotees of CH-22 temple or temple. The defendant number 1 temple authority shall utilize the service of barber community people of Nanjanguda, including the plaintiff on priority basis with reasonable conditions and restrictions. It is made clear that the temple authority can appoint or take the service of other barbers as and when necessary, taking into consideration of the interest of devotees. If the service of barber community are taken in the place building or presence of the temple can insist upon the suitable conditions keeping the interest of devotees, barbers community, and also the temple. All interim orders passed in the appeal shall not just in this judgment. The suit of the plaintiff seek relief of appropriation of money, absolute rights, and also injunction against the defendant number 1 is dismissed. This is the.
So therefore, you have suppose alone Jatre, there are about 1 lakh people. Nanjanguda iruvanta ಕ್ಷೌರಿಕರು ಸಾಕಾಗೋದಿಲ್ಲ. So what should the temple do?
We have more than 1,500 people Malaysian residents of
Sir, 1,500 ಇಟ್ಕೊಳ್ಳಿ. There are 1 lakh people coming for a jatra.
ಜಾತ್ರೆಗೆ ಬರ್ತಾರೆ.
1 ಲಕ್ಷಕ್ಕೆ ಬರ್ತಾರೆ. ಆಯ್ತು 1 ಲಕ್ಷ ಟಾನ್ಸರಿಂಗ್ ಬರ್ತಾರೆ. ಎಲ್ಲಿ ಏನ್ ಮಾಡೋದು?
ನಾವು ಆಗ್ಲಿಂದ ಕಾಲದಿಂದ ನಾವು ಮ್ಯಾನೇಜ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀವಿ.
Therefore, the court has said, no, please wait. The court has said, ನಂಜನಗೂಡಲ್ಲಿ ಇರುವಂತ ಬಾರ್ಬರ್ಸ್ ಅನ್ನ ಆತ ತಗೊಳ್ಳಿ on a priority basis.
Differential basis.
Nanjangudu, it is declared that the plaintiffs and also the barber community of Nanjangud shall have the rights of tonsuring the heads of devotees of Sri Kanteshwara Swami temple. So, in the
the suit of the plaintiff seeking relief of appropriation of money, absolute right, and also injunction against the defendant number 1 is dismissed. We are seeking customary rights of tonsuring because from the time immemorial, we are tonsuring the heads of the devotees, and we are making appropriate. We are not paid by anything by the temple from the time immemorial. In turn, my lordship, we used to give the service, our service to the temple for Volaga, Prativanto function, Prativanto occasion. We used to give the service of our 3 of us. Our service, Volaga, Kartik Masad Seve, Doddu Jatrege, ಮತ್ತೆ ಪೌರ್ಣಮಿಗೆ ನಮ್ಮ ಸೇವೆನ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ನಾವು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೀವಿ. ಮತ್ತೆ ಆಗ್ಲಿಂದ ನಾವು ಅದರಲ್ಲಿ ಬಂದಂತ ಮುಡಿಯಲ್ಲಿ ಬಂದಂತ ರೆವಿನ್ಯೂನಲ್ಲಿ ನಾವು 150 ಫ್ಯಾಮಿಲಿಗೆ ಅದರಲ್ಲಿ ನಾವು ಡಿವೈಡ್ ಮಾಡಿ
ಕೂದಲ
ಎಂಜಾಯ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ. Now, in the year 1960, my lords, the temple want to ನಮಗೆ ಸರ್ಕಾರದಿಂದನೇ ಒಂದು ಪ್ರಿಮಿಸಸ್ ಪ್ರೊವೈಡ್ ಮಾಡಿ ಆ ಪ್ರಿಮಿಸಸ್ ನಲ್ಲಿ ನಾವೆಲ್ಲಾನು ನಮ್ದೇ ಆದಂತ ಕಾಸ್ಟ್ ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಬಿಲ್ಡಿಂಗ್ ನಾವು ಎಲ್ಲಾನು ಮೈಂಟೈನ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀವಿ. ಅದನ್ನು ಸಹ in the year 1960s, my lords, the temple want to build its own ಅಂದ್ರೆ its own premises. So we have obstructed it. On the Sandarbhadalli, they have filed a suit for declaration that these barbers are not, they cannot restrict us construct the Budikai. Then after filing of our legal statement, they have withdrawn. That's it. They have abandoned their rights. Subsequently, my lordship, in the year 1970s, 68 order, 1970 order,
has the rights, absolute rights.
ಏನ್ ರೈಟ್?
ಮುಡಿ ತೆಗೆಯೋ ಹಕ್ಕು ಮತ್ತೆ ದೇವಸ್ಥಾನ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಕಟ್ಟಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಇದು ಅಬ್ಸಲ್ಯೂಟ್ ರೈಟ್ ಫ್ರಮ್ ಟೈಮ್ ಇವ್ರು ಮಾಡ್ಕೊಂಡು ಬಂದಿರೋದ್ರಿಂದ the temple cannot rebuild the its separate ಮುಡಿ ಕಟ್ಟಿಸ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ.
What is the right of this ಸಂಘ? ಈ ಸಂಘ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಯಾವಾಗ?
ಸಂಘ ಅದು ಬ್ರೇಕ್ ಆಗಿ ಇದಾಗಿ ಬರ್ತಾರೆ.
ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಯಾವಾಗ?
It is in the year 1960s ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. ಮತ್ತೆ ಫಸ್ಟ್ ಟೈಮ್
ರೈಟ್ ಜೊತೆ ಹಾಕ್ಬೇಕಲ್ಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್. You have to file a registration certificate.
That's called now.
No. ಅಡ್ಮಿಷನ್ ಮುಂಚೆನೆ ಎಂಟ್ರಿ ಮಾಡೋರು ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಏನಂದ್ರೆ ಅವ್ರಿಗೆ ರೈಟ್ ಆಫ್ ಮುಡಿ ಇದೆಯಂತೆ, ರೈಟ್ ಟು ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆಲ್ಸೋ. ಇಟ್ ಶುಡ್ ಗೋ ಟು ದಿ ಟೆಂಪಲ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನ್ ತಿರುಪತಿ ಟೆಂಪಲ್ ಇಟ್ಸ್ 464 crores. ನಮ್ದ್ರಲ್ಲಿ 1.8 crores ಬರುತ್ತೆ. ಅದು ಬಾರ್ಬರ್ಸ್ಗೆ ಹೋಗುತ್ತಂತೆ. ಮುಡಿ ಶುಡ್ ಗೋ ಟು ದಿ deity. Deity should get it ಮುಡಿ, ದಿ ರೈಟ್ಸ್ ಆಫ್ ಮುಡಿ. ಇವರು ಒಂದೊಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದಕ್ಕೆ ನಾವು 50 rupees ಕೊಡ್ತೀವಿ, ಪ್ಲಸ್ 10 rupees ಕೊಡ್ತೀವಿ ಖರ್ಚಿಗೆ. ಇದಕ್ಕೆ ಬ್ಲೇಡ್ ಅದಕ್ಕೆಲ್ಲ 10 rupees ಕೊಡ್ತೀವಿ.
10 rupees ಕಟ್ ಮಾಡಿ ಬ್ಲೇಡ್ ಚೇಂಜ್ ಮಾಡೋದಿಲ್ಲ ಅವರು.
ಯಾವುದು ಅದನ್ನ ಮಾಡೋಣ, ಅದನ್ನ ಖಂಡಿತ ಮಾಡೋಣ. ನನಗೆ ರೈಟೇ ಇಲ್ಲ, ಈಗ ಒಳಗೆ ಹೋಗಕ್ಕೆ ರೈಟ್ ಇಲ್ಲ. ಇವರು ಒಂದ್ ಕಡೆ ಟಾರ್ಚರ್ ಮಾಡ್ತಾರೆ. ಟಾರ್ಚರ್ ಮಾಡಿದ್ದನ್ನ ಅವ್ರ ಹೇರ್ ತೋರಿಸ್ತಾರೆ ಅಷ್ಟೇ. No, it's not correct.
That is the most unfortunate things happened. ನಾನೇ ಪರ್ಸನಲ್ ಆಗಿ ಹೋಗಿ ನಾನೇ ಒಂದು 4-5 ಸಿಟಿಂಗ್ ನಾನೇ ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿ ಎಲ್ಲ ಮಾಡಿದ್ವಿ.
ಬಟ್ ಮುಡಿ ನಿಮ್ಗೆ ಹೆಂಗ್ರಿ ಬರುತ್ತೆ? ಮುಡಿ ಹೆಂಗ್ ಬರುತ್ತೆ? It goes to it's a temple property. You offer the mudi to the god. So how can you take it away?
This is the way. I respect the service of the Lord. No doubt, Maharaj. The mudi will be given to the temple. ಇಲ್ಲಿ ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ಮುಡಿನ ಮೈಲಿಗೆ ಅಂತ ನಮ್ಮ ಹತ್ರ ಬಿಟ್ಬಿಟ್ಟು ಹೋಗ್ತಾರ ಹೊರತು ಡಿವೋಟೀಸ್ nobody will take.
ಯಾರು ಕೂದು ತಗೊಂಡು ದೇವ್ರ ಮೇಲೆ ಹಾಕಲ್ಲ.
ದೇವ್ರ ಮೇಲೆ ಹಾಕೋದಲ್ಲ, ಆ ತರದ ಪಾಪಗಳು ಬೇಡ. ನಾನು ಹೇಳೋದು that is what I am seeking for hereditary rights. My
ಇಲ್ಲ ಮುಡಿ ತಗೊಳ್ಳಿ, ಇಲ್ಲ ಮುಡಿ ತಲೆ ಟಾನ್ಸರ್ ಮಾಡೋದಕ್ಕೆ ಚಾರ್ಜ್ ತಗೊಳ್ಳಿ. You cannot get the ಮುಡಿ and there is also the charge.
ನಾನು ಅದನ್ನೇ ಸೆಟಲ್ ಮಾಡಿದ್ದೆ. ಬಟ್ ಹಾಗೇನು DC is ready to sit. Temple is ready to accept our offer.
This 50 rupees is given for tonsuring by the temple.
Tonsuring by the temple. And 10 rupees for expenses.
60 rupees per person.
Per person. ದಿನಕ್ಕೆ ಆವರೇಜ್ ಒಬ್ಬರಿಗೆ 50 ಟಾನ್ಸರಿಂಗ್ ಬರುತ್ತೆ. ಮಿನಿಮಮ್ ಅದು.
Not for the plaintiffs.
When do you want to argue? You please pick a date of your choice before 31st. List on 29th as desired by the Learned Council for the appellate. In the meanwhile, office is directed to secure the records of the trial court telephonic.
For specific performance, the land is 49 for survey number 49.2, measuring 28.5 sale consideration was 4,50,000 and 1,50,000 was paid as an advance. That's why kindly turn to page. The ready and willingness is not true. That's why kindly turn to page 61. The trial court what ends is that not issuance of notice itself is sufficient to hold that the plaintiffs are ready.
What?
That's page 63, not sorry. Page 63, not from the top there are 4 lines. There is no reason why the difference left over The non-issuance of reply of the notice 653 by defendants amounts to a revision on their part. There is no reason to disbelieve the contents of exhibit legal order. Thus, issue of legal notice by the plaintiff, exhibit 3 and oral evidence of 1 to 4 clearly proves that the ready and willingness of the plaintiff to perform their part of the contract as required in the section 16C of the specific fact. Therefore, by the conduct of the plaintiff, it appears that they were always ready and willing to perform their part of the contract. Hence, there is no hesitation of this court.
What is the material to show that they are willing?
But then, only notice is issued that they are willing. Readiness, but they are not. Know that they were having the balance consideration amount. Even the appellate court also not concurrently holds that not at page 34. Page 34 please not.
ಆಯ್ತು ಅವ್ರಿಗೆ ಎಷ್ಟು ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
Give your lordship's discretion.
ಇಷ್ಟಿದೆ ಜಮೀನ್ ಬೆಲೆ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ?
ಅದರಲ್ಲಿ even your lordship can see adjacent properties also sold to me.
ಯಾವುದು?
ಇದ್ರ ಪಕ್ಕದ ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ that we have produced the sale deeds.
But what is there to show that you are ready and willing?
But the only notice that was referred in the judgment. But your lordship can see he has purchased the even adjacent properties, he has having a money.
ಅವ್ರಿಗೆ ಗೊತ್ತು, ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗಬೇಕು? ಜಡ್ಜಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗಬೇಕು? ಜಡ್ಜ್ ಗೊತ್ತಾಗಬೇಕು ಅಂತ ದಾಖಲೆ ತೋರಿಸ್ಬೇಕು. What is there to show? Exhibit P1 is agreement of sale, P2 is RTC, P3 is legal notice.
Yes.
P4 is acknowledgements, P5 is RPAD cover, P5A is copy of the notice, P6 is copy of sale deed dated 14/8/2006, P7 is copy of sale deed dated 14/8/2006, P8 is judgment and decree copy through PW4, P9 is a plain copy. ಯಾವ್ದು plain copy ಯಾವ್ದು?
There was a suit for partition. What is the
sisters?
Because after filing of this suit, your lordship will see that sisters have filed a suit for partition.
ಅದೇನಾಯ್ತು?
ಅದರಲ್ಲಿ ಇವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತಾರೆ. Yes, we have already executed agreement of sale in favor of this person. That is there is an admission.
Yes, there is settlement ಇದೆಯಾ? ಚಾನ್ಸಸ್ ಇದೆಯಾ?
ನಾನು ಕೇಳ್ತೀನಿ ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು
not is anything to show your willingness.
ಅಲ್ಲ ಅದನ್ನು ಒಂದು ಡೇಟ್ ಕೊಡಿ, ನಾನು ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು if they have any settlement or not.
What is the property value ಎಷ್ಟಿದೆ?
ಪ್ರಾಪರ್ಟಿ 20 ಗುಂಟೆ.
ಅಲ್ಲ ಬೆಂಗಳೂರು ಕೋಲಾರ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ತಿಪ್ಸಂದ್ರ ಅದೇ ಕೋಲಾರ ಪಕ್ಕದಲ್ಲ ಇದು ಹೊರಗಡೆ ಬರುತ್ತದು.
ತಿಪ್ಪಸಂದ್ರ ವಿಲೇಜ್ ಕಸ್ಬಾ ಹೋಬಳಿ ಕೋಲಾರ ತಾಲೂಕು.
It should be more than a crore.
ರೋಡ್ಗಿಲ್ಲ.
50 lakhs.
50 lakhs in 2007.
ಅಲ್ಲ 20 ಗುಂಟೆ. ಅದು ಪಕ್ಕದಲ್ಲಿರೋದು ಮಾರಿರೋದು 1,87,000.
45 ಮಿಸ್ಟರ್. ಪಿಂಕ್ ಪೇಜ್ 45 ಬಂದು ನೀವೇ ಹೇಳಿರೋದು 2007ನೇ ಇಸ್ವಿನಲ್ಲಿ 50 ಲಕ್ಷ ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಿ. 2007 50 ಲಕ್ಷ. We are in 2022, 15 years back. Yes. It should be about 1.5 crores.
ಅಲ್ಲ ಬೌಂಡ್ರೀಸ್ ನೋಡಿದ್ರು ಕೂಡ there is no road on the either the side.
ಕರೆಕ್ಟ್. 2007ನೇ ಇಸ್ವಿಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ 50 ಲಕ್ಷ ಅಂತ. That is the case, then today it should be about not less than 1.5 crores.
ಹೌದು.
Settlement ಏನು ಅಂತ ಹೇಳಿ. How much you want more or how much more will you give? Yes. 5 ಲಕ್ಷ ಅಲ್ಲ. Don't throw peanuts. What you should throw. Correct, Mr. You should offer something by which the defendant plaintiffs bite the bullet. ಸುಮ್ಮನೆ 5 ಲಕ್ಷ 10 ಲಕ್ಷ ಅಂದ್ರೆ ಗೋತಿನ ನೋಡೋದು. Not 10 lakhs. Come up with some reasonable amount. ಇಲ್ಲ ಅರ್ಧ ಜಮೀನ್ ಬಿಡ್ತೀರಾ ಹೇಳಿ. ಅರ್ಧ ಜಮೀನ್ ಬಿಟ್ಕೊಡಿ, ನಿಮ್ಗೆ ಅರ್ಧ ಅವ್ರಿಗೆ ಅರ್ಧ. Come up with something reasonable. 2 ಸೂಟ್ ಡಿಕ್ರಿ ಆಗಿದೆ. 2 concurrent finding. Please think what is your position. The position yochane ಮಾಡಿ. ಇಲ್ಲ, you want to go to the Supreme Court, you can take it.
Everyone who got examined as a witness is the person who is the agreement holder. Meanwhile, in the during the course of the cross examination, he passed away. So even the agreement is also there are some contradictions in the depositions of CW2.
No, but you look at this, Mr. He's purchased 2 properties in 2006.
Yes.
So he's got the capacity to purchase. Correct. And you have permitted the execution of the agreement. He's got the capacity to purchase. He has purchased the adjacent land. What more is required in a suit for specific performance? Come up with a reasonable solution. You can't escape. Don't leave it to my discretion. If you ನಾನು ಬೇಕಾದ್ರೆ ಡಿಸ್ಕಷನ್ ಕೊಡಿ, ನಾನು ಇವಾಗ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀನಿ. Give me the discussion, I'll dismiss it right away. ಈಗಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ, ಹೇಳಿ. According to you, it was 50 lakhs in 2007. According to you, 2007 ಇಸ್ವಿನಲ್ಲಿ. So it should be easily about 1.5 crore today. Yes, ಕೊಡ್ತೀರಿ. Yes, 25 lakhs.
I will get the instruction. Next week ಅಲ್ಲಿ ಯಾವತ್ತಾದ್ರೂ ಹಾಕೊಳ್ಳಿ, 28, 29, 30.
ಹೇಳಿ ಸರ್, ಯಾವತ್ತು ಅಂತ ಹೇಳಿ.
30th ಮಲ.
The learned counsel for the appellant submits that his client is willing to pay 25 lakhs as compensation in lieu of specific performance. The learned senior counsel appearing for the respondent seek time to get instructions. List on when do you want it?
30th, my lord.
List on 30th. Please wait, Mr. 30th. ಅದರೊಳಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಬೇಡಿ.
ಅಲ್ಲ, ನಾನು ಕರೆಸ್ಕೊಳ್ತೀನಿ, ನಾಳೆನೇ ಕರೆಸ್ಕೊಳ್ತೀನಿ.
ಅಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಬೇಡಿ ಎಂದು ಸೇಲ್ ಡಿಡ್ ಏನೋ ಡ್ರಾಫ್ಟ್.
Execution is there. Execution already defined. Whether it is executed or not, I don't know. But you will
hearing till the next date of hearing, all further proceedings in execution petition number 16 bar 2020 on the file of the state. List on 30th.
Please.
Apparently, the defendant before the trial court sued for partition by the sister. The sister born in the year 1955. And victim number 2 or 3, trial court dismissed the suit. On the ground that they have not proved that the suicidal properties are not, they have not proved that the suicidal properties are joint family. And one more thing is the first appellate court has declared the suit in respect of portion of item number 1 of the property. And there is a case pending before the land tribunal for grant of the item number 1 of.
Please read that portion. There are 25 bunny.
Because if the above pleadings, evidence and other materials placed on record, the trial court was called upon whether plaintiff was successful in proving their case. However, the trial court has not accepted these of the plaintiff and dismissed the suit. Plaintiffs are now before the court. Let us once again reassess the pleadings and evidence of the parties. As stated earlier, the plaintiffs relied on evidence of PW1 2, contents of PW1 to 10. Defendant has relied on evidence of PW1 and contents of PW exhibit D1 and D2 D5. On proposal of the para 15 of the press, defendant has admitted regarding existence of 1 acre 28 acres of land in serial number 184 Senapati legal, that is suit item number 1. Even in the very same para, the defendant admitted regarding existence of suit item number 2. Old Kata number 633 and new Kata number 799. Even it is gathered from the written statement and also from the said properties are answered with the trial court records also reflected the record of rights in respect of land survey number 183, 1 acre 28 units are available. The said properties appeared in the name of Panchammana Devoda, and later it appeared in the name of the defendant. Well, the document produced by the plaintiff along with the number 213, that is original partition is dated 1950, clearly shows that 1 acre 28 units of land was allotted to the seat of Panchammana Devoda in the Karnataka. Similarly, the above referred documents show that the suit number 2 recorded to the seat of Panchammana Devoda and still is standing in it. Even the learned advocate for the defendant classic of PWM suggested suit item number 1 to the answer to purpose. The suggestion can be considered as admission in your facts and pleadings of the case. Even BWM in the classic admitted that the second item of being granted, there is no partition between the family members of the defendant have stated in his statement as well as in the oral. The plaintiff number 2 has been given gold, cash, and land at the time of her marriage towards her share. The defendant has laid on the contents of the which are the third copy of the dated 21/2/1976 and same date dated 16/4/2007. On perusal of the given, it reflected that the defendant and his father paid 6 acres of land in survey number 187/3/2020, number 2 towards her. There are no words in the said document to believe that this land is gifted towards a share, the share of the plaintiff number 2 in the primary properties. Moreover, Resolution D2 is the sale deed executed by the plaintiff number 2 in respect of property acquired by the except producing PW given and P2. There is no sufficient and believable evidence to believe that there is already partition in the family and that
But ಇದು ಅರಿಶಿನ ಕುಂಕುಮ ಕೊಟ್ಟಿದ್ದು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ?
Same item number, some other property.
187/3.
This is 183/1. Moreover, she has born, plaintiff number 2 was born in the year 1950 as per the and before coming to Hindu Succession Act 1956. On the same ground, the trial court has dismissed the suit of case number 52. And also the plaintiff number 1 is a mother. She is getting monthly maintenance from the defendant. She has filed a criminal proceedings under domestic violence act, and she is getting a monthly maintenance for her life. And they have also not produced any document to show that the land is already granted in favor of the Manchaman Devoda or the defendant. They admit that in the fact of the defendant number, the plaintiff number 2, that's PW2 admits that case number 50 of the trial court. It is further elicited that Tavasutul survey number ವಿಸ್ತೀರ್ಣ ಆಗೋ ಚೆಕ್ಕು ಬಂದಿಯನ್ನು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ನಿಂದ ಸೇನಾಪತಿಯಲ್ಲಿ ಗ್ರಾಮದ ಜಮೀನು ನಮಗೆ ಮಂಜೂರಾಗಿದೆ ಎನ್ನುವ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. So suit is still pending regarding the item number 1 of the property. Started granted in favor of the defendant or in favor of the father of the plaintiff. Further, she has already given property.
2 ಗುಂಟೆ ತಾನೆ
6 acres. 6 acres she has already given. And with respect to item number 3 and 4, the 44 rented those properties are self-acquired properties of the defendant number 1. This is the suicidal property item. Item number 2 is the house property where the defendant number 1 is listed. Item number 56 of the trial court judgment clearly holds that for the sake of argument, the suicidal property or joint family property as contended by the plaintiff is not a co-partner along with plaintiff number 1 and defendant number 1 because the
No, but the suit is filed after 2005. Suit is filed after 2000. Section 6 OD.
2001.
So it is after 2005. Section 6 OD once.
donation of interest in co-personal property. On and from the commencement of the Hindu succession,
ನಿಧಾನಕ್ಕೆ ಓದಿ ಅರ್ಥ ಮಾಡಿ.
the giant Hindu family government Mitakshara, the daughter of a co-partner cell by birth became a co-partner in her own right in the same manner as the son.
So therefore, date of birth illiದೆ.
That is coming data from 1956. That time she was not born.
But you please look at 2005
Before
Act.
that she was born.
2005 Act ಅಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
Of the same rights in the co-partner as well. How had she had in a son?
ವಿನೀತಾ ಶರ್ಮಾ ಜಜ್ಮೆಂಟ್ ನೋಡಿದೀರಾ? ಹ್ಯಾವ್ ಯು ಗಾನ್ ಥ್ರೂ ದಟ್? ಓದಿದೀರಾ? ಕಂಪ್ಲೀಟ್
ಅದರಲ್ಲಿ
ಕಂಪ್ಲೀಟ್ ಓದಿದೀರಾ? ಧೈರ್ಯವಾಗಿ ಹೇಳ್ರಿ, ಓದಿದಿರಾ ಇಲ್ಲ?
regarding application of act to the daughters born before the 1950s.
ಇಲ್ಲಿದೆ.
It's not specifically stated.
Date of birth ತೋರಿಸಿ ಇಲ್ಲಿದೆ.
It's not specifically stated.
But on what basis are you saying? On what basis you are saying? Date of birth.
And whatever the properties.
Act came in 2005. Suit is filed after 2005. How do you say that she was born before 1956 and therefore she is not entitled for a share as a co-partner?
There was no act on the date of birth.
Date of birth relevance ilri. ಅದಕ್ಕೆ ಓದಿದ್ವಿ. ವಿನೀತಾ ಶರ್ಮಾ ಓದಿ ಫುಲ್ ಮೇಲಿಂದ ಕೆಳವರೆಗೂ ಓದ್ಬೇಕು. ಪಾಸು ಸಾರಿ ಸರ್, ಓದಿ, ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ, ಓದ್ಕೊಂಬನ್ನಿ. ಅದು ಕೊಡಿ, ಪ್ಲೀಸ್ ಸಿಟ್ ಇನ್ ರೀಡ್ ದ ಜಜ್ಮೆಂಟ್. ಎಲ್ಲ ಹೈಲೈಟ್ಸ್ ನೋಡ್ತೀರಾ ಅಷ್ಟೇ, ಯಾರು ಫುಲ್ ಓದೋದಿಲ್ಲ, ಹೈಲೈಟ್ಸ್ ಮಾತ್ರ ನೋಡೋದು ಅಷ್ಟೇ. ಪ್ಲೀಸ್ ರೀಡ್ ದಿ ಎಂಟೈರ್ ಜಜ್ಮೆಂಟ್. ಪಾಸು ಏನಂತ this was listed yesterday. ಏನು ಹೇಳ್ತೀವಿ? As on date 6 lakhs. 6 lakhs. What is the measurement? ಎಲ್ಲಿರೋದು? Which area? No, I will not fix. You people will have to work out.
Yes, yes. And
The General Counsel for the appellant submits after obtaining instructions from the appellants that the appellants are willing to buy out the suit property based on the present market value or take reasonable time to vacate the premises. The General Counsel for the appellants on instructions submits on instructions that the appellants are willing to pay up the market value of the suit property. So alternatively, he submitted that the appellants may also consider vacating the suit property if reasonable time is granted. Stopping that view of the matter, issue notice to the respondent. Interim stay. The parties are directed to maintain status quo in respect to the property in question till the next date of hearing. List on When do you want it? 4th April. It's on 4th April. Not necessary. Oh, one here, no. No, not necessary. Let them come and do. ನಿಮಿಷ ಅದು ಕರೀರಿ ಅವ್ರು ಬರಕ್ಕೆ ಹೇಳಿದ್ರು 1655. Who are the plaintiff and defendant? How are they related? Yes. Yes. Got it. Sorry. So Sunday stable. Yes, please.
95 days for declaration and motion. But later melodies, the appellant appeared and testing. Thereafter melodies, issue melodies.
What is your claim insofar as the suit property is concerned?
Property concern melodies, I have not produced any documents to the trial court. But melodies in the year 1978, appellant have got a awarded cheap melodies.
So how much cost will you grant? How much cost will you pay? The trial court case Narsila. You not conducted the case before the first appellate court also.
And also the dependent also.
From 2014 till 2018, you are not well. Great. Suit is filed in 2014, decreed in 2018. So now of course which are
2 years.
2 years, sir. And he is still alive. Both of them are alive. This how much cost will it? Yeah, ನೀವು ಹೇಳಿದ್ರೆ notice issue ಮಾಡ್ತೀವಿ ಇಲ್ಲಾಂದ್ರೆ no. Star in multiples of thousands, not 2000. 2000 ಇದಕ್ಕೆ ಡಿಲೇಗೆ ಆಗ್ತಾ ಇದೀವಿ. ನೀವು 2000 ರೂಪಾಯಿಗೆ ನೀವು ಕಂಡಕ್ಟ್ ಮಾಡ್ತೀರಾ ಅಪೀಲ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ. Yes. 25,000. Is willing to pay 25,000 rupees cost and issue notice. 25,000 rupees. Who will conduct a iವಾಗ ತಿರ್ಗಾ ವಾಪಸ್ ಹೋಗುತ್ತೆ ಸೂಟ್ ವಾಪಸ್ ಹೋದ್ರೆ ತಿರ್ಗಾ ಲಾಯರ್ ನೋಡ್ಬಿಟ್ಟು ತಿರ್ಗಾ ಇಟ್ಬಿಟ್ಟು ತಿರ್ಗಾ ನಡೆಸಬೇಕು ಕೇಸು ಮತ್ತೆ The learned counsel for the appellant submits that the appellant did not have an opportunity to conduct the suit, to contest the suit before the trial court, resulting in an ex parte decree. Full stop. He submitted that the appeal filed by him before the first appellate court also was dismissed. So the learned counsel submitted on instructions that his client is willing to pay the sum of rupees 25,000 as cost to compensate the plaintiff. So rupees 25,000. compensate the plaintiff for the compensate the plaintiff if the impugned judgment and decree passed by the trial court is set aside, and if the defendant is permitted granted an opportunity to contest the suit on merits. So in view of the aforesaid submission, issue notice to the defendant. Parties are directed to maintain status quo. List on 4th April.
I appear for the appellant's, Your Lordship.
Yes, please.
Serial number 59, Your Lordship.
Yes.
Lord, this is appeal on concurrent finding by the defendants. Lord, suit is for declaration and injunction. Lord, the claim of the plaintiffs, my lord, was based on a will, my lord, which was subsequently registered, my lord. And my lord, on the other context, my lord, the interference was there by the defendants, and accordingly, they sought for declaration and also for injunction. Lord, the claim of the defendants before the trial court, my lord, was that Lord, the suit admittedly in the presence of a release deed, which was executed, my lord, by Maranna, Lord, who is, my lord, the husband of first defendant, the father of, my lord, defendant number 2. Lord, he cannot claim, my lord, they are not entitled for the declaration relief. Lord, and also on the ground that, my lord, plaintiff number 3, my lord, Parvatama, alias Akamarama, my lord, there is a denial to the relationship between the Maranna as well as Parvatama, my lord. And also on the ground that, my lord, admittedly the defendants are in possession, unless a relief for, my lord, recovery of possession, may are sued for.
What is a suit property?
Suit property, my lord, it's a landed property, my lord.
There's a question of possession.
My lord, it is exclusively in the possession of the plaintiff, defendants.
You keep it in your pocket, is it? Agricultural land.
It is not the question. It is not the question of, my lord, seeking the, my lord, consequential relief of.
No, but how do you remain in possession of an agricultural land?
My lord,
is there any house?
My lord, Lord, on the basis of a registered release deed, my lord, I have taken the possession of the property.
From whom?
By Maranna, the husband of the plaintiff number 1 and father of defendant number 2.
Yes.
My lord, by virtue of, my lord, the presence of the release deed, my lord, which is dated 25 to 1976. Lord, the will. Please, your lord.
25 to 1976.
76. Lord, the alleged will, my lord, was executed according to the plaintiffs was on 23/9/1981.
Yes.
My lord, my humble submission would be, my lord, in the presence of a registered deed, until and unless there is a challenge to that effect, my lord, the suit for declaration holding that the plaintiffs got the property under the registered will, my lord, itself, my lord, carries no value. Lord, when my lord, the evidence was let in, Lord, certain facts were also, my lord, brought from the witnesses, my lord, wherein the defendants are in exclusive possession of the property. Lord, insofar as, my lord,
Maranna does not execute a release deed in your favor.
Lord, it was the plaintiff number 1 and 2 who had executed the release deed.
Why are you misleading?
My lord, my submission would be, my lord, sorry, my lord, it was by plaintiff number 1 and 2.
You are saying that it was released in your favor.
Sorry, my lord. My apologies. My lord, now in the presence of the registered release deed, until and unless there is a question, my lord, challenging that particular release deed, my lord, the suit.
No. Plaintiff number 1 and 2 give up their rights
under the release deed.
In favor of Maraya.
Please, my lord.
Maranna thereafter executed a will.
Please, my lord.
Will is held to be proved.
My lord.
Trial court says it will is proved.
Please, my lord.
First appellate court says will is proved.
Please, my lord.
What is your case?
My lord, my submission would be, my lord, there are suspicious circumstances where, my lord,
what are the suspicious circumstances?
My lord, will was never seen the light of the day till 2009, my lord. Though it was executed on 23/9/1981.
Maranna died.
My lord, Maranna died, my lord, in the year 1990. Lord, the will was never pressed into service, my lord, till 2009. That is the day on which the suit was filed.
Yes.
My lord, the second suspicious circumstances, my lord, on the basis of the will, with regard to the will is, my lord, Lord, in the will, my lord, for the first time, my lord, the name of a third plaintiff that has been shown as the daughter of my lord Marana. Lord, if really that would be the case, my lord, my stand before the trial court was that, Lord, as on the date of my lord filing of the suit, the age of Marana would have been somewhere around, my lord, the age of the plaintiff number 3 would have been somewhere around 19 years. But the age that has been given as on the filing of the date of my lord, plaintiff number 3 age may kindly be looked into, my lord. She has been shown, my lord, as if she is aged
25 years.
25 years. Lord, even that amounts, my lord, in the presence, my lord, 1981. If really, my lord, she was aged around 4 years, according to, my lord, the recitals of the will, she was somewhere around 4 years. It is highly impossible to believe the version of the plaintiffs that the will, in the presence of, my lord, the plaintiff number 1 to 3.
What are the other properties you have?
My lord, the other properties, my lord, is my lord, which I have acquired, my lord, much earlier to 1976, my lord.
Which are those properties?
Lord, those properties details, my lord, I have mentioned in the return statement, which I got, my lord, under the partition. Lord,
Well, this will is not only executed in favor of the plaintiffs 1 and 2, but also in favor of the defendant number 1.
No, my lord.
Half share is given to him. Half share is given to plaintiffs, 3 persons.
Yes.
He is a beneficiary under the will.
Yes.
My lord, the other aspect, my lord, is that the other suspicious circumstances, my lord, surrounding the will was, my lord, in order to execute, my lord, that will, if because the very recitals which has been taken in the will, my lord, it is the property, my lord, belonging to, my lord, said Maraya, that is Marana, who had got under the partition. If really that would be the case, my lord, the suit ought to have been for the relief of partition, my lord, because admittedly, my lord, when the very release deed was there depicting the fact that, my lord, disclosing the fact that the right has already been transferred in favor of the present, my lord, defendants. Lord, the question of now again going back, saying that he has already become the owner of the property cannot be accepted. And the other parameter, my lord, is with regard to section 50 of the Evidence Act. Lord, when I have taken a stand with regard to the relationship of plaintiff number 3, it is the duty, my lord, cashed upon the plaintiffs to lead evidence on that point. There
The
are
suit is not for partition, Mr. Suit is for declaration.
Declaration, my lord. It should
So
have been.
therefore, where's the question of proving the relationship? There's a will.
My lord, my submission would be, instead of filing the declaration suit, they ought to have filed a partition suit questioning the validity of this particular thing. In the presence of will, they cannot claim, my lord, a declaratory relief. My lord, my other submission would be, my lord, may I make one submission, my lord? My lord, if your lordship permits, my lord, by 2:30, I will place the, my lord, the rulings on the point, my lord, where section 50 has to be, my lord, looked into.
Now there is a will executed by Marana.
Please, my lord.
Even if we say that the relationship is not proved.
Please, my lord.
Marana has executed a will in favor of the plaintiffs 1 and 2 and defendant number 1. If the will is proved, then the property will have to go as per the will.
My lord, my submission would be, my lord, admittedly, my lord, the according to my lord Marana, it's a property which has been allocated under the partition.
Yes.
My lord, if that would be the,
how much would Marana get in that property?
My lord, he has already released, my lord, in the sense the plaintiff number 1 and 2, they have already released. I pray on
the plaintiff number 1 and 2 have already released and they one relationship prove aita.
Number 3 matra nan keltaradu Swami, only with regard to
will is in only in respect of plaintiff number 1 and 2.
No, my lord, even 3, even 3, my lord, even 3.
Alla 3 will illal bardidare.
3 ಜನಕ್ಕೂ ಸೇರಿಸಿ ಬರ್ಸಿದ್ದಾರೆ ಸ್ವಾಮಿ ಬಿಲ್. My lord, my submission would be, I pray your lordship kindly come to, my lord, para number 38.
All right, Mr. Dev, this judgment is, I think they have done justice to both the parties.
My lord, my submission, my lord, my submission, page number 40, my lord, para number 33 may kindly be looked into. My lord, without there being the challenge, my lord, with regard to, my lord, registered release deed, my lord, the court has given an opinion, my lord.
Release deed, yes, they accept. Release deed ಬರ್ಕೊಡೋದ್ರಿಂದ ಅರ್ಥ ಏನಾಯ್ತು? The entire property went to Maranna.
No, my lord. Release was executed in favor of defendant, my lord, not with regard to, my lord. I pray your lord.
ಯಾರಿಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದು?
ಇವರಿಗೆ ನಾರಾಯಣನ್ ಬರ್ಕೊಟ್ಟು
ಇಲ್ಲಿದೆ.
ಅದು ಎಕ್ಸಿಬಿಟ್ ಆಗಿ ಮಾರ್ಕ್ ಆಗಿ.
Where is that? Where is the finding regarding release deed?
ಯಾವ್ದು?
Release deed ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ. Plaintiff number 1 and 2.
Number 1 and 2 in favor of Maharashtra.
Why are you misleading, Mr.?
My lord, para number 33 may kindly be looked into.
And he dies subsequently.
Please come to page 15, in page 50 of the trial court judgment.
Lord, the defendant number 1 has denied the entire case of the plaintiff and admitted that the relationship between plaintiff number 1 and 2 and father of first defendant, and denied the relationship of plaintiff number 3 with the father of first defendant. The plaintiff number 1 and 2 have executed registered release deed, my lord, dated 25 to 1976, favor of the father of the first defendant, Maraya. After executing the release deed dated 25 to 1976, the plaintiff number 1 and 2 have left the family of the first defendant and they are wandering village to village.
Yes, where's the question of executing in favor of the defendant?
My lord, my submission is, my lord, issue number 4, my lord, was framed. 5 was framed, my lord, with regard to the release deed, registered release deed. My lord, the opinion of the trial court, my lord, on this issue, my lord, is available at page number 55, where does not survive for consideration.
Yes.
My lord, I pray your lordship kindly come to page number 40, my lord, para number 33 of the first appellate court judgment, my lord.
Yes.
My lord, the first appellate court, my lord, has given its finding, my lord, on this particular factor, my lord. No doubt, the exhibit D1 shows that the plaintiff number 1 on our behalf and on behalf of minor plaintiff number 2 released right by receiving rupees 2,200 in favor of Maranna. At the time of execution of the said registered release deed, they have no right over the property of Maranna. For the sake of arguments, if it is considered that they had right over the property, the said execution of release deed does not bar Maranna from executing the will. Hence, the said Maranna had every right to execute the will in favor of any person, even in favor of the plaintiffs also. The execution of the registered release deed does not take away any right of Maranna to execute the will. Moreover, the execution of the said registered relinquishment deed does not take away the marital relationship of said Maranna and first plaintiff. The exhibit P3, my lord, now by virtue of this finding, my lord, without there being a challenge to the relinquishment deed, my lord, my humble submission.
ಆಯ್ತಪ್ಪ, relinquishment deed ಬರ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ.
Please, my lord.
Even if relinquishment deed is not executed, Maranna has got half share in the property.
My lord,
Maranna and the defendant number 1, ಅವರಿಬ್ರಿಗೆ ಅರ್ಧ ಇದೆಯಾ?
ಅವರಿಬ್ರಿಗೆ ಅರ್ಧ ಇದ್ದದ್ದು, my lord, that has been executed, my lord, by virtue of the, my lord, the release deed. By receiving the...
Don't mislead the court.
Sorry,
if you have not read the file, please take adjournment. Don't mislead the court.
Sorry, my lord. May I request for...
Release deed is executed by plaintiff number 1 and 2 in favor of Maranna.
Please, my lord.
Assuming that there is no release deed.
Please, my lord.
Maranna will get half, defendant number 1 will get half.
Please, my lord.
By virtue of the will, Maranna has given away half to plaintiff number 1, 2 and 3 and the other half to the defendant number 1. What is wrong in that?
My lord, may I make one submission, my lord? But it may be called tomorrow, my lord. I will...
Sorry, mister. No, tomorrow.
ಅಲ್ಲ ಇಲ್ಲಿ ಒಂದು
ಇವತ್ತಿನ ಲಾಟ್ರಿ ಇವತ್ತಿಂದ ಡ್ರಾ.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ ಸ್ವಾಮಿ. I have actually got confusion, my lord, with regard to, my lord, will, because in the will, my lord, it is nowhere mentioned, lord, with regard to, my lord, the property allocated to the share of defendant number 1. This is what
Maranna get this property.
Yes. What happened is his plaintiff number 1 is the second one.
Right, how did Maranna get this property?
Yes, purchased it. There is
it his ancestor property?
It is sulfur-pet property.
Is this his ancestor property, mister?
No, my lord. It is a sulfur-pet property of Maranna.
Illiде finding idea.
That he said, Pachapallan said, after the death of Maranna, I have succeeded.
Illi ಹೇಳಿದ್ದಾರೆ self ಕೊಡುತ್ತೆ ಇಲ್ಲಿ.
Some statement alla ಅದೇ content. ಅವರೇ purchase ಮಾಡಿದ್ರು finding.
ಆಯ್ತು ಹೇಳಿ ಸರ್ ಎಲ್ಲಿದೆ ಅಂತ.
Page 52 no.
Page 52. Now what?
Intent no right title whatever good property and other property को मारा यार subsequent will be absolute property.
Our statement होता है इधर.
अरे health of. Evidence collected.
ಆಯ್ತು ವಿಲ್ಲಲ್ಲಿ ಏನಂತ ಬರ್ತಾರೆ ನೋಡಿ ರಿಲೀಸ್ ಡೀಲ್ ಏನಂತ ಬರ್ತಿದ್ದಾರೆ. ವಿಲ್ಲಲ್ಲಿ ಏನಂತ ಬರ್ತಿದ್ದಾರೆ. Yes, Mr. Chandrasekhar.
My lord.
How did Maranna get this property?
My lord, under a partition, my lord, Maranna, my lord, and my lord, his brother, my lord, they divided the properties, my lord.
Where is that partition?
Lord, that has not been produced, my lord.
Then what can be done, Mr.?
My lord, I will place the material, my lord. In the will, there is an entry, my lord. Exhibit P3.
Not be.
72 na to.
Exhibit
D4.
Exhibit?
D4.
What is D4, Mr. Chandrasekhar?
Exhibit D4, my lord, is Lord, exhibit D4, my lord, original sale deed, my lord, which is dated 13/4.
So I can read it from the judgment.
Please, my lord. It is a registered sale deed, my lord, executed by one Srinivas, my lord, in favor of my lord, the family, my lord, the Marana's family.
ಯಾರು Marana's family ಅಂದ್ರೆ ಯಾರು?
ಅವರು ಅವ್ರ ತಮ್ಮ ಇಬ್ರು ಸ್ವಾಮಿ.
ಇಲ್ಲಿ ನೋಡಿ ಯಾರ ಹೆಸರು ಇರೋದು? ಯಾರ ಹೆಸರು? ಓದಕ್ಕಾಗಲ್ವಾ?
ಓದಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ.
Yes. Yes, 230.
Your Lordship, I am appearing for the appellant Lordship. Kindly give an adjournment, Lordship.
Oh, madam. Oh, adjournment.
Personal inconvenience, Lordship.
No, pass over.
Short date, Lordship. Short
Sorry,
date.
madam. Sorry, either you come or I'll dismiss it.
Tomorrow will be. Tomorrow, Lordship.
So tomorrow you can get the certified copy, madam.
Please, Lordship. Tomorrow.
Pass over. Please argue it anytime before 4:30. Yes, sir.
22nd concurrent. Suit is one for declaration of title, one for permanent injunction. In the alternative for possession. The suit properties are two in items, landed properties. Item number 1 and case number 9.
Yes.
Item number 1, case number. Item number 1, certain number 10 for 1. Measuring 1 acre 30. Item number 2.
1 acre 12 gutas.
1 acre 12 gutas. So far as survey number 10 for 1 is concerned, survey code and sketch was prepared in the year 2001. There, the name of the plaintiff appears in the RTC for 1 acre 12 gutas, 1 acre 32 gutas. So they did not interfere with the defendant did not interfere with the possession.
So, but what about the decree granted against you in voice number 26 of 82? ಅದರ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತೀರಾ? voice 26 of 82 ನಲ್ಲಿ ನಿಮ್ಮ ವಿರುದ್ಧ ಒಂದು ಡಿಕ್ರಿ ಆಗುತ್ತೆ. Nagarajaya had filed a suit for declaration injunction. Nagarajaya. He had filed a suit. That is a defendant number 3. He had filed a suit for. Sir, decree ಆಗಿದೆ sir. ನೀವು ಅದೇನು ಚಾಲೆಂಜು ಮಾಡಿಲ್ಲ ಎಂಥದ್ದು ಮಾಡಿಲ್ಲ. Please come to page number 55, ink page 55 ಬನ್ನಿ. ಕೆಳಗಡೆ ಬನ್ನಿ. In the year 1982, third defendant Nagarajaya had filed a suit for declaration permanent injunction in respect of the first item.
First defendant and 9 others. Server number invoice number 26/89. On the file of the municipal court, this is two was declared misdemeanor. Not produced.
Produce Madilla, that is the statement filed. You dispute that? Yes.
Item number 1 is concerned, there is no dispute. I have sought for deletion and lower appellate court has deleted item number 1 of the social. So far as item number 2 is concerned, the total extent in survey number 10 is measuring 12 acres. The father of the plaintiff has purchased 5 acres, 20 gunters. This 5 acres, 20 gunters was divided by the plaintiff and his brother. His brother has sold his share. So far as my share is concerned, I have retained.
There is the finding of the trial.
Finding of the trial court. Item issue number 5 and 5, 6 and 9 they are important. Page number 57. Page number 57. So far as item issue number 5 is concerned, it is at page number 11, para 11. Whether the plaintiff proves his title over the social property and possession and enjoyment of the social property. The relevant portion melody is at page 72. 72. Stated melody.
Yes, please.
On the boundaries mentioned in the schedule to the social properties and also the boundaries mentioned in the exhibit P10, P11, P12 and P8. Exhibit P8. The social properties are not properly identifiable on those proceedings and documents produced by the plaintiff. And the defendant certain admissions made by the plaintiff and defendants. Certain admissions made by the plaintiff even in his class examination sold in favor of Sudhira of the land in number 10. It's clear that there are contradictions in the measurement boundaries in the property which are not there. Nevertheless, the plaintiff to the plaintiff and the defendant in respect of the lands is number 10 of the sale and exhibit PA. The extent of land remain one of the plaintiff and another is less. Less than the property ನಮ್ ಏನ್ ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ವಿ ಅದನ್ನ ಮಾತ್ರ ನನಗೆ ಕೊಟ್ಟು ಸರ್. ನಮ್ಮ ಬ್ರದರ್ ಶೇರ್ ಅವ್ರು ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ನಮ್ದೇನು ಬಡ್ಡಿ ಇಲ್ಲ.
ಶೇರ್ ಅಲ್ಲ ಸರ್, ಈ OS 26 of 82 ನಲ್ಲಿ ಅತ್ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ Yes.
Issue number 5 and 6 and 9 are important.
But what is there to show that you are owner of this property? What is there to show that you are the owner of this property?
Share and exhibit P10.
P10 is not believed by the court, both the courts.
P10 is the property where my father has purchased 5 acres.
Issue notice call for record. Issue notice call for records. Also,
Then has been mentioned.
Office objection raised. The analysis was earlier referred to since the learned counsel for the appellant has stated that the name of appellant number 6 is properly shown or the explanation is accepted. Office objection raised regarding discrepancy in the name of the appellant number 6 is overruled. Is the appeal for final hearing as per seniority. Next. Bharatha. ಹೌದು ಅದನ್ನ ನೀವು ಇದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು ಯಾಕೆ ತೋರಿಸಿದ್ರಿ 2006 ಆದ್ಮೇಲೆ ತಕ್ಷಣ 2007 ಬರುತ್ತೆ ಕ್ಯಾನ್ ಫಿಕ್ಸ್ ಎ ಡೇಟ್ ಕರೆಕ್ಟ್ ಬಟ್ ಏನ್ ಮಾಡೋದು 2006 ಮುಗಿಸ್ಬೇಕಲ್ಲ ಫಸ್ಟ್ ಮುಗಿಸೋಣ ಅದನ್ನ ನೋ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಸ್ ಪರ್ ಸೀನಿಯಾರಿಟಿ ಬರುತ್ತೆ ಸರ್ 2006 and 2007 ತಗೊಳ್ತಾ ಇದೀವಿ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ Yes. Number
38 minute.
Yes, please.
Minute for the first respondent minute. The Shandikappa sought passover minute. Your lordship directed to hear the matter. Your lordship will take it up at 2:30 minutes. Minute in view of the order, the two grounds minute.
38 passover. Yes, next.
Copy of the orders 38.
Yes, always please come at 2:30. Yes, Mr. Vishwanath R. Hegde. Vishwanath R. Hegde. Passover 2:30. Mr. Raghupati T.N. 2:30. Passover. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್
ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರೆ
ಸರ್ ಅವ್ರನ್ನ ಯಾಕ್ರಿ ಕೇಳ್ತೀರಾ FDP ಲೋಗ ಒಂದು ಪಿಟಿಷನ್ ಹಾಕ್ರಿ ವಾಟ್ ಇಸ್ ದಿಸ್ ಮಿಸ್ಟರ್
offered to pay reasonable amount if they are ready to exclude my property.
ಹೌದು ನೋ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್ ನಾಳೆ ನಾಡಿದ್ದು ಹೇಳ್ತೀರಾ ನಾಡಿದ್ದು at the request of the counsel for appellant and respondent list day after tomorrow to explore the possibility of a settlement. Now ಕೆಲಸ ಮಾಡಿ settlement ಇದನ್ನ ಆರ್ಡರ್ see number pass over
for partition and position and declaration of declare the three changes for judgment and over.
So notice. Next. ಏನಕ್ಕೆ suit is dismissed, mister. Suit dismiss ಆಗಿದೆಯಲ್ಲ ಬರ್ಲಿ ನೋ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ ಪಾಸು ಪಾಸು ಎರಡೂವರೆಗೆ ಹೇಳ್ತೀರಾ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ದಯವಿಟ್ಟು ನೀವು ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ 2:30 ತನಕ ಏರಿ ಸಾರಿ ಐ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಮಿಸ್ಟರ್ I will not grant adjournment. You can say whatever you want. I will not grant adjournment at mere asking. ನೀವು ಓದ್ಕೊಂಬರಲ್ಲ ಫೈಲು ಬುಕ್ ತರೋದಿಲ್ಲ ಜಜ್ಮೆಂಟ್ ಓದೋದಿಲ್ಲ ಸಿಂಪ್ಲಿ ಯು ಸೇ ಫ್ರಮ್ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಹೌ ಇಸ್ ದ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ರಿಲೆವೆಂಟ್ ಅನ್ನೋದು ಯೋಚನೆನೂ ಮಾಡೋದಿಲ್ಲ ಸಾರಿ ಮಿಸ್ಟರ್ you should come prepared. No adjournment. Please come at 2:30. Prepare mark bani. Don't come and take adjournment. Sumne adjournment ತಗೊಂಡು ಏನು ಸರ್ 2:30 ಬನ್ನಿ ಆಗಲಿ ನೀವು ಬರ್ದೇ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಬರ್ದೇ ಇದ್ರೆ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. ಪ್ಲೀಸ್ 2:30. ಸಾರಿ ಮಿಸ್ಟರ್, ನಿಮ್ಗೊಬ್ಬರು ಕೊಟ್ರೆ ಎಲ್ಲರೂ ಕೊಡ್ಬೇಕ್ರಿ. ಬೆಳಿಗ್ಗೆಯಿಂದ ಒಂದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಲ್ಲ. ಒನ್ ಕೇಸ್ ಬೆಳಿಗ್ಗೆಯಿಂದ ಒಂದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಿಸ್ಟರ್ ಚಂದ್ರಶೇಖರ್ 60 ಕಾಶಿನಾಥ್ JD. Yes. Seven. ಹಿಯರ್ ಮಾಡಿದೀವ? ಯಾವ್ದು ಇದ್ರದ? When do you want it? So when do you want 67? It's day after tomorrow. Please intimate the other side.
yesterday, I was application.
I'll consider. Idea? Huh? So. Yes, Mr. Shanmugappa. Shanmugappa.
Appeal may not survive.
I cannot dismiss the case on merits if it doesn't.
But two grounds for that. One, there is an appeal, a revision is pending. Appeal is dismissed, and the revision petition this court held that revision is not pending. Substantial question of law.
Are you willing to accept some extra money and just be done with it? Consider taking some extra money and just.
2008, I paid this money, 20 crore, 20 lakhs.
Huh? 20 crores.
20 lakh, 20,000. 20 lakh, 20,000. In 2008, I have paid.
What is the value of the property today?
This valuation, at that time, it was about 18 people participating in the highest. They have taken the loan.
No dispute.
So far as I am concerned, I am bona fide purchaser.
Sir, absolutely, I am not finding fault with you.
Yes.
I'm only saying only a humanitarian consideration. They lost the roof over their heads. You can take back the money along with some amount of premium.
But I want property. That's the reason I filed a suit. Because he wanted a house for him, therefore family. He participated in the auction. In auction, there will not be any problem, but they never knew.
What happened to the proceedings before the cooperative society?
That's a reject. That's what I wanted to see. The appeal filed is dismissed. Kindly see, who appeals are filed?
G. Somashekar. Sarvamangala.
And then they filed a revision before the state government. Revision was allowed, and matter was remanded. Then we came before this court. This court held that the revision is not pending. The appeal order copy, I just only read the operative portion of it. This at page 18. Yes. IA filed by the appellant under Section 5 of the Limitation Act dismissed. Consequently, appeal filed by the appellant under 105 of the Karnataka Cooperatives Act dismissed as barred by limitation by confirming the award passed by the arbitrator in suit number so and so. The office is direct. Then the second ground is that the revision petition has been filed. Kindly come to page 39, the order of this honorable court. 15th of July 2021. That this court took the view that the revision itself is not maintainable. Paragraph 5
Yes, please.
The material on record indicates that apart from the fact that revision filed by the respondents 1 and 2 before response secretary was not maintained. Substantial question of law, your lordship could see that only at those two grounds.
What happened to the proceedings before the cooperative societies? Authorities went to the cooperative society. Pending dispose agogiddalla KT munde.
Just can have copy.
Adu dispose agogide. We lost everywhere. Position adike bitkodi anta keltiru. Now purchase the property. ಖಾಲಿ ಮಾಡಿಸ್ಕೊಡಿ ಅಂತ ಸೊಸೈಟಿ ಅವರು ಪೊಸಿಷನ್ ಕೊಡಿಸ್ಬೇಕಾಯ್ತು ಕೊಟ್ಟಿಲ್ಲ ಖಾಲಿ ಮಾಡಿಸ್ಕೊಡಿ ಅಂತ This is the due process. Suit ಹಾಕಿರೋದೇ due process. ಏನು mean profits ಏನು? They'll give up mean profits. ಎಷ್ಟಿದೆ?
3,000 rupees per month.
ಆಯ್ತು, ಅದು ಬಿಟ್ಟುಬಿಡಿ ಅದನ್ನು. ಒಂದು ಡೇಟ್ ಆಫ್ ಸೂಟ್ ಡಿಸ್ಚಾರ್ಜ್ 36/22. ಎಸ್ ಎಸ್ ಅಷ್ಟೇ ಅಲ್ವಾ? ಬರ್ಕೊಳ್ಳಿ.
By judicial order set aside that mean profit. Within some time frame, let it hand over without making me to go to the again execution is already filed, delivery warrant is issued. That is subject to the handing over the possession within 1 month.
This appeal is filed by the wicket ಮಾಡ್ಬೋದಾ? This appeal is filed by the defendants in OS number 15 of 2010, challenging the concurrent finding of fact recorded by both the courts, by which it was held that the plaintiff is entitled to recover possession of the suit's real property. Next para, the parties shall henceforth be referred to as they were read before the trial. The appellants were the defendants 1 and 2, while the respondents were the plaintiff and defendant number 3. Next para. The suit in OS number 15/2010 was filed for recovery of possession and for damages at the rate of ₹5,000 per month. The plaintiff, full stop, the plaintiff claimed that the defendants 1 and 2 had availed a loan from the defendant number 3 and had mortgaged the suit property. Full stop. Due to the default in payment of the repayment of the loan, the defendant number 3 initiated action for recovery of the loan by proceeding against the mortgaged property. Full stop. The plaintiff claimed to be the successful bidder at a public auction held by the defendant number 3. Public auction conducted by the sale officer, and the plaintiff purchased the same for a total sale consideration of ₹20,20,000. Stop. He claimed that the sale was confirmed on 11/12/2008, and the sale certificate was registered on 15/12/2008. Stop. The defendant number 3, who was under an obligation to recover possession and deliver it to the plaintiff, failed to do so and allowed the defendants 1 and 2 to continue in unauthorized possession of the suit property. Hence, the plaintiff sought for recovery of possession and for mean profits. Full stop. The defendants 1 and 2 contested the suit and claimed that contested the suit and denied the default on their part to repay the loan to the defendant number 3. Full stop. They also denied the auction of the suit property and its purchased by the plaintiff. They claimed that there were several irregularities in the conduct of auction, and in that regard, they had filed an appeal before the DRCS Hassan, challenging the validity of the sale. Full stop. They also claimed that the suit was bad for non-joint of necessary parties, and the sale was not legal. Stop. The defendant number 3 admitted their contentions of the plaintiff, and also the proceedings running up to the sale of the suit property. Full stop. Based on these driver contentions, the trial court can the following issues. Plaintiff was examined as PW1. He marked documents exhibit P1 to P8. Stop. The defendant number 1 was examined as PW1. The witness who marked exhibits P1 to D19 and examined the witness as PW2. So based on the overall documentary evidence, the trial court held that the plaintiff had proved his lawful title for the suit property. Consequently, dismissed the suit and directed the defendants 1 and 2 to deliver vacant possession of the suit property, and also quantified the damages payable by the plaintiff, payable by the defendants 1 and 2 to the plaintiff at the rate of 3,000 per month, with interest at 6% per annum from the date of suit till realization. After being agreed with the aforesaid 23, the defendants 1 and 2 filed RA 281 of 2013. Stop. The first appellate court secured the records of the trial court, heard the counsel for the parties and framed points for consideration, and in terms of its judgment and decree dated 27/7/2015, dismissed the appeal, holding that the plaintiff had proved that he had lawfully purchased the suit property and that he was entitled to recover possession of the suit property. So being agreed with the aforesaid judgment and decree, the present second appeal is filed. As per the learned counsel for the appellant, defendants 1 and 2 submitted that the defendants 1 and 2 had challenged auction sale in an appeal before the Karnataka Appellate Tribunal, and thereafter before the government in the division petition. He therefore submitted that the proceedings in the suit were therefore misplaced, and it was incumbent upon the plaintiff to take recourse to the provisions contained under the Karnataka Cooperative Societies Act to recover possession of the suit property. Next paragraph. The learned counsel for the respondents, on the other hand, plaintiff, on the other hand, submitted that the appeal filed by the defendants 1 and 2 before the Karnataka Appellate Tribunal was dismissed, and the revision petition filed before the state government was also set at naught by this court in WP number 82210 of 2018. Stop. He therefore submitted that the plaintiff defendants 1 and 2 had availed all remedies that are permitted under the Karnataka Cooperative Societies Act. Therefore, the defendants are bound to comply with the judgment and decree of the trial. Next paragraph. As rightly submitted by the learned counsel for the plaintiff, the defendants 1 and 2 who had raised a loan from the defendant number 3 fell in arrears, defendant number 3 were unable to repay the loan, which constrained the defendant number 3 to initiate action for recovery by proceeding against the mortgaged asset. Full stop. The defendant number 3 conceded to the plaintiff governments and claimed that the property was indeed sold to the plaintiff at a public auction, and the sale certificate was registered in accordance with law. In that view of the matter, the plaintiff was justified in filing a suit for recovery of possession from the defendants 1 and 2. And the trial court has considered the material on record and has held the plaintiff is entitled to recover the possession. The first appellate court has also applied itself thoroughly and has upheld the judgment and decree of the trial court, which is based on acceptable oral documentary evidence. Stop. As there is no substantial question of law which requires consideration in the appeal, the same is dismissed. Before parting with the case, it is relevant to note that the trial court had awarded damages at the rate of ₹3,000 per month, along with interest at 6% per annum from the date of suit and realization. Full stop. The defendants 1 and 2 had not delivered possession to the defendant number 3 to the mortgage deed. Therefore, the defendants 1 and 2 are not liable to pay the damages as quantified by the trial court. Hence, to this extent, the interim judgment and decree of the trial court is modified. Yes, how much time you need?
3 months time.
Yes, 3 months or 6 months. 6 months. In addition, get it done. In addition, the defendants 1 and 2 are granted 6 months time to put and deliver vacant possession of the scheduled property to the plaintiff, subject to the defendants 1 and 2 filing an undertaking. Subject to filing an affidavit, defendants 1 and 2 filing an affidavit before this court within 10 days from now. Undertaking to put and deliver vacant possession of the suit premises to the plaintiff a year before. September 2022, without compelling the plaintiff to take steps to execute the decree passed by the trial court. They shall also undertake that they will not sublet or underlet or allow any trespassers to enter possession of the suit property. Stop. Yes.
6 months.
Parvaila biಡಿ ಸರ್ parvaila ಏನು ಮನೆ ಏನು ಮಾಡ್ತೀರಾ ಪಾಪ ಇರುತ್ತೆ ಇರೋ ಮನೆ ಇಟ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೆಯಲ್ಲ.
Undertaking affidavit is not 5 minutes.
This the benefit of this order not be available to the plaintiff defendants 1 and 2 if the affidavit as stated above is not filed within 10 days.
Not appear for the appellant, not appellants.
ಏನದು ನೋಡಿದ್ರ ಅದು
ನೋಡಿದೆ. Both the courts appear to have rightly appreciated and come to the right conclusion.
ಇಲ್ಲ ಅಲ್ಲ
ಏನು ಇದ್ದಂಗೆ ಕಾಣೋದಿಲ್ಲ. Your lordship may proceed to pass orders on merits.
When it is dismissed. Mr. Raghupati TN. There is no representation for the appellant, though it is called thrice in the day. Hence, the appeal is dismissed for non-prosecution. Same order. Dismiss. This next. Pardon? How settlement.
You have signed it. You have to just.
This bundle is municipal.
And the suit was dismissed by the plaintiff on the ground of lordship. The declared suit has not committable fact other than the mandatory injection, your lordship. The against which appeal was filed and appeal was allowed. Now it is divergent by some findings of the court. Now issue, your lordship, are not going to the issues much, your lordship. Now 2 sale deeds are executed. The plaintiffs claiming the execution of the sale deed in the year 1994. Whereas my client, your lordship, the defendants are claiming, your lordship, is based on the 2010 sale deed. Now 2 sale deeds have, your lordship. Now one aspect has been not considered by the courts below. In the first sale deed, your lordship, it is the signature of the
husband.
Allah, executed.
Mehboobi. Khalil
Saab, your lordship, is my son. Khalil Saab.
A registered sale deed from one Khalil Saab.
Yes. What happened, your lordship, is the property in question was, your lordship, in the name of Mehboobi Home Khalil Saab. Home Antal, he's not the husband. He's the son, actually. It was in the joint name.
Mehboob Saab, Khalil Saab, Home Andrenu.
ಅದು ಆಕ್ಚುಲಿ ಗೋಮಂತ ಆಗಿದೆ ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಆನ್ ರೆಕಾರ್ಡ್ ಆನ್ ದ ಮುನ್ಸಿಪಾಲಿಟಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಂತೀವಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಂತೀವಿ 6/2/2010 ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಂತ ಬರ್ದಿದೆ
2010 ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ
6th of ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಆಯ್ತಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಫಸ್ಟ್
ಅದರಲ್ಲಿ ನಾನು ಇಷ್ಟೇ ಹೇಳಿದ್ದೀನಿ ಮೆಹಬೂಬೀರ್ ಅವರ ಮಗ ಸುಮಾರು 5 ವರ್ಷದ ಖಲೀಲ್ ಸಾಬ್
ಮಗನೇ ಆಗ್ಲಿ ಮಗನಿಗೆ ಏನಿತ್ತು ರೈಟ್
Khalil Saab, because it's in the joint name, your lordship. He has executed the sale deed in 2010. Thereafter, your lordship, rectification sale deed was executed by the mother herself. To the rectification sale deed, your lordship, it is she has given her thumb, your lordship. And what is transpires, your lordship, whereas in the 1994 sale deed, it is appears to be signature. And she is illiterate. She is not having the knowledge of writing the signatures. But unfortunately, your lordship, that has been not considered by the courts below, your lordship, when 2 different signatories has been appears in these 2 sale deeds, your lordship.
First sale deed ಏನು ಮಾಡಿದ್ರು
First sale deed, your lordship, sign ಮಾಡಿದ್ದಾರೆ.
ಅದನ್ನ ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದಾರಾ
ಹೌದು
ಎಲ್ಲಿ ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದ್ದಾರೆ
First sale deed ಅಲ್ಲಿ, your lordship,
1994 ಸೇಲ್ ಡೀಡ್ ಅನ್ನ ಎಲ್ಲಿ ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದ್ದಾರೆ
1994 sale deed question ಮಾಡಿಲ್ಲ, but your lordship, what happened, your lordship, only we have put the question only to this extent, whether she has executed a sale deed.
ಅದನ್ನ how can you challenge in his suit? ಆಯ್ತು ಒಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಹಾಕಿದ್ದೀರಾ ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ will prevail unless you set aside that.
Your lordship, what is transpires now to the extent, your lordship, badly conducted case before the court below. Badly conducted case before the courts below.
Badly conducted, even lawyers cannot help because first sale deed is 1994, next sale deed is 2010.
Whether because the very son, one of the another son comes before the as a DW2 states that my mother has not executed any such sale deed. But mother was not exempt for the reason, your lordship, by the time she was dead.
Mother, what steps did she take? Mehboobi, what steps did she take for annulment of the sale deed of 1990?
She has not taken any steps. She has not taken any steps.
This appeal is filed by the defendant. The voice number from 480 of 2000 challenging the divergent opinion recorded by the first appellate court in RA 15 of 2018, by which the first appellate court reversed the judgment in decree of trial court and decreed the suit in voice number 480 of 2010 for declaration for
Declaration.
What is the suit filed for?
Suit for mandatory injection. The lordship will get it page 41. The
refuse the suit for removal of the defendant.
Removal and possession of possession.
And to hand over possession of the same to the plaintiff. Next para. The suit property is the residential site of property. Is a house. Suit property is a tile roof house. Situated on third cross near Park Davangere, measuring 40 feet into 15 feet. Which was owned and possessed by Mehboobi. Full stop. It is stated that the plaintiffs 1 to 4 purchased the suit property from the said Mehboobi in terms of a sale dated 27/7/1994. Full stop. The plaintiffs 1 to 4 claimed that the defendant was their aunt and therefore allowed her to remain in possession of the suit property. Permitted her to remain in possession of the suit real property. Full stop. They allege that though she assured to vacate the property, she refused to do so. And also failed to pay the rent. Rent at the rate of rupees 300 per month. Full stop. Plaintiffs were therefore constrained to issue a notice on 28/6/2010 for calling upon the defendant to hand over possession. So since the defendant did not consent, did not concede to the claim, the plaintiffs filed the suit. Full stop. The defendant contested the suit and claimed that the suit property was allotted to Mrs. Mehboobi. Full stop. He claimed that the son of Mehboobi, namely Mr. Khalil Saab, executed a deed of sale of the suit property on 6/2010. Later, the said sale deed was rectified and was executed by Mehboobi. So the defendant claimed that she was in possession of the suit property and was not a tenant in the property as alleged by the plaintiffs. Full stop. Based on these rival contentions, the trial court set down the case for trial. So the parties were examined and documentary evidence were marked. Based on the oral and documentary evidence, the trial court held that the plaintiff did not seek the relief of declaration that the sale deed executed in favor of the defendant by Mehboobi did not bind them. Full stop. It also held that since the plaintiffs had not fought for the relief of declaration, they are not entitled to recover possession of the scheduled property and hence dismiss the suit. After being agreed by the aforesaid judgment and decree, the plaintiffs filed RA 15 of 2018. The first appellate court secured the records of the trial court, heard the counsel for the parties and framed points for consideration. Full stop. It held that the parties did not deny the fact that the suit property was earlier owned and possessed by Mrs. Mehboobi in terms of Exhibit P1. Full stop. It also held that Mrs. Mehboobi had conveyed the suit property to the plaintiffs 1 to 4. Terms of a sale deed dated 27/1994. Full stop. The first appellate court therefore held that the contention of the defendant that she had purchased the suit property from the son of Mehboobi on 6/2/2010, which was later rectified by Mrs. Mehboobi on 12/4/2010, was inconsequential, as Mehboobi did not retain any interest in the suit property after the conveyance of the suit property on 27/7/1994 in favor of the plaintiffs 1 to 4. Full stop. The first appellate court therefore reversed the judgment and declared the trial court and declared the suit and directed the defendant to hand over possession of the suit property. After being reviewed by the aforesaid judgment and decree, the present regular second appeal is filed. As per the learned counsel for the defendant / appellant submitted that the sale deed dated 27/7/1994 allegedly executed by Mrs. Mehboobi in favor of the plaintiffs 1 to 4 was doubtful in as much as Mehboobi was illiterate and she had put her thumb impression in the sale deed in the rectification deed dated 12/4/2010. And therefore, there was no proof regarding the lawful execution of the sale deed dated 27/7/1994 in favor of the plaintiffs 1 to 4. Plaintiff number 1. Full stop. It is seen from the judgment and decree of the trial court as well as the first appellate court that the suit property was earlier owned by Mehboobi. Full stop. The plaintiff number 1 to 4 purchased the suit property from Srimati Mehboobi in terms of a sale deed dated 27/7/1994. Full stop. Exhibit P1 and P2 stand testimony to the above fact. P1 and P11. P1 and P11 stand testimony to the above. Full stop. The other revenue documents also establish that the suit property was sold to the plaintiffs 1 to 4. Per contra, the defendant relied upon the rectification deed, Exhibit D1, which disclosed that Srimati Mrs. Mehboobi, even after disposing of the suit property to the plaintiff 1 to 4, executed a rectification deed purportedly rectifying the sale deed dated 6/2/2010 executed by her son in favor of the defendant. Full stop. Full stop. It is a matter of common sense that the sale deed executed by Mehboobi in favor of the plaintiff being earlier, the defendant cannot contend that Mehboobi had not disposed of the suit property and that the sale deed executed in her favor subsequently was binding upon the plaintiffs. Full stop. The first appellate court has considered the oral and documentary evidence in the right manner and has held that the plaintiff has made out the case for grant of release. Full stop. That way of the matter, there is no merit in this appeal and the same is dismissed. Yes. Settlement could be. Yes. Yes, please. Purple. appeal is filed by the plaintiff in OS number 82 of 2004, challenging the concurrent finding of recorded by both the courts, by which the suit filed by the plaintiff for special performance was dismissed. When the appeal was listed for admission, parties have entered into a settlement and have filed a compromise petition under Order 23 Rule 3 of CPC. The relevant terms of which reads as follows. By virtue of the compromise, the respondent / defendant has agreed to pay the sum of rupees 4,50,000 to the plaintiff / appellant in lieu of as damages for not pursuing the relief of special performance. Stop. It is also agreed that the plaintiff will return back the original of the sale agreement and also the possession of the suit property to the defendants. Stop. Since the compromise is just and fair, the same is accepted. The parties are present in person and are identified by their respective counsel. So both of them admit and acknowledge the terms of the settlement and affix their signature to the orders of this court in token of acceptance of the terms of the settlement. Stop. In view of the compromise, this appeal stands disposed of. In view of the compromise, the interim judgment and decree passed by the trial court and the first appellate court are modified. This appeal is disposed of in terms of the compromise. Stop. Office is directed to draw a decree in terms of this compromise. Next para. The office is directed to the trial court. Sorry, trial court is directed to return the original of exhibit P1 to P3 to the defendant in the suit. Defendant in OS number 82 of 2004. Full stop. Likewise, comma. Possession ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದ್ರ? Likewise, comma. The stop. Upon payment of the sum of rupees 3.5 lakhs, as stated in paragraph number 10 of the compromise, the plaintiff shall deliver back possession of the suitable property to defendant. This complaints can ಆಗ್ಬೇಕಾ? Want is to be listed for complaints. ಯಾವತ್ತು ಕೊಡ್ತೀರಿ ಲಿಖಿತ? 3 months ಇಲ್ಲಿ ಎಷ್ಟು ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ಲಿ? Which made clear that if the defendant does not comply with the terms of this compromise, the plaintiff / appellant is entitled to seek recalling his order accepting the compromise. This was 47. This was Chandrappa. Yes.
Starting with the order of the first appellate. In RA, it to be dismissed and continued. And the plaintiff before the trial court and OS number as courts are.
Yes.
Principal infant, that is also dismissed on 23/2009.
Yes, ma'am.
Agreed by the same, initially I preferred the suit for perfection injunction. Later on, plain got amended and filed the perfection injunction and video putting the position for declaration and my adverse position. Agreed by the said judgment and degree passed in English 47, 471 1823 First additional district session judge ruler, that is in RA 47 and subsequently the said appeal has withdrawn and transferred to the first additional district session judge.
Yes.
After hearing the arguments of the both sides, the first appellate court approved the appeal decreed the suit of the plaintiff, OS 471 by its judgment and decree dated 13/7.
What is the suit file? What is the suit for?
Suit is for perfection in declaration and adverse position.
Declaration that you have perfected your right by adverse possession.
The copy of the judgment is connected to the defendant has filed the miscellaneous petition on the ground that defendant has noticed that duly not served, further he has taken condition that the plaintiff has taken steps by way of service. Whether the Ganta daily newspaper or the state newspaper is not widely calculated. The honorable court was allowed the petition by setting aside the judgment and decree in RA 47 dated 13/11/2010 and issuing the appeal on its original side after hearing the arguments first appellate judgment dated 13/11/2018. Appeal has been allowed. Later on, is only the reason is the notice was not served. This reason.
It was remanded. It was remanded. After remand? Chain model. Yes. Yes, ma'am. Yes, what are those applications? Before the first appellate court, you filed two applications. One is under order 41 rule 27. Other is under order 6 rule 17. What are those applications? So, Ian, what are those? What did you want to produce as additional documentary evidence?
Bank South Taluk in the East Karnataka.
What about the additional documents? Please come to para 19 of the first appellate court judgment.
Documents arise after passing earlier expiry judgment and so the set is defendants are not required to take the matter in the further documents of the also not required plaintiff has denied the defendant's over the structural property. The main issue to be decided in this appearing whether appellant plaintiff has proved that he has perfected his right to use over the structural property by way of adverse. Further, the issue to be decided whether the trial court committed error in the dismissing the plaintiff suit. Therefore, the under this was family and not to consider opinion that the deciding the said issues documents sought to be produced mentioned 8 and 5 as additional evidence in the appeal are not necessary to be considered for effective disposal of the case.
Very good. This appeal is filed by the unsuccessful plaintiff, challenging the judgment and decree of the courts, of both the courts, by which the suit filed for declaration that the plaintiff had perfected his title to the suit property by adverse possession was dismissed. The plaintiff claimed that he was in actual possession and enjoyment of the suit property since the year 1978. 1978. He claimed that the defendant, being the owner of the suit property, attempted to interfere with his possession 3 days prior to the filing of the suit, and therefore sought for declaration of his title, declaration of his title to the suit property on the ground that he had perfected it by adverse possession. Next para. The defendant contested the suit and claimed that it was the defendant and his brother who were in possession, cultivation, and enjoyment of the suit property. They claim that out of 4 acres 39 guntas in survey number 114, they, as the owners of the suit property, had sold 1 acre 30 guntas and were in possession of the remaining. They claim that the plaintiff was never in possession, was never in adverse possession as alleged. Full stop. Based on based on these rival contentions, the case was adjourned for trial. The plaintiff was examined as PW1 and he marked documents exhibit P1 to P9. Full stop. He also examined 2 witnesses as PW2 and 3. Full stop. The defendant did not enter the witness box and did not produce any oral or documentary evidence. Next, based on the oral and documentary evidence, the trial court held that the plaintiff had not proved the ingredients for claiming the relief of adverse possession. Full stop. It held that the plaintiff did not establish when he entered possession and when his possession became adverse, and also as to when he perfected his title by adverse. It held that mere production of the revenue records would not confer adverse title upon the plaintiff and hence dismissed the suit. So being agreed with the aforesaid judgment, the plaintiff filed RA 47 of 2009. The first appellate court considered the oral and documentary evidence and held the plaintiff had not proved the requirements of relief of adverse possession and hence dismissed the appeal. Being agreed with the aforesaid judgment and decree, the present regular second appeal is filed. The learned counsel for the appellant / plaintiff submitted that the plaintiff has been in possession of the suit property for well over 50 years, and the evidence of PW2 and PW3 stand testimony to the above fact. She contended that the trial court and the first appellate court failed to consider the revenue records which carried an entry in the name of revenue records, which indicated that the plaintiff was in possession of the suit property. Next paragraph. The relief of adverse possession has to be based on the dates when the plaintiff entered possession adversely, and whether it was to the knowledge and notice of the defendant, and it is incumbent upon the plaintiff to prove that such hostile possession continued for well over 12 years to the notice and knowledge of the defendant. In the case on hand, except claiming that the plaintiff is in possession of the suit property, the plaintiff did nothing to establish that his possession was adverse and or that he was in hostile possession of the suit property. A mere assertion that he is in possession cannot blossom into the right to claim relief of adverse possession. So in that way of the matter, the trial court and the first appellate court have considered the oral and documentary evidence in the right perspective and have dismissed the suit. There is no merit in this appeal and this can be dismissed. Yes. Same one. Though the appeal is called twice in the day, there is no representation for the appellant. This appeal is dismissed for non-constitutional. Same order.
Plaintiff number 2 has not proved that the properties are available partition. Number 1. 3 and 4 they are not also held that they are not ancestral properties.
Plaintiff number 2 has not proved. Yeah,
properties are available for partition.
but 1 and 2 are the properties which
Plaintiff number 2, case number 50, my lord. Fire court judgment, para number 11. She has been separated and she has for more than 30 years she was not stayed in parental house. After taking.
but item number 1 is granted already by the tribunal. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ
PW1 is that
ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಹೇಳಿ ಎಲ್ಲಿ
case number 48. 48 in case 48. Para number 13. PW1 has admitted the mother of the parent.
where are reading?
Page number 9 of trial court. From the beginning, the suggestion put on the dawa number, item number 3. ನಾಲ್ಕರ ಸೊತ್ತುಗಳು ಪ್ರತಿವಾದಿ ಹೆಂಡತಿಯ ಸಹಜಾರ್ಪಿತ ಆಸೆಗಳೆಂದರೆ ಸಾಕ್ಷಿ ದಾವಾ ಐಟಮ್ 3ರ ಸೊತ್ತನ್ನು ದಾವಾ ಐಟಮ್ 1 ಮತ್ತು 2ರ ಆದಾಯವನ್ನು ಸದರಿ ಸೊತ್ತನ್ನು ಐಟಮ್ ನಂಬರ್ 1 ಮತ್ತು 2ರ ಆದಾಯದಿಂದ ಇದು ಮಾಡಿದ್ದು ಯಾವುದೇ ದಾಖಲೆ ಇಲ್ಲ. PW admits that wife and daughter of the defendant is not made as party in the above case. PW further admits that her husband died about 22 years ago. PW denies the suggestion that on 21/19 her husband and the defendant have given 6 quintals of land to the plaintiff. PW1 further admits that ಮದುವೆಯಾದ ನಂತರ ಎರಡನೇ ವಧು ತನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿಯೇ ಸಂಸಾರ ಮಾಡಿಕೊಂಡು ಅಲ್ಲೇ ಇದ್ದಾರೆ ಅಂತ ಸರಿ. ಮದುವೆಯಾದ ನಂತರ ಎರಡನೇ ವಧು ಪ್ರತಿವಾದಿ ಮನೆಗೆ ಬಂದು ಮಾಡಿಲ್ಲ ಅಂತ ಸರಿ. ಪ್ರತಿವಾದಿ ಎಲ್ಲಾ ವ್ಯವಸ್ಥೆಗಳನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಈ ಸಜೆಷನ್ ಕೊಟ್ಟ PW ದಾವಾ ಐಟಮ್ ನಂಬರ್ 1ರಲ್ಲಿ 3 ಎಕರೆ 15 ಗುಂಟೆ ಜಮೀನು ಇರುವುದಿಲ್ಲ. 1 ಎಕರೆ 28 ಗುಂಟೆ ಮಾತ್ರ ಇದೆ ಅಂದರೆ ಸಾಕ್ಷಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು ಇಲ್ಲ 1 ಎಕರೆ ಗುತ್ತಿಗೆ ಜಮೀನು ಆಗಿರುವುದಾಗಿ ತಿಳಿಯುತ್ತಾರೆ. ಗುತ್ತಿಗೆ ಜಮೀನು ನಂತರ ಆಗಿದ್ದು ಆ ಸಂಬಂಧ ದಾಖಲೆ ಇದ್ದು ಅವನ ಆಧಾರಪಡಿಸಿದ್ದು ನನಗೆ
But is it your case that item number 1 does not exist?
They are cultivating. Defendant number 1 is cultivating, but it's not yet granted.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಾ? Where have you taken that contention? ಇಲ್ಲಿ ಹೇಳಿದ್ರು ಓದಿ. ಇಲ್ಲ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರು? Trial court judgment paragraph number 3 1.
What has issued the summons to the defendant? Defendant has appeared before the court. With that statement by contending that suicide property is not met for the law of facts and the same is liable to be discussed in the minute. This contented suit is brought by law of invasion and the plaintiffs have filed this suit for furnishing wrong boundaries and measurements of the suitable property. The plaintiffs filed this suit for the non-existing property. The suit is bad for misgender and non-gender of the service purpose. The suit is bad for partial person. The averments made in the para 2 and 5 of the plaint are denied and contend that Manchama Siddha, who is the father of the defendant, was paid on 1/5/1991. The averments made in para 6 of the plaint is denied. It is true that the plaintiff got issued legal notice to the plaintiff for 2012 and the same was duly replied by the defendant and denied the other averments made in para 8 of the plaintiff. There is no cause of action for this court. The court will be solicited from the mouth of the PW1, PW2.
ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಇದು ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಇನ್ನ ಆಗಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವನ್ ಅಪರೇಟ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅಬ್ಸರ್ವ್ ದಿ ಸೇಮ್. ಅರ್ಧ ಆಗಿದೆ ಅರ್ಧ ಆಗಿಲ್ಲ ಅಂತ
ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ.
26 ಮೇಲೆ base 23 ಆಗಿದೆ.
Yes.
As a result of the para 15 of the written statement, the defendant has admitted regarding the existence of 1 acre 28 acres of land in survey number 182/1. Which are entrance in upper the that is suit item number 1 in the very same para, the defendant admitted regarding the existence of suit schedule item number 2, that is housing old Kata number 633, new Kata number 793. Even it is gathered from the written statement, also from the evidence of the that said properties are answered to the property. Therefore, records also reflected that the record of rates in the respect of land survey number 183/1, measuring 1 acre 28 gunters are available. The said property appeared in the name of Manchamani Siddhavara and later it appeared in the name of the given. The document produced by the principal with the A number 4 and 3, that is original partition dated, clearly shows that 1 acre 20 land was allotted to the share of the family part. Similarly, the above documents fallen to the share of Manchamani Siddhavara and still it is standing. Even the current advocate for defendant in asset examination suggested that suit item number 2 or the asset purpose. The suggestion for the admission in of the
28 ಬನ್ನಿ ಅಲ್ಲಿ
27 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
28 ಬನ್ನಿ ಅಲ್ಲಿ
is gathered and also that the matter with respect to remaining area of 1 acre land in suit item number 1, that is survey number 183/1 is still pending before the land.
Therefore 1 acre 28 ಗುಂಟೆ
ಖಾತಾ ಇದೆ ಸರ್, ಆರ್ಟಿಸಿ ಇದೆ
ಅಲ್ಲ. ಮಂಚಮ್ಮನ ಸಿದ್ದೇಗೌಡನಿಗೆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ 1 acre 28 ಗುಂಟೆ ಬಂತು.
ಬಂದಿದೆ ಅಂತ
one item ಅಲ್ಲಿ
document is not admitted. So this produced by the plaintiffs, not admitted in the
not admitted in the document is produced.
Document is produced.
1950 document. So 1950 document, however, overcome section 90 of the Evidence Act. 30 ವರ್ಷ ಆಗೋಯ್ತಲ್ಲ, ಅದು ಹೆಂಗ್ ಡಿಸ್ಪ್ರೂವ್ ಮಾಡಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ.
RTC has come, but it's started granted ಅಂತ.
1 acre 28 ಗುಂಟೆ ನಿಮ್ ತಂದೆಗೆ 1950 ಇಸ್ವಿನಲ್ಲಿ ಭಾಗ ಬಂತು. ನಿಮ್ಮ ಅಪ್ಪ 1 ಎಕರೆಗೆ ಫಾರ್ಮ್ 7 ಹಾಕಿದ್ದಾರೆ. ಆ 1 ಎಕರೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. 1 acre 28 ಗುಂಟೆ ಏನಾಗ್ಬೇಕು?
ಅದಕ್ಕೂ ಡಾಕ್ಯುಮೆಂಟ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬಂದಿದೆ as per the RTC. On the basis of the RTC, this partition, including 3 acre 25 gunters. Item number 1 ನಲ್ಲಿ ತೋರಿಸಿರೋದು 3 acre 25 gunters.
Please come to the operative portion of the order first for the first appellate court. 1 acre 28 ಗುಂಟೆಲ್ಲೇ ಶೇರ್ ಕೊಟ್ಟಿರೋದು.
Not confirmed ಅಂತ
ಸರ್. 1 acre ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಬಗ್ಗೆ ಶೇರ್ ಕೊಟ್ಟಿಲ್ಲ. 1 acre 28 ಗುಂಟೆ ನಿಮ್ಮ ಅಪ್ಪನಿಗೆ 50ನೇ ಇಸ್ವಿನಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಬಂದಿರೋದ್ರಲ್ಲಿ ಭಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. Please come to the operative portion, page 20. Para 30.
Resultantly, this is by the plaintiffs seeking relief of partition and separate person. Party detail, plaintiff number 1 is entitled to 19 share, plaintiff number 2 is held entitled to 49 share. And defendant is held entitled to 49 share in the land survey number 183/1 measuring 1 acre 28 gunters.
Correct ಮಾಡಿದ್ರು.
Not proved it.
ಯಾವುದು not proved?
Partition is unmarked documents they have done.
ಏನು unmarked documents?
Started marked as per paragraph 6. They only produced document produced the plaintiff along with IA. The IA is also not considered.
This is IA.
Paragraph 26. Appellate court. Page 23. Last even the documents
The document to print along
with IA number 2 and 3.
What is IA 2 and 3?
Production of documents. The documents are not being marked. Now admit ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಆ documents.
56 ಅಲ್ವಾ?
ಹೌದು ಸರ್.
Issue notice. Call for report. ಹಾಕದ ಮೂವ್ಮೆಂಟ್. ಬಟ್ ವಿನೀತಾ ಶರ್ಮಾ ಅದೊಂದು ಲೀಡಿಂಗ್ ಕೇಸು, ಅದನ್ನ ಓದಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ? ಆಯ್ತು, ಜನರಲ್ ಆಗಿ ಹೈಲೈಟ್ಸ್ ತಿಳ್ಕೋಬೇಕು. ಬಟ್ ನಿಮ್ ಕೇಸ್ ಬಂದಾಗ ಓದಿದ್ರೆ ಹೆಂಗೆ? ಡೇಟ್ ಆಫ್ ಬರ್ತ್ it has no relevance now. Date of birth has no relevance. ದಯವಿಟ್ಟು ಓದಿ. Yes.
Lord, Marana, my lord, I had two wives, my lord. One is my lord Rangama and the other one is Narsama. And Narsama is the plaintiff number 1 and plaintiff number 2. Lord, is what the admit is the fact admitted by my lord.
Start from where you left. Don't start over
Yes,
all
please.
over again.
My submission would be, my lord, with regard to Lord the claim that has been made, my lord, under the will. Lord, I have, my lord, taken the suspicious circumstances before the trial court. On one instance, my lord, wherein, my lord, though it is registered, my lord, in the year 1981, but till 2009, Lord, it was never seen the light of the day. Lord, and apart from this, my lord, the plaintiff herself, themselves have relied upon two documents, P1 and P2, my lord, P2 and P3, wherein, my lord, my name is already forthcoming in the RTC as well as, my lord, in the property tax registration. But my submission would be, my lord, since it's a suit for declaration, Lord, as per the proviso of section 34 of the, Lord, specifically fact, Lord, mere suit for declaration without seeking possession is not maintainable.
When did the first wife of Marana die?
Lord, she died, my lord, admittedly, my lord, much earlier to, Lord, there is no relevance that has been placed either by both the parties, my lord.
Therefore, the plaintiffs are entitled for a share in all the properties.
Lord, my submission, my lord. Now, my lord, there is a will placed by, my lord, the plaintiffs. Lord, the entire suit, my lord, for them is under the will, my lord. Lord, when I am able to show and demonstrate the fact that, my lord, in the presence of exhibit D4, which is a sale deed, my lord, executed in the name of, my lord, defendant number 1, who has purchased the property, including that property, my lord, if the plaintiffs want to claim, my lord, their right under the will, Lord, they have to question the validity of the sale deed as well as the relinquished deed that has been executed. Lord, the sale deed was executed in the year 1972 in favor of defendant number 1. By the earlier vendor. It's a sale deed where, my lord, the defendant number 1 had purchased the properties, Lord, under a registered sale deed. It is
Which property, Mr. Which property?
My lord, that item number 3, which is house property, my lord. And my lord, in 1976,
from whom did you purchase?
Lord, I purchased, my lord, exhibit D4 from I tried my best, my lord, to read that. Lord, this first page, my lord, it is not possible to read, my lord, through whom he has purchased. But, my lord, there is recitals, my lord, available. Lord, wherein, my lord, the first appellate court.
How did Marana get item number 3? Please.
But Marana had no right, my lord. He never had any independent right in acquiring suit item number 3.
How old were you when you purchased item number 3?
My lord, I was, my lord, aged majority, my lord.
Appellant ಮೇಲೆ majority ಎಷ್ಟು ವಯಸ್ಸು?
But according to my lord, as of now, my lord, I am age 60, my lord. Somewhere in the 1972, my lord, I was, my lord, 30 years old. But my submission, my lord, on the other aspect of it, my lord, when voluntarily, my lord, plaintiff number 1 and 2 have relinquished their rights, lord, under a registered relinquishment deed, lord, that too taking, my lord, a consideration of rupees 2,200, lord, without questioning the validity or other.
Again, you going back to the same question, Mr. I have to execute ಮಾಡುದು. They have executed the relinquishment deed. They have given up all their claims. Maranna says, take this property by a will. What is wrong?
My lord, my submission is, my lord, by that relinquishment deed, now, my lord, I have become the owner of the property to the full
How
extent.
did you become?
Because, my lord, admittedly, my lord, the sale deed which stands in my name with regard to suit item number 3, lord, it becomes my property. How under the bill, my lord,
Which is the document?
Exhibit D4, my lord. Yes. Exhibit D4 is the sale deed, my lord, which is dated 1972.
That relates to different property. That relates to different property.
Not the item number 3.
My lord, I pray your lordship, my lord, kindly turn to my lord, the judgment, my lord.
That relates to different property.
Where is the finding regarding the D4?
For property number 25C, item number 391 page, what is the page? Here, the code.
Where is the discussion regarding exhibit D4?
Page number 33, my lord. Yes. Exhibit D4 is the sale deed dated 13/4/1972.
Where are you reading?
Page number 34, my lord. Page number 34. First appellate court judgment. Para number 27. Yes, please. The exhibit D4 is the sale deed dated 13/4/1972, which recites that Rangegoda sold grass roofed house measuring 45 yards and north-south 56 yard and property number 21 east-west 10.5, north-south 8 yard of house but 25/6, house measuring east-west 12 yards and north-south 13 yards, and land bearing survey number 82/2 measuring 2 acres 24 guntas and survey number 73 measuring 20 guntas and assessment number 145 and property number 15/B in favor of Chelvarangayya, defendant number 1. Son of Maraya. Exhibit D7 is the card issued by Bangalore Power Supply. This is
And these properties are not.
Half-hearted. Why do you argue half-hearted? What is there to show that you have purchased item number 3? Exhibit D4 and L is the This is east to west 10 yards, north to south 15 yards. East is there. 45 yards to 56 yards.
But this is the only discussion, my lord.
There is a finding regarding item number 3 that you have purchased.
The entire issue, my lord, was clubbed and my lord, the entire suit by virtue of
Please come to para 31.
It is not the case of first defendant that any items of the suit scheduled property are purchased in his name. No doubt, exhibit D4 shows that the properties therein are purchased in his name through his guardian Lingegoda. But exhibit D4 does not show that the suit property is a description. On the other hand, it shows that the properties stated therein are not the suit scheduled properties.
What does it mean?
My lord, my submission would be, my lord, the relevance, my lord, with regard to exhibit suit item number 3. My lord, is I relied upon exhibit D4. My lord, the portion which, my lord, which they are now insisting, my lord, stating that it is item number 143 is the item 145, which is the subject matter of, my lord, exhibit D4.
Lord, I have the copy of the written statement.
Please,
item number 3
yes, my lord.
3, para number 7, my lord.
ನೋಡಿ ಎಲ್ಲಿ ಹೇಳಿದೆ?
But it is only with regard to the registered document number. The plaintiff have suppressed material fact and registered documents and filed this suit without clean hands.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಐಟಮ್ ನಂಬರ್ 3 ಪರ್ಚೇಸ್ ಮಾಡಿದೀನಿ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
Throughout the proceedings was canvassed on exhibit E4. And the next point would be, my lord, with regard to, my lord, the relief of, my lord, second relief which has been granted to the honorable, my lord, both the courts, with regard to the injunction, but I'm just relying upon judgments, my lord. Right of the same, I request you not check that.
What possession ಬಗ್ಗೆ ಏನಿದೆ?
My submission is now, I am in possession of the property, and by virtue of, my lord, this decree, they want to enter into the possession. Now, in a suit for declaration, my lord, without seeking for the consequential relief or further relief for possession.
There is a question of seeking possession, Mr. Agricultural land.
Money property in suit item number 3. That is what, my lord, my submission is.
Possession ಕೇಳಿದಿರಾ?
Please, my lord. It's a suit for declaration.
ಬಿಲ್ಲಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಪೊಸಿಷನ್ ಬಗ್ಗೆ? ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರಾ? See, there cannot be a warrant to deliver possession, correct? They cannot obtain a warrant for delivery of possession, correct? Possession ಇದೀನಿ
ಇಲ್ಲ ನಾನು ಏನು ಇಷ್ಟಕ್ಕೆ 1976 ಅಲ್ಲಿ when she has voluntarily given her right, when the possession was delivered. So the question of, my lord, under the bill again getting, my lord, the possession, that doesn't come. But make consultation. I am only relying upon one judgment, which I pay a lot about that. But
2020 ಲೋನ್ ಬಂದಿದೆ ನೋಡಿ.
ಹೌದು ನೋಡಿದೆ.
2020 ನೋಡಿದಿರಾ? Possession without declaration, without possession ಮಾಡಬಹುದು ಅಂತ ಬಂದಿದೆ ನೋಡಿ.
Title is put, my lord, the consequential relief.
Possession has to be given ಅಂತ ಬಂದಿದೆ ನೋಡಿ.
My only submission is, my lord, 1976 deed ಅಲ್ಲಿ release ಮಾಡಾದ್ಮೇಲೆ when she has taken the possession ಅನ್ನೋದು ಮಾತ್ರ there is no relevance.
Agricultural land ಅಲ್ಲಿ, in respect of agricultural land, possession will follow title. Bill ಅಲ್ಲಿ possession title ಬಂದಿದ್ರೆ possession follows automatically. There is no need for him to seek for recovery of possession. Injunction ಸಿಕ್ಕಿದ್ರೆ ಸಾಕು.
ಇಲ್ಲಿ suit item number 3 related ಆದ್ರೂ ಕೇಳಬೇಕಾಗಿತ್ತು.
Earlier, how have you proved that you are in possession?
My lord, I have produced, my lord, the very document they relied upon exhibit P2 and P3, my lord, which shows my name. And my lord, I have also produced the document wherein which, my lord, I have my lord, taken the loan and I have subsequently discharged. But throughout, my lord, the second judgment, my lord, year 2007 Karnataka, page 91, my lord. But I take the lordship to para number 30.
You will only stay this only to the extent of item number 2. Possession ಬಗ್ಗೆ ಏನು?
ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಎಕ್ಸಿಬಿಟ್ P3 ನಲ್ಲಿ ನನ್ನೊಟ್ಟಿಗೆ ಅವರ ಅದು ನಾರಾಯಣ P3 ನಲ್ಲಿ ಬಂದಾಗ ನನ್ನ ಜೊತೆಗೆ ಇದ್ದಾರೆ ಅವರೆಲ್ಲ.
ಈ ಮನೆಯಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ವಾಸ? ಕಾಸ್ಟ್ ಏಟ್ ಏನಂತಿದೆ? ಕಾಸ್ಟ್ ಏಟ್ ಏನಂತಿದೆ? ಮಾರೇಗೌಡ
ಮಕ್ಕಳಿಗೆ ಮದುವೆ ಆಗಿ ಬೇರೆ ಕಡೆ ಇದ್ದಾರೆ, ತಾಯಿ ಮಕ್ಕಳು.
They are residing in the same village, not with us.
That they have,
my lord, exhibit P3, my lord. My only submission is exhibit P3. Exhibit P3 stands in my name.
Sorry, Mr.
At least, my lord, the judgment may be, my lord, taken for a moment.
I'll look into it. Judgment pass ಮಾಡುವಾಗ ಈಗ detailed judgment ಇದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
One more submission, my lord, which I wanted to plan. To, my lord, relationship, purpose relationship, my lord. I have never admitted the fact about that.
Who are you to admit? Marana doesn't have dispute.
But none of share kuda it is going in
share already. Maran share ಅವರು ಕೊಟ್ಟರು ಅಷ್ಟೇ. ನಿಮ್ ಶೇರ್ ನಿಮ್ಗೆ ಅರ್ಧ ಬಂದಿದೆ.
ಇಲ್ಲ ಹಂಗ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲಲ್ಲಿ ಅವ್ರಿಗೂ ಶೇರ್ಸ್ ಕೊಟ್ಟಂಗೆ ಬರ್ತಿರೋದು.
ಇಲ್ಲಲ್ಲಿ ಅರ್ಧ ಬಂದಿಲ್ಲ.
ಇವ್ರಿಗೆ ಅರ್ಧ ನಮ್ಗೆ ಅರ್ಧ.
ಹೋದ್ರೆ ಅವ್ರಿಗೆ is determined not to take an order. ನಾನು ಓದಿ
ಅವರು 4 ವರ್ಷ ವಯಸ್ಸಿನ ಅಕ್ಕ ಮಾರಮ್ಮನ ಮಗಳು ಸೇರಿ ಹೆಣ್ಣು ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನಾನು ಎರಡನೇ ಹೆಂಡತಿ ಮತ್ತು ಅವರ ಮಕ್ಕಳೊಡನೆ ಒಂದೇ ಕುಟುಂಬದಲ್ಲಿ ಅವರ ಪೋಷಣೆಯಲ್ಲೇ ಇರುತ್ತೇನೆ. ನನ್ನನ್ನು ಈ ವೃದ್ಧಾಪ್ಯದಲ್ಲಿ ಕಾಪಾಡತಕ್ಕವರು ಇವರೇ ವಿನಃ ಬೇರೆ ಯಾರು ಇರುವುದಿಲ್ಲ. ನನ್ನ ಹೆಂಡತಿಯಾದ ನರಸಮ್ಮನ್ನು ನನ್ನ ಪ್ರೀತಿ ವಿಶ್ವಾಸದಿಂದ ಕಾಪಾಡಿರುತ್ತಾಳೆ. ನನ್ನ ಮರಣಾನಂತರ ನನ್ನನ್ನು ಇವಳೇ ಸತ್ಕರಿಸಿ ಸಹ ನನ್ನ ಅಂತ್ಯಕ್ರಿಯೆ ಮಾಡತಕ್ಕದ್ದು. ಈ ಮುಂದೆ ಕಾಣುತ್ತಿರುವ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತುಗಳನ್ನು ಮುಂದೆ ಕಾಣಿರುವ ರೀತಿಯಲ್ಲಿ ವಿಲ್ ಮಾಡಿರುತ್ತೇನೆ. ಶೆಡ್ಯೂಲ್ ವಿವರ: ಮಾಗಡಿ ತಾಲೂಕು, ಮುಡಬಾಳು ಹೋಬಳಿ,
ಶೆಡ್ಯೂಲ್ ಬಿಡಿ ಮುಂದಕ್ಕೆ ಹೋಗಿ.
ಇಲ್ಲಿದೆ. ಮೇಲ್ಕಂಡ 2 ತಾಕು ಜಮೀನುಗಳಲ್ಲಿ ಸಮಾನಾರ್ಥವಾಗಿ 1ನೇ ತಾಕಿನಲ್ಲಿ ಉತ್ತರಾರ್ಧ ಭಾಗ ಜಮೀನನ್ನು ಎರಡನೇ ಹೆಂಡತಿ ನರಸಮ್ಮನಿಗೂ ಅವರ ಮಕ್ಕಳಾದ ಜಯಮ್ಮ ಮತ್ತು ಅಕ್ಕಮಾರಮ್ಮನವರಿಗೆ ಸಮಾನವಾಗಿ ಸೇರತಕ್ಕದ್ದು. ಮತ್ತು ಈ 1ನೇ ತಾಕಿನಲ್ಲಿ ದಕ್ಷಿಣಾರ್ಧ ಜಮೀನು ನನ್ನ 1ನೇ ಹೆಂಡತಿಯ ಮಗನಾದ ಚೆಲುವರಂಗಯ್ಯನಿಗೂ ಸೇರತಕ್ಕದ್ದು. ಎಲ್ಲದರಲ್ಲೂ ಕೊಟ್ಟಿದೆ.
ಐಟಮ್ ನಂಬರ್ 3 ಲಾಸ್ಟ್ 4 portions, 4 lines. 3ನೇ ಜಮೀನು ಡಿಟೋ ಮನೆ ಇದಕ್ಕೆ ಸೇರಿರುವ ಬಾಳು ನಿವೇಶನ ನನ್ನ 2ನೇ ಹೆಂಡತಿ ನರಸಮ್ಮನಿಗೂ ಮತ್ತು ಇವಳ ಮಕ್ಕಳಾದ ಜಯಮ್ಮ ಮತ್ತು ಅಕ್ಕಮಾರಮ್ಮನಿಗೂ ಮೆಜಾರಿಟಿ ಬರುವವರೆಗೂ 2ನೇ ಹೆಂಡತಿ ನರಸಮ್ಮನೇ ಇವರ ಗಾರ್ಡಿಯನ್ ಆಗಿ ಯಾವಾಗಲೂ ಇವರುಗಳನ್ನು ಪೋಷಣೆ ಮಾಡಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ಈ ಭಾಗದ ಆಸ್ತಿಯನ್ನು ಪಡೆದುಕೊಳ್ಳತಕ್ಕದ್ದು. ಈ ಸ್ವತ್ತು ಮೇಲೆ ಯಾವ ವಿಧವಾದ ಪೂರ್ವಾದಿ. Item number 2 is concerned, my lord. It is exclusively given to the share of
item number 3.
Item number 3. No. Lord, item number 3 ನಂದು ವಿಚಾರಕ್ಕೆ ಬಿಲ್ ನಲ್ಲಿ ಏನು ಮಾಡಿಲ್ಲ. when I have purchased the property.
ಅಪ್ಪನ್ ಕೇಳಬೇಕು.
But now, my lord, this is my lord a case where my lord bill has been subsequently inserted. That too, my lord, after long lapse of my lord.
That's all right. ಸ್ವಲ್ಪ ಆಗುತ್ತೆ, ಏನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ನಿಮ್ಮ ಅಪ್ಪ ಮಾಡಿರುತ್ತೆ ಎರಡಿಗೆ ಇದ್ದು ಎಂಟು ಇಟ್ಕೊಂಡ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ.
Makes only one submission. My attempt is only with regard to my lord safeguarding the interest of suit item number 3. Lord, if even that goes, my lord, I am in possession of the property where I am going to give, my lord.
ಬಾಳು ನಿವೇಶನ ಅದು
ಮನೆ ಕಟ್ಟಿ ನಾನು ಇದ್ದೀನಿ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸಾಲನು ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು, ಜಮೀನು ಕಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು. ಅಟ್ಲೀಸ್ಟ್ ಫಾರ್ ಐಟಮ್ ನಂಬರ್ 3.
ಬೇರೆ 72 ನಾವು ತಗೊಂಡ್ರಲ್ಲ, ಅದರ ಸಂಬಂಧಪಟ್ಟ ಏನು ಮಾಡಿಲ್ಲ.
ಐಟಮ್ ನಂಬರ್ 3 ಬಿಟ್ಕೊಡ್ತಾರೆ ನೋಡಿ ಅವ್ರು. ಮಿಕ್ಕಿದಲ್ಲಿ ತಗೊಳ್ಳಿ. ನಾಳೆಗೆ ಹಾಕಿ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಹಾಕಿ. ಇಲ್ಲಿಗೆ ಸೋಫಾದ ಐಟಮ್ ನಂಬರ್ 3 is concerned. ನಾಳೆ ಅಂದ್ರೆ ಪಾರ್ಟಿಗಳನ್ನ ಕರೆಸ್ಬಿಡಿ.
Dependence of the million.
Yes.
This is load to specific performance agreement to sell filed by respondent. Respect of an mobile property, 20 windows of property. The concurrent findings. Trial court load, judgment of the trial court is at page 60. Page 60. Here, my lord, the findings is relying on that, my lord, the signature of the parties to an agreement, understood agreement, which is sent for truth lab, saying that, my lord, that has considered, and the report of the truth lab, my lord, considered and held that the issue number 1 as affirmative, holding that, my lord, the execution of agreement is true. Kindly, my lord, findings. Findings from para 9. The initial defense of the defendants before the trial court, they have not executed the agreement. Kindly, para 9, page 60. I'll read. In the case on hand, it is in dispute that the defendants are absolute owners of the property. According to the plaintiff on 28/12/2005, the defendants have executed the agreement to sell in favor of the plaintiff with respect to the suitable property, but the defendants have denied that they have executed an agreement of sale dated 28/12/2005 in favor of the plaintiff,
Since the defendants have denied the execution of agreement of sale, the burden lies on the plaintiff to prove the execution of agreements of sale, as required under the Section 91 of the Indian Evidence Act. The PW1 produced the original agreement of sale dated 28/12/2005. The same is marked as Exhibit B1. And perusal of the Exhibit B1 shows that on 28/12/2005, the defendants have executed the agreement of sale in favor of plaintiff with respect to the receipts of property, but the defendant number 3 has not signed the sale agreement of sale. Further, it discloses that one Venkatramaya and Annaya were signed as attesting witness to Exhibit B1. The plaintiff has not chosen to examine the attesting witnesses. The plaintiff has got referred the signature to defendants 1, 2, and 4 at Exhibit B1 and their admitted signatures to the handwriting expert. The said handwriting expert examined the admitted and disputed signatures of defendant number 1 and 4. Following that, the handwriting expert has submitted the review. The plaintiff and defendants have not filed the objections to the Commissioner report. At this juncture, it is just necessary to refer decision of court with an ILR to Karnataka 1840 between Parappa and others versus Timoppa and other, wherein the Honorable High Court Karnataka held an extraordinary judgment. In view of the principle laid down in the above decision, it is very clear that if none of the parties have filed the objections to the court commissioner, there is no necessity to examine the court commissioner. The report submitted by the court commissioner would be part and parcel of the record. Therefore, there is no necessity to examine the court commissioner. As stated above, the plaintiff and the defendants have not filed objections to the court commissioner report. Since the plaintiff and the defendants have not filed the objections to the commissioner report, the same can be accepted. The court commissioner need not be summoned to mark the court commissioner as an exhibit. On perusal of the report submitted by the court commissioner, discloses that the disputed and admitted signatures of the defendant number 2 and 4, one and the same. The opinion given by the handwriting expert manifests that the defendant number 2 and 4 have signed the sale dated 28/2005. It shows that the plaintiff has discharged the initial burden that on 28/2005. So he relying on the entire Milord to court commissioner report.
No, but if you don't object, then what should be done?
Kindly Milord. Even Milord, the circumstances, signature is proved Milord. Entire content of the agreement was proved Milord by on that
But
day.
you have to disprove.
Kindly Milord.
If the signature is proved, you have to disprove that something else was written in the agreement, not what is contained in exhibit.
Here, Milord, they have not even executed the agreement is the defense.
But now the court says that the signature found on the agreement belongs to you.
Signature is one in signature, another one thumbing impression. Here, Milord. And my reference submission is Milord. When Milord, the attesting witnesses are available, it would have been Milord considered the execution of sale deed is concerned. You would have been examined the attesting witness on that day, amount is paid, and agreement of sale has been executed. Since Milord, the burden is to prove his agreement, Milord, not by way of testimony providing in commissioner's report, Milord. Yes, Milord, he only receives the agreement in respect of property.
The problem is both of you are residing in the same village. ಇವೆಲ್ಲ ಒಂದೇ ಊರಿನಲ್ಲೇ ವಾಸ ಇರೋದು.
So, Milord, agreement on the attesting witness.
Will any attesting witness come and depose on behalf of the plaintiff? And all of them are residing in the same village.
Attesting witnesses, Milord, Annaya and Venkatram from each Srinivasapura, but they are in one is different village.
Issue notice.
Kolipura.
Notice. Call for the court. You want, I'll decide the case. Oh, okay, sir. here, the name is not. Who's the other side? See number 62. Yes. Upon golden.
Serial number 62, my lords.
Yes, please.
Yes, my lords, for the respondents, my lords.
Ah. Yes, madam.
My lords, the petitioner has filed the present petition seeking to challenge the enhancement, my lords.
Yes.
They have not challenged the order of conviction, but only that the enhanced amount of 30 lakhs 10,000 that has been awarded by the sessions judge, my lords.
Yes, ma'am. Yes, please. How do you prove your capacity to pay this kind of money?
My lords, I have not placed that on record, but the conviction has not been challenged, my lords.
Yes.
I had some money incoming from other sources.
What are the other?
My lords, rental income as well as some money I had received from my family side, my lords.
How would the judge know, madam, unless you produce it?
My lords, that as a question was not raised. His conviction was not challenged.
No. You will have to establish that, madam, you have the minimum funds, or you had these funds to pay the money to this man. 25 lakhs.
Yes, my lords. My lords.
25 lakhs is not a small amount, madam.
My lords, I have not challenged this, my lords. I have only asked for enhancement of the compensation which was awarded to me.
Yes.
I am the complainant, my lords, not the accused.
Yes.
Yes, my lords.
So you will have to prove, madam, source. That is the law declared by the Supreme Court now. You have to prove the source.
My lords, the source was questioned during the during the cross-examination also, my lords. This particular question was not raised against me, saying that I have not proven my source of income or any of this, or that I am not capable of making such a
But you
payment.
please come to the conviction, madam. Please come to the conviction. Order.
My lords, the order is at, I believe the order is produced at page 20, my lords.
Yes, page, ink page 30.
Ink page, my lords, I have received at, yes, my lords, yes, my lords. The reasons would start at page 25, my lords.
Yes.
My lords, if I may please submit that this would ideally be argued by the petitioner, my lords. I am not, I am only on the point of enhancement that I have received.
Please come to the order of conviction.
Yes, my lords.
What the court has convicted the accused is
Yes, my lords.
sentenced to pay fine of rupees 1,55,000, which is admitted.
Yes,
he
sir.
admits the amount of 1,55,000, so therefore is convicted for that. Now you come in, you file a revision seeking for enhancement.
Yes, my lords.
Correct?
Yes, my lords.
Now the conviction is enhanced based on what material?
My lords, the conviction is enhanced on the point that the accused has accepted his signature on the check, as well as the check itself.
The enhancement of sentence should be based on some material. What is the material for enhancement?
My lords, if I may please, my lords, ink page number 7, my lords.
Yes. Yes.
My lords, if reading from the previous page, the sentence, my lords, at the bottom it would be that any check bounce case shall make liberal use of section 357 of CRPC, and sentence should be appropriate when the amount covered by the check remains unpaid.
Yes.
It is settled that court of law shall award sentence proportionate to the established guilt. In the instant case, as noted supra, accused admitted issuance of XP1 check, impugned check in favor of the complainant. Complainant, pardon, my lord?
Yes, yes, please go on.
Yes, my lords, complainant being holder of exhibit P1 check is entitled to take benefit of presumption contemplated under Section 139 of NI Act. Accused has not rebutted presumption with unacceptable evidence. It is significant to note that the court below also did not uphold the defense of accused.
Yes.
The approach of court below in convicting accused and appreciating claim and defense of the parties is incorrect. Once the court below found accused guilty for the offense punishable under Section 138, it should have awarded fine bearing in mind the quantum of amount mentioned in the check and also intention of legislature in using phraseology for imposition of nature of sentence.
Yes.
Provision of Section 138 provides that any person committed who has committed offense punishable under Section 138 is punishable with imprisonment, which may be extended to 2 years of fine, which may extend to twice the amount of check or with both. Honorable Court below neither awarded punishment of imprisonment nor fine to twice the amount of the check. Therefore, approach of the court below on awarding sentence is not improportionate to the guilt established.
Yes.
Complainant also awarded compensation of 1,50,000, taking into consideration plea of the accused that accused received only 1,50,000 from the complainant as a loan.
Yes.
Even that quantum of amount is considered for imposition of fine. Court of law has to award at the rate of twice up to that amount.
Yes.
It is not the finding of the court below that accused repaid the check amount of 24,97,000. When such being the case, court below ought to have awarded sentence of more than rupees 24,97,000.
Yes.
Thereafter,
where is the justification for enhancing the sentence? The court below says, the trial court says, that there's nothing to show that you have paid the money.
My lords, the presumption under 139 would fall in my favor, my lords, that I have made this payment and this is towards a debt. Now, the rebuttable evidence that was to be produced by the accused has not been raised, my lords.
What is the latest judgment regarding source of the source? What is the latest judgment regarding source?
Source they have to go.
Source and judgment is not correct, but where is the judgment? There should be something to show that, madam, there's some justification for enhancing this sentence.
My lords, the conviction itself has not been challenged, my lords, even for the finding of guilt. There is, or for the finding of...
He was not affected by the conviction, he was willing to take the conviction. So if the first revision court were to enhance the sentence, there should be some material.
My lords,
Please come to paragraph number 11 of the trial court judgment.
Yes, my lords. PW1 is fully cross-examined by the accused. In his cross-examination, he got marked as per the facts stated in the chief examination of DW1 as also as per the reply notice. The same has been denied by the complainant. Further, regarding source of income, income of the complainant to lend an amount of rupees so-and-so to the complainant, as the complainant has not produced any documentary evidence to show that he got sufficient source to pay the same to the accused. Hence, in respect of this, the complainant creates doubtful whether he really advanced such a huge amount to the accused without interest. My lords, they have taken a contention to this effect, my lords, but this finding
Recorded by the court, trial court.
Yes, my lords.
So how will you overcome this finding? Have you filed any appeal against this finding?
No, my lords, I have not filed the appeal against the finding, my lords, but the only thing I filed sought for is an enhancement of the amount, my lords.
Unless you get this finding set aside, how can an enhancement of the sentence be granted?
My lords, enhancement, I've approached these honorable courts, below honorable courts only under 139, as well as the 357 of CRPC, my lords.
357 is for a different purpose.
My lords, apologies, I might have mistaken the section. My lords, 357(3) of the CPC provides for
Releasing, that is for appropriating the fine, madam. That is for appropriating the fine.
Yes, my lords, the fine, my lords, as per 139, as per 138 also, the fine amount should be twice the check amount, or even
that is willing to pay, but your client is not willing to accept. He's willing to pay 3 lakhs.
My lords, 30 lakhs is something that the court has arrived at, my lords.
You can extend up to twice the check amount as extend up to ಅಂತ ಇರೋದು.
Yes, my lord.
So it can extend up to means it can extend anything. It could be 10 rupees, it could be 100 rupees.
Yes, my lords, but also it must also be appropriate, alva, my lords, proportionate to the crime as to the guilt established.
Therefore, I am saying the accused is willing to pay 5 lakhs as against 1,50,000, which your client is not willing to accept. 5 lakhs, Allah?
4 lakhs.
Huh?
4 lakhs.
My lords, I will have to ask them, my lords. I was not told about this.
Sorry, madam.
My lords, I may be given about 10 minutes time. My
Please,
lords,
please listen to me. The lawyer argued this appeal.
Yes, my lords.
Petition.
Yes, my lords.
When we indicated a compromise, the client came to the court and he said, "I am taking back the wakalat from my client," and he took back the wakalat, filed a NOC or a memo of retirement. The lawyer filed a memo of retirement.
Yes, my lord.
Thereafter, another lawyer by name Mr. Anand has come on record.
Yes,
Now
my
you
lord.
come on record.
My
And
lords,
you are arguing.
my lords, I may be given 10 minutes. I will settle this matter if it is possible, my lords. If not,
Tomorrow.
I will suffer the order, my lords.
Tomorrow, madam, tomorrow.
Yes, my lords. Much obliged, my lords.
Yes. But the next year.
First appeal is for the mention.
Second appeal daily. Yes, first one. Mr. Ramon.
Represent Ramohan. There are 2 appeals. Both appeals arise from my suit. I am the plaintiff in both the suits. One suit is filed by me for specific performance against 5 people. They will just give me details. It is for specific performance of the sale agreement. The sale agreement is executed by one Chodegowda. It is 4 sons. It is 4 sons. By the time suit is filed, Chodegowda was dead and gone. And one of the sons of Chodegowda by name Manjappa Gowda, he was also dead. So the other 3 sons of Chodegowda are defendants 1 to 3. Now that Manjappa Gowda, another son of Chodegowda, who was also dead, his son is implicated as defendant number 4. Now, during the exchange of notices, it was found out that they are trying to, particularly the 4th defendant, is trying to sell the property to the 5th defendant. Therefore, the 5th defendant was also implicated in the suit. Suit is filed in the year 1990. Then in the year 1995, 4th defendant executed a sale deed in favor of the 5th defendant. Therefore, another suit is filed by me against him for permanent injunction. Now, as far as the suit for permanent injunction is concerned, my suit is decreed, holding that I am in possession of the property. That is confirmed in the first appeal filed by the 5th defendant, against which that 2006 second appeal is filed. File 29 of 2006. Now, as far as the other suit is concerned, that is filed by me. Me means appellate and his son. Appellate name is Sheshapagowda and his son is Srinivasa. For specific performance of a sale agreement dated 18/4/1979
Now the property in question was granted to the Chaudegowda. It was a temporary grant or a provisional grant of year 1961, 62, 63. Now, in pursuance to that provisional grant, Chaudegowda, who was placed in possession, about 17 or 18 years later, Chaudegowda executed the sale agreement with respect to the granted land in my favor. 18/4/1979 is the date of that agreement. Chaudegowda's all the four sons also joined him in executing that agreement. Now, the consideration amount mentioned in the agreement is rupees 30,000, out of which on the date of the agreement, they collected rupees 10,000. And over a period of time, they also collected almost the remaining consideration amount. Now, under the agreement, two conditions are prescribed. There is no time limit prescribed in the sale agreement. Now, two conditions are stipulated in the sale agreement. One is that Chaudegowda should obtain a permanent grant before proceeding to execute the sale deed in my favor. The second condition is, since the land was granted for coffee cultivation, as required under the Coffee Act, Chaudegowda was to obtain the coffee registration certificate before executing the sale deed in my favor. These were the two conditions stipulated in the agreement. And as I again said, no time limit was prescribed in the agreement. Now, Chaudegowda got the permanent grant certificate in the year 1985. Then he got that coffee registration certificate in his name in the year 1989. 18/10/1999 is the date of that coffee registration certificate. Now, after he obtained that registration certificate, that's the defendants never cared to inform me that they have obtained the registration certificate. Now that there is no impediment in the law, I can proceed to execute the sale deed, so that I can also proceed to have the sale deed executed. On the other hand, during 1991, I noticed defendants 1 to 4. As I said, defendants 1 to 3 are the children of Chaudegowda. Defendant number 4 is the grandson of Chaudegowda. Particularly, defendant number 4 hobnobbing with defendant number 5 for the sale of the property. Immediately, I issued a notice to all the defendants. So these are the terms of the agreement. The prohibition, unfortunately, in the permanent grant, which is of the year 1985, a condition was imposed that the property should not be alienated for a period of 15 years. It is nobody's case that such a condition was there in the temporary grant. After the permanent grant was made, 15 years prohibition was imposed on Chaudegowda and others. Then in 89, the coffee registration certificate is issued. In 91, when I noticed their movements with the fifth defendant, I issued them a notice calling upon them to perform their part of the contract. Now, defendants 1 to 3, who are parties to the agreement, that they did not send any reply. Defendant number 4, who is the grandson of Chaudegowda, also did not send any reply. It is the defendant number 5 who sends a reply to me, stating, number 1, after Chaudegowda's death, in a partition amongst the family members, the property in question is allotted to the share of the 4th defendant, grandson of Chaudegowda. His name is Ravi.
he has executed a sale agreement dated 18/4/91 in favor of the fifth defendant. And it is the fifth defendant who makes a reference to this aspect in his reply. Neither defendants 1, 2, 3 nor defendant number 4 reply to my notice. He sets up a plea of partition in which 4 defendant is supposed to have got this property. Then he proceeds to state that he has entered into an agreement with the 4 defendant. Then he also proceeds to state that the agreement in question is a concocted document. None of the parties, Chavadegowda or his children, have executed that document. Now, after receiving this reply, as I filed the suit for specific performance, OS 135 of 92. Now, the suit was decreed in the first instance. 4th defendant carried the matter by way of a first appeal before the first appellate court in a regular appeal. That appeal was also dismissed. And the trial court's decree granting me a specific judgment granting me a specific performance degree was confirmed. Now, 4 defendants carried the matter to this court in a RSA. This court in that RSA said 2 issues necessarily arose from the pleadings of the parties. Number 1, whether the sale agreement in question is valid in law. The second issue was whether the suit is barred by limitation. These 2 issues had not been framed by the trial court. So this court felt that since those issues arise from the pleadings, the issues should be framed and the matter should be again heard by the first appellate court. The matter went back to the first appellate court. Before the first appellate court, seeking framing of additional issues on the basis of the judgment of this court in the RSC, an application was filed indicating that about 8 issues arise for consideration, and those issues should be framed. The appellate court rejected most of those issues, saying that either they do not arise or the issues already framed cover those issues also. Nevertheless, the court framed 2 issues. 1, whether the suit is barred by limitation. Second one, whether the agreement in question is invalid in law or null and void. After framing those issues, the appellate court again sent the matter back to the trial court because it was of the opinion that further evidence is required on these questions. Therefore, it is as well that the matter goes back to the trial court, which will record further evidence and redecide the matter afresh. Now, after matter went back to the trial court, further evidence was recorded. After recording the evidence, that's the trial court answered the issue regarding the execution of the agreement in my favor. It held undoubtedly the agreement in question is executed by Chavadegowda and his children. That was answered in my favor. Then this next issue, whether plaintiffs prove that the defendants have received by way of advance of rupees 10,000 and have placed the plaintiff in possession of the property. That issue is also answered in my favor. As far as the other 2 issues which are later on framed, the trial court held number 1, the agreement is null and void. Number 2, the suit is barred by limitation. Number 3, plaintiff has failed to prove his readiness and willingness. Therefore, even after answering the earlier 2 issues in my favor, the trial court dismissed the suit. Now it was my turn to carry the matter before the first appellate court in a regular appeal. The first appellate court affirmed the finding of fact and the question of execution of the agreement in my favor. It also held the execution of the agreement is due. It also held that I am placed in possession of that property under that agreement. Then as far as the trial court's finding on the validity of the agreement is concerned, the appellate court reversed that finding. The trial court gave a finding that the agreement is null and void because the trial court felt the agreement is executed by Chaudegowda in my favor at a time when it was still under the provisional grant. There was no permanent grant made in favor of Chaudegowda. The provisional grant does not confer any right upon, did not confer any right upon Chaudegowda. Therefore, Chaudegowda did not have title to the property. Therefore, the agreement is void. That is how the trial court proceeded to void the agreement. As I said, the appellate court reversed that part of the judgment of the trial court. The appellate court said the agreement is perfectly valid. It's not a void or an invalid document as the trial court found. However, on the question of readiness and willingness, on the question of limitation, the appellate court held against me. The reason for holding that the suit is barred by limitation, and the reason for holding that I am not ready and willing is practically the same set of facts, or practically for the same reasons. Both the courts have held. The agreement is of the year 1979. Suit is filed in the year 1932, 13 years later. In the interim, there is nothing to show that plaintiff has shown his readiness and willingness. Therefore, since the suit is filed 13 years later, it is barred by limitation. Since there is nothing to show that plaintiff has done anything in the interim, it cannot be said that plaintiff is ready and willing to perform his part of the contract. That it is on those two questions, or on those 2 points, that I have lost this. Therefore, the question before this honorable court in this second appeal is whether the courts below are right in holding that the suit is barred by limitation, whether the court are right in holding that I was not ready and willing to perform. So, my part of the contract. So, this is on that short question as far as my appeal is concerned. Now, as far as his appeal is concerned, that both the courts have accepted that the execution of the agreement.
That is for injunction. That is for injunction.
Therefore, both the courts have said once the agreement is accepted, there is a clause in the agreement which mentions that possession is handed over to me. Therefore, there cannot be any difficulty in granting a decree for injunction in my suit. That's at the time the trial court decreed my injunction suit against him. But the matter had not yet reached this court in the second appeal. At that time, the trial court's earlier judgment decreeing my suit and the first appellate court's confirming that decree was there on record. Matter was pending in this court. Therefore, the trial court in that suit, injunction suit, said, in addition to what the agreement contained, in addition to that, the trial court also said, anyway, the suit for a specific performance is decreed. It is also confirmed in the appellate court. Therefore, plaintiff is entitled for a decree of permanent injunction. That is confirmed by the appellate court practically for the same reasons. Now, that is an issue in the second appeal filed by the 2006 appeal. Therefore, principally what this court, if I may say so with great respect, needs to look into is whether the courts below are right in dismissing my suit. That is the question for which I will read the judgment, few evidence and few judgments. Tomorrow or after tomorrow.
Continuous.
It's coming the afternoon. ಬೆಳಗ್ಗೆ ಸಾಮಾನ್ಯವಾಗಿ ರೀಚ್ ಆಗ ರಾಸಾಯ ನೋಟಿಸ್ come at 2:30.
Yes, yes, Kumbar.
For the appellant.
Yes.
Shall I? Have addressed argument before the other bench, my lord. If it is listed tomorrow, that we will comment.
If you talk tomorrow.
My lord, have it on Friday, my lord. My senior counsel is also tomorrow and day after tomorrow is not.
2 ಗಂಟೆ ಬೇಕಂತ್ರಿ.
Ashok Cardinal is our senior Nale Dila. You have it on Friday, my lord.
28th.
Let us see.
28th, better, sir. 30th, my lord.
More the merry. Let him begin.
Let him start.
Let him start.
So, 30th, my lord.
We want to finish this at least up to 2010 ಆದ್ರೂ ಮುಗಿಸ್ಬೇಕು ಅಂತ ಟಾರ್ಗೆಟ್ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ.
We will also assist that we are also very eager to get the disposal of all these matters.
Is tomorrow you please
I will make
what Mr. Vardarajan Iyengar.
Yes.
My lord, 25th at least, my lord, it will be would be better, my lord. Senior counsel is not in station.
Only at 2:30, maybe I think about 3:30.
My lord, 25th, my lord.
So it will come tomorrow. Let us see how. Let him begin.
Much obliged.
Subject availability of time tomorrow because we already listed one more matter.
After completion of Vardarajan's matter, Lord, I will commence.
How much time do you need?
That I need at least 45 to 50 minutes. Because the two suits are there, but I will.
The two suits, but one suit, injunction suit.
Injunction is bad. One suit they ಹೇಳ್ತೀನಿ. One suit they at least on the 35 to 40 minutes are better.
Yes. ಆಯ್ತು ನಾಳೆ ಮಾಡಿ.
ಅವತ್ತು ವರದರಾಜನ್ ಅವರು ಕಂಪ್ಲೀಟ್ ಆದ ತಕ್ಷಣ
ಅದೇ ವರದರಾಜನ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಟೈಮ್ ಇತ್ತಿದ್ರೆ ನಿಮ್ಗೆ ನಾಳೆ.
Please.
Anyway, in the list tomorrow.
Let it be in the list. I will comment.
65. KV Narasimhan. Yes. Yes, Mr. KV Narasimhan.
Started argument.
Yeah, partition.
Partition concurrent and
yes.
Now you are they have taken the contention in the item number 2 and 3 are there.
Is KV Narasimhan. Madam. Oh. Why are you hesitating to come inside? Yes.
Now they are claiming the item number 2 is and it is self-acquired property and item number 3 are acquired under the will.
Item number
2. Item number 2 acquired under the sale deed and item number 3 is acquired under the registered sale deed. Therefore,
the item number 2 is under sale deed. Item 2 and 3 ಎರಡು sale deed ಇದೆಯಾ?
Item number 2. Now they are seeking.
What is their case, Mister? What is their case?
Their case, my lord, in the kindly see the T1 3 to 3.
ಅಲ್ಲ item number 2 ಹೆಂಗ್ ಬಂತು ಅವ್ರಿಗೆ?
According to them, they are purchasing the
purchased
under the sale deed.
Exhibit.
Exhibit D2, my lord.
Exhibit D2.
D2.
Item number 3 ಏನು?
Item number under the share will. It is exhibit D1.
ಇಲ್ಲ. ಯಾರು ಬರ್ತಿರೋದು?
Grandfather of the D1.
Data. Their DW2 is the attester.
DW2 is the attester. Yes. My lord, kindly see the exhibit B2. B2 and return statement.
May kindly be taken up tomorrow, my lord. Here was right here, my lord. There is an emergency. He just left.
Kindly B2, my lord. Good morning. B2, before filing of the suit by the plaintiff, had issued the legal notice, my lord. And replied to the said legal notice, Your Honor, we had issued the reply notice. Yes. Where, my lord, there is no whisper about this, the item number 2 at purchased. Under the registered schedule.
The reply notice is the statutory notice.
Kindly see the return.
This is not a statutory notice, Mr.
Please kindly the return statement filed by the.
Yes. I had another 7 minutes, so I should work. Let him.
But it was an emergency, my lord. It may kindly be taken up.
No, I can't dispose of the case in another 6 minutes. Please sit down. Relax for some time.
Yes. The genealogical tree.
Please sit down.
The genealogical tree in the plaintiff is correct, but it is not true to say the plaintiff and defendant are legal heirs of the Timaya. The plaintiff has succeed the estate of the Timaya. It is also not to say that the suitable properties are joint family properties of the plaintiff and defendant. The plaintiff only surviving was son of the late Timaya and return statement of the return statement. Original
because item number 2 of the plain child property is purchased.
Now it is inserted, my lord, that portion is not in the original return statement. Based on that, my lord, the substantial question of law is claimed.
It is inserted now on the paper book.
Please, Your Honor.
What is this statement?
No. Second time.
Plaintiff is only
surveying son of late Timaya had entered into his estate as the defendant married long before, about more than 30 years ago, and living separately with their family in Pandupura, where her husband is working. Yes, as per the law, the plaintiff has no right to write or whatsoever over scheduled properties as so as to be member of family of the defendant father as per law. There is no cause for the suit of the plaintiff and only alleged in the plaintiff. The suit is not valued properly to so and so. There is no whisper about the defense set up with the defendant now. With regard to the item number 2 and 3, the genealogical tree is admitted. Only one the defense, my lord, the plaintiff has married 30 years back, therefore she is not entitled. Well, based on the pleadings, Your Honor, the court below has framed the issues. The issues at page number 11, my lord, of the paper book. 11. The trial court did. Whether the plaintiff prove that the suitable properties are the ancestral and joint family properties, whether the plaintiff is entitled to offset in the suitable property by way of partition, whether the defendant prove that since the plaintiff got married more than 30 years ago and residing separately in Pandupura, she is not entitled to claim any right over these properties. Whether the plaintiff is entitled to relief of partition and rendering in accounts as sought for, what order and decree. When the plaintiff based on the pleadings here and the issues, what is the evidence, my lord? Where, my lord, produced the document. All the suitable properties here was the ancestral and joint family properties. Yes. Which is marked as the document as per exhibit P1 to P8 in respect of the suitable properties. And thereafter, in the class examination, no.
And after that, my lord, the defendant reduced the evidence, where, my lord, the defendant has admitted the item number, the first time in the cross-examination of PW1, I put the question regarding the registered sale deed in respect of item number 2 and will. At that time, the object was made because there is no pleadings. Therefore, the only it is the first time in the cross-examination of PW1, they have put the question regarding item number 2 and 3. Thereafter, my lord, the defendant has adduced the evidence. In the evidence, the admitted even item number 2, though he has not taken this contention, even the item number 2 has purchased out of the giant family fund and nucleus. Please, the
Page number?
Page number 21 of the paper book. Relevant portion is extracted. Para 14, para 14. ದಾವಾ ಸೆಡಿನಲ್ಲಿ ತೋರಿಸಿದ ಎಲ್ಲಾ ಜಮೀನುಗಳ ಆಸ್ತಿಯ ಉತ್ಪತ್ತಿಯನ್ನು ನಾನು ಮತ್ತು ನನ್ನ ತಂದೆಯು ಪಡೆಯುತ್ತಿರುವುದೆಂದರೆ ಸರಿ.
ಏನಕ್ಕೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಇದು?
Because in the written statement, my lord, they have taken in the paper book, my lord, they have set up the item number 2 and 3. In the original written statement, it is not there. In the reply notice, it is not there.
What is the question of law?
No, the question of law, my lord, is removed. Whether the court below was justified in holding the item number 2 and 3 of the social properties are joint family property when the sale date dated 1987 stand in the name of the defendant in respect of item number 2 of the property, and item number 3 of the property belongs to maternal grandfather of the parties, who in turn bequeathed the same to the defendant under the will dated 22/4/1985, which is not at all there in the pleadings. Therefore, the very substantial question of law would not arise because no pleadings. And second substantial question of whether the court below was justified in allotting equal share to the daughter who was married 30 years prior to the date of the suit. These two substantial question of law is there.
When was the suit filed?
Suit filed in the year 2004, 13 of 2004.
Yes. It's tomorrow. Yes. All other matters will be listed there. Speak.
Submission matter. Serial number 40, my lord. Serial number 40 pass out, my lord. Second time login ಕೇಳಿಸಿಲ್ಲ.
Dismiss ಆಗಿದೆ for non-prosecution.
My lord, even senior is ready, my lord. Technical issue. Technical issue ಮೇಲೆ connect ಆಗಲ್ಲ. Ready ಇದೆ sir. ನೀವು ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ sir.
It was passed over thrice, not once.
ನಾಳೆಗೆ ರೆಡಿ ಇದೆ ಸರ್.
ಅಲ್ಲ ನಿಮ್ದು ಒಬ್ಬರದ್ದು ಎಲ್ಲ ತುಂಬಾ ಜನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೀನಿ, ಸೊ therefore I can't.
ಇಲ್ಲ ಸರ್, ಟೋಟಲ್ 5 ಇದಲ್ಲಿ ಹಾಕೊಂಡಿದ್ವಿ, ಅದು ಗೊತ್ತಾಗಿಲ್ಲ.
All the cases where lawyers have not appeared, I dismissed. I called the matter thrice. ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೀನಿ, so therefore please pardon me.
Serial number 74, my lord. Kindly have it on day after tomorrow, my lord. 74 serial number.
All matters which are not reached today will come next week.
Hello, court officer. Court officer.
Yes, sir.
Sir, serial number 68. ಯಾವ date, sir?
Next week, sir.
Next week. Thank you, sir.